Hmm. 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 Tomorrow no sitting. Next week.
He matters for 138.
Ah.
38. The respondent wants to pay the son's children's school fee. That is the reason. They have deposited 50% before. That is the reason. Permission to.
Next week.
138.
Told ella next week.
Extension of time.
Extension of time.
Extension.
Kodi.
What's 138 matter?
138
matter.
That's 138 matter. Warrant has been issued, Manoj. Kindly have it Monday. Monday. Nale sitting.
Monday kaki.
Please.
Warrant issue agide. Monday.
Please.
Live stream.
Grateful.
Entry from page number 5, 32 to 41, 42 to 49.
Serial number 49, Manoj. Just for petition in this case. In fact, I have requested the other side advocate also. I have to obtain trial. I have applied for the copies of trial court.
2017 matter ಈಗೇನ್ documents ತಗೊಳ್ಳೋದು?
ಇದರಲ್ಲಿ previous advocate depression ಹೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ನಾನು affidavit
ಹೆಸರು ಹೇಳಿದ್ರಿ ನೀವು ತಂದು ಬೀದಿಟ್ಟಿರ್ತಾನೆ ಇಲ್ಲಿ.
very recently I have filed in Makalat. Very recently I have filed in Makalat that too without NOC. Our records.
Other side ಹೇಳಿದಿರಾ?
ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. I have requested him.
ಅವ್ರು ಮತ್ತೆ
ಇಲ್ಲ ಸ್ವಾಮಿ. He has told that he has not got any.
Yes, told. Petitioner counsel seeks time and counsel also submits that he has already informed the respondent counsel and hence list this matter on 4/4.
50 to 58.
That's 54 minutes. Serial number 54 minutes. Petitioner. 1 week's time.
Why you want time, madam?
Because PCR got phone ಮಾಡಿದ್ರು.
PCR, SCR ಎರಡು ಇದೆಯಲ್ಲ?
ಇವತ್ತು ಬಂದಿದೆ ನಾನು ಇವಾಗ ಫೋನ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು, petitioner counsel seeks time and counsel for the respondent is also present.
5/4.
Let's list this matter on 4/4.
That's 5.
ಆಯ್ತು, 5/4. ಆಯ್ತು.
Serial number 56, my lord. Serial number 56. I apologize, my lord. Last time also I took a time.
ನೀವು ಯಾರಿಗೆ?
I am for the petitioner, my lord.
Petitioner.
Today I have received the LCR. 1 day accommodation maybe.
ವೆಂಕಟೇಶ TS ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
Inform ಮಾಡಿ.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಆಮೇಲೆ ನೋಡಿ.
Please.
ಅವ್ರು ಬಂದ ಆಮೇಲೆ ನಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ತಗೊಂಡವ್ರ ಡೇಟ್ ಅಂತ ಹೇಳೋದ್ ಬೇಡ.
Please.
59 to 64.
59 to 64.
65. 230.
65.
230.
ಆಯ್ತು, 65 to 60 ಎಲ್ಲ 230 ನಾ? ಆಯ್ತು.
What is matter? Serial number 1.
Niranjan Ganik, non-furnishing of PF and petition copy to issue notice to respondent. ಯಾವಾಗ ಆಗಿರೋದು ಮೇಡಮ್? This petition was filed in 2020. And this court suspended the sentence on 19/2/21. In order to issue notice to the respondent. And petitioner has not furnished the PF and also not furnished petition copy. And thereafter, petitioner never appeared before the court. On 24/3/2021, a week's time granted to do the needful. And once again on 1/4/21, court made it clear that if PF not furnished, appropriate order will be passed. If steps are not taken within a week, the matter once again listed on 17/4/21 none appears. And finally, a week's time granted. And on 15/9/22 also none appears. So also on 14/6/23, Akin Hunche, 14/6/23, 17/7/23, 11/9/23, 5/12/23, 18/1/24, and almost a dozen time listed after the notice has been ordered. And hence, it is very clear that the petitioner counsel is not pursuing the matter diligently, and hence petition is dismissed for non-furnishing of PF and petition copy to issue notice against the respondent.
Serial number 2, Rahul Karyappa.
Non-furnishing of process fee for issue of notice. Huh? Hmm. Hmm. Issue notice on 22 ನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದಾ?
ಆಗಿರೋದು. ಒಂದ್ಸತಿ
This court has issued notice on 21/3/22 on main as well as on IA. And notice was issued and the same was returned. ಏನಂತ ಬಂದಿದೆ? Was returned with an endorsement that they did not find the address. Week's time was granted to do the needful on 24/6/22. ಯಾಕೆ ಹಿಂಗ್ ಹೊಡೆದಾಕಿದ್ದಾರೆ? And matter was listed on 16/1/24. Order to reissue notice. ಇದು ಎರಡು ತೆಗೆದಾಕ್ಬೇಕಿತ್ತು ಇದು. Reissue notice through Superintendent of Police, Mysore. And once again, matter was listed on 5/2/24. And from last 2022, proper steps has not been taken in the matter. And in spite of sufficient opportunities given, petitioner is also not pursuing the matter diligently, and hence petition is dismissed for not taking steps.
Three,
Arvind
Arvind
M.
M.
Neglur. This petition was filed in 2020. When this court ordered to issue notice against the respondent on 15/1/22/21. And those submissions are made that going to report the settlement. And on 19/1/21, made the submission that the same is not materialized. And notice ordered on 19/1/21. Also, the counsel not pursued the matter when the matter was listed on 16/2/21. And ordered that and ordered once again to issue notice. And time was sought on 24/3/2021. So also on 30/3/21. And finally, a week's time granted to the petitioner for furnishing process. And in spite of matter is listed on several occasions. Not taken any steps. In the previous date of hearing on 14/9/22, this court made it clear that if needful is not done by the next date of hearing, the revision petition shall be dismissed for non-prosecution, and in spite of the same, not taken any steps. And even on 12/1/24 also week's time was granted. The same. And also not taken any steps in the matter, and hence petition is dismissed for non-furnishing of PF and petition copy to issue notice against the respondent.
4.
Lots, in this case, the
Mati,
respondent has expired in lots.
Hmm.
Appellant's whereabouts is also not known. Today I'm sending a registered post. I'll file acknowledgement in lots and in case if we.
Petitioner counsel seeks 2 weeks time to send a letter to the revision petitioner and file appropriate memo. And hence 2 weeks time granted. List this matter on 8/4.
5. Anand
Anand.
Muttali.
Thirdly,
Hearing for the petition of Allah.
TCR awaited ಅಂತಿದೆ. ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿದಾರೆ ಇವತ್ತು?
ಅದು ಸರ್ TCR ಬಂದಿಲ್ಲ.
ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ವು ಇಲ್ಲಲ್ಲ? ಹಾ
ಕ್ವೆಶ್ಚನ್ ಕೋಡ್ ಮಾತ್ರ ಬಂದಿದೆ.
ಹಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬಂದಿಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾವ್ದು? ಬ್ಯಾಂಗ್ಳೂರ್.
Earlier it was posted for final hearing.
ರಿಜಿಸ್ಟರ್ ಕರ್ಸ್ ಮಧ್ಯಾಹ್ನ 2:30 he must be present before the court. ಒಂದಲ್ಲ ಭಾರಿ ಕೇಸ್ಗಳಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ ರೆಕಾರ್ಡ್. ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಪಾಸ್ ಓವರ್.
6. Mr. Shri Prasad.
Respondent.
Deposited the money, Lord.
Hmm?
Pursuant to the order passed by this honorable court. Lord, I have deposited the
Defense
money.
of office objections on A1/24 for withdrawal of amount filed by the,
Provision of law, correct?
Petition of law, sir, we are working.
Kindly permit to correction of the provision of law. Mala. Kindly permit to correction of the provision.
ಆಯ್ತು ತೊಗೊಳ್ಳಿ ಕರೆಕ್ಟ್ ಮಾಡಿ. ಹೇಳ್ರಿ ಏನ್ ರಿಲೀಸ್ ಏನ್
Allah,
ಅಬ್ಜೆಕ್ಷನ್ಸ್?
Lord, a condition may be imposed. Lord.
ಕಂಡೀಷನ್ ಏನಿಲ್ಲ, ಡೆಪಾಸಿಟ್ ದಿ ಅಮೌಂಟ್ ಅಷ್ಟೇ.
Allah,
ಇನ್ ಕೇಸ್ ಇಫ್ ಯು ಸಕ್ಸೀಡ್ಸ್
ಅದು with interest.
ಈಗ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು provision ಅಲ್ಲಿ ಇರೋದು ಅದನ್ನ ಹೇಳಿದೆ 148(3) ಅಲ್ಲಿ.
ತೊಗೊಳ್ಳಿ. Heard the revision petitioner, respondent counsel and also the counsel appearing for the revision petitioner. And the application is filed for withdrawal of the amount which is in deposit, and counsel for the petitioner also submits that a direction may be given to repay the amount. The revision petitioner succeeds in the revision.
148(3), Lord.
Subclass 3.
148 subclass 3.
So released with interest at the bank rate. So in view of the proviso of section 148 subclass 3, order to release the amount with a condition that if the appellant revision petitioner is acquitted, the complainant to repay the amount to the revision petitioner, so released with interest at the bank rate prevailing at the bank rate prevailing nationalized bank.
Within 60 days,
Within 60 days. ಆಯ್ತು.
please.
Accordingly, IA is disposed of.
7. Manjunath MR.
1 week's time may be granted, madam. Take a fresh address.
Non furnishing of PF and address.
Correct
Petitioner
address.
counsel seeks 1 week time to furnish the PF and correct address. If the same is furnished within 1 week, issue notice against the respondent.
8.
The petitioner, my lord.
Non furnishing of PF and petition copy to
Time
issue
may kindly be
notice to
granted,
respondent.
Week time may kindly be granted.
Week's time granted. If PF paid, issue notice against respondent. If
Nine.
PF paid within 1 week ಅಂತ.
9.
Office objection regarding maintainability. 14%. Quittal.
My lord, I want permission to withdraw my criminal division petition and allow me to file criminal appeal under 378 subsection 4.
Good. The 14 person files a memo seeking permission of this court to withdraw the revision petition and to file a criminal appeal under section 378 subclass 4 of CRPC, and in view of the memo permitted to withdraw with liberty as sought.
Thank you, sir.
10.
My lordship, 1 week time, my lordship. PF.
Council seeks 1 week time and PF paid within 1 week. Issue notice against the respondent.
Obliged.
11. Babu Dia.
Office objections along with advocate submission.
For the petition.
Huh.
NPW issue ಆಗಿದೆಯೋ because NPW has been issued. Hence I filed the memo, Your Honor. I was not aware of that office objection, Your Honor. My colleague has been complained the office objection, but it was pending in. It will be cleared, complied within 2 days, Your Honor.
Is not having the judgment copy of criminal.
ಅಡ್ರೆಸ್ಸೇ ಸರಿ ಇಲ್ಲ ಅಂತಲ್ಲ ನೀವು ಹಾಕಿರೋದು ರಿವಿಷನ್ ಅಲ್ಲಿ ಮತ್ತೆ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಇರೋ ಅಡ್ರೆಸ್.
You know, initially he was residing in the Avli, Your Honor, but he is residing now in Hospati, Your Honor.
ಈಗ ಬೇರೆ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಹೌದು, Your Honor.
ಅದೊಂದೇನಾ?
Yes, Your Honor.
The counsel for the petitioner would submit that the present address of the respondent
Yes, Your Honor.
is furnished, and hence the same is not tallies with the criminal appeal, and hence counsel submission is accepted. ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
Your Honor, suspension of sentence ಗೆ satisfied ಆಗಬೇಕು, Your Honor.
ಏನು
Your Honor, warrant issue ಆಗಿದೆ, Your Honor.
ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸರಿ ರೀ, ನೀವೇನ್ ಮಾಡಿದಿರಿ ಹೇಳಿ ಫಸ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Your Honor,
ಡಿಫೆನ್ಸ್ ಏನ್?
Your Honor, the
Defense.
suppression, complainant has been suppressed the fact, Your Honor. When the agreement ಆಗಿತ್ತು, there was an agreement between the complainant and the accused. The agreement has not been stated before the trial court. Hence I have the agreement, Your Honor. Because the suppression of the agreement, he has been made the order, Your Honor, in his favor. It has been convicted of the accused, Your Honor. Hence,
What is the check amount?
check of 5,50,000, Your Honor.
Deposit 50%. Subject to, including the payment made in appellate court. Issue notice against respondent. Bail bond 1 lakh with 1 security.
12.
Sachin BRR. Furnishing of PF and petition copy to issue notice to respondent. Weeks time granted. If PF paid within 1 week, issue notice against respondent.
Kindly grant time to deposit the amount.
Deposit. ಏನ್ ಡೆಪಾಸಿಟ್? ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ. ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಇಲ್ಲ.
ಕಂಪ್ಲೈ ಮಾಡಿದಿರ ಇಲ್ಲ? ಮಾಡಿಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಾ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ಗೆ? ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್.
4/12/23.
4/12/23 ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದೆ?
4 weeks.
4 weeks.
This court wide order dated 4/12/23 directed to deposit 50% of the amount within 4 weeks. From today, failing which the trial court is at liberty to proceed against the petitioner accused in accordance with already ಇದೆಯಲ್ಲ ಅಷ್ಟೇ. Issue notice against the respondent.
30.
My lords, I appear for the petition. My lords, I request for the office objection.
Office objection at serial number 2, 3, 4 and 8.
Lords, this was the application filed with the state.
Counsel, why you have moved the memo without complaints of office objections?
My lords, I seek for overruling of the
Huh?
office objection.
There are several office objections.
My lords, state of Karnataka is not made.
First you comply. Tawle, the petitioner counsel has moved the memo without compliance of office objections. And there were office objections number 2, 3, 4 and 8. And hence 1 week time granted to comply with office objections on cost of ₹1,000 payable at registry. If cost not paid and not complied within 1 week, list the matter for dismissal on date kodi.
Lords, I seek apologies, my lords. Kindly.
ಒಂದು ವಾರ ಬಿಟ್ಟು ಕೊಡಿ.
28/3.
28/3 ಯಾರ್ಯಾರು ಇನ್ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ ಮೆಮೋ ಮೂವ್ ಮಾಡ್ತೀರಿ ಕೋರ್ಟ್ ಮುಂದೆ, ಇನ್ಮೇಲೆ ಕಾಸ್ಟ್ 1,000.
Lord, I seek
You
apologies.
think that the court is not having any work?
My lords,
ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡೋದಿಲ್ಲ, ಆಫೀಸ್ ಕೋರ್ಟ್ ಮೆಮೋ ಮೂವ್ ಮಾಡ್ಕೊಡೋದು ಕೋರ್ಟ್ ಅಲ್ಲಿ.
complete order sheet.
ಬೆಳಗ್ಗೆ ಇದ್ರಿ ಒಂದು 100 ಮೆಮೋ ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲೇ. ನೆಕ್ಸ್ಟ್ ಯು ಪೇ ಕಾಸ್ಟ್.
I request for cost to be waived.
ನೋ
I'll comply today.
ನೋ
Please, my lord.
ಫಸ್ಟ್ ಯು ಪೇ. ಐ ಹ್ಯಾವ್ ಗಿವನ್ 1 week ಟೈಮ್, ಯು ಕಂಪ್ಲೈ ಇಟ್
Date may be.
ಅಂಡ್ ಪೇ ಕಾಸ್ಟ್. ಕಾಸ್ಟ್ ಅಟ್ ರಿಜಿಸ್ಟರ್ ಅಂತ ಮಾಡಿದ್ನಲ್ಲ ಮೇಡಮ್ ಫಸ್ಟ್.
40.
To withdraw the petition.
Office objections regarding maintainability. Petitioner counsel has filed memo for withdrawal of the petition
Liberty to file.
with liberty to file the appropriate appeal and permitted to withdraw in terms of the memo.
50.
It's 15 ma'am.
Diary, maintainability.
The family court order.
That's my seniors appearing through VC, my lords.
Yes,
Millard's,
counsel.
Millard's 138 matter, Millard's conviction before the magistrate court in the appellate acquittal agide. Kindly permit me to convert this into a criminal appeal, Millard's.
Then you file a memo, counsel.
I will file, my colleague will file memo.
File
I'll be
memo.
very good.
The petitioner counsel files memo seeking permission of this court to convert the same as
Criminal appeal, Millard's.
criminal appeal. Better to withdraw this and file appeal. ಏನ್ ರಿಪೇರಿ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲೇ ಬೇರೆ ಇರ್ತದೆ, ಅಲ್ಲೇ ಬೇರೆ ಇರ್ತದೆ. ನೋಡಿ ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು ಆಯ್ತು. ಪರ್ಮಿಟೆಡ್ ಟು ಕನ್ವರ್ಟ್. ಮೆಮೋ ಬರ್ದ್ ಕೊಡಿ. In terms
I'm
of the
grateful.
memo.
I'm grateful.
60.
I appear for the
Narasimha Murthy on
petition.
office objections.
Well, 2 weeks time.
2 weeks time granted as sought for compliance.
70.
17 Ashok Kumar Shetty.
Place for time.
Esti Sabek.
2 weeks.
2 weeks time granted as sought.
80. Lata DL.
Lata DL. Petitioner counsel is absent. 2 weeks time granted to comply with office objections.
90. CR Rajgopal.
Same order.
20.
Puttaraju. Counsel 6, 2 weeks granted as sought.
21.
GS
Millard.
Prasanna Kumar.
Millard, for the petitioner Millard, I seek 2 weeks time to comply the office objection.
2 weeks time granted as sought.
Grateful Millard.
22.
Acceptance of memo along
Prakash
with
KV.
copy of acknowledgement having served the RP to the respondent filed by the party in person. ಕೊಡಿ. ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ ನೋಡಿ. ಹಾಕಿದಾರ ಯಾರು?
Nurullah Hussain ಅನ್ನೋರು 2678 10.
26
2678 10.
Counsel Sri Nurullah Hussain has filed wakalat for R2, R6, R7, R8, R10. ನೀವು ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
ಎಲ್ರಿಗೂ ಸರ್ ಮುಂದೆ.
And hence registry is directed to show the name of the counsel in the cause list. The memo filed by the review petitioner is accepted. ಕೊಡಿ ಬಾಕಿ ಅವ್ರ ಹೆಸರು ಹೇಳಿ ನೋಡಿ ಮೇಡಮ್. R1 ಎಲ್ಲಿದೆ ಮೆಮೋ? ಸರ್ವಿಸ್ ಮಾಡಿದ ಮೆಮೋ ಎಲ್ಲಿದೆ? ಪಾಟೀಲ್ ಎಲ್ಲಿದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ದಿ ಕಾಪಿ?
ಅವ್ರು ಕೊಟ್ಟಿದ್ವಿ ಸ್ವಾಮಿ ಪಿಟಿಷನ್ ಕಾಪಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೀವಿ. ಅವ್ರಿಗೆ
ಸರ್ವ್ ಮಾಡಿದಕ್ಕೆ ಸೈನ್ ತಗೋಬೇಕಲ್ಲ, ಅದು ಎಲ್ಲಿದೆ?
ತಗೊಂಡಿದೀವಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಅದು? ಇಲ್ಲಲ್ಲ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲಲ್ಲ. The above matter petition about 2 party in person have
Serve
served the
ಮಾಡಿದ್ದೀನಿ.
copy of the review petition to the
ಕೊಟ್ಟಿದೀವಿ
respondent
ಕೊಟ್ಟಿದ್ದೀನಿ
counsel.
ಖುದ್ದಾಗಿ ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
Respondent counsel ಅಂತ ಇದೆ ಇದು. ನೀವು ಕೌನ್ಸಿಲ್ಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೌನ್ಸಿಲ್ಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಪಾರ್ಟೀಸ್ಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೌನ್ಸಿಲ್ಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ತಾವ್ ಹೇಳ್ದಂಗೆ ನಾ ಕೌನ್ಸಿಲ್ಗೆ ಕೊಟ್ಟು ಅವ್ರ ಹತ್ರದಿಂದ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿದ್ದೀನಿ.
Served the RP to the respondent ಅಂತ ಇದೆ ಇಲ್ಲಿ.
ಮತ್ತೆ ಅವ್ರು ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ಎಲ್ರಿಗೂ ವಕಾಲತ್ ಆಗ್ತೀನಿ ಅಂತ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
Petition of office objection raised on SPA copy filed by the party in person. Petitioner 2 on behalf of petition number 1 and 3. ಏನ್ ರೆಟಿಫಿಕೇಶನ್ ಏನ್ ಮೇಡಮ್? SP ಹಾಕಿದ್ದಾರೆ. ರೆಕ್ಟಿಫಿಕೇಶನ್ ಏನು? ಇದ್ರಲ್ಲಿ ಇನ್ನ ರಿವ್ಯೂ ಪಿಟಿಷನರ್ ಇನ್ನು ಎಷ್ಟು ಜನ ಅವ್ರೆ? ಇವ್ರು ಬಾಕಿ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ ಕೋರ್ಟ್ಗೆ. ಯು ಸರ್ವ್ಡ್ ದಿ ಕಾಪಿ ಓನ್ಲಿ ಆನ್ ದ ಕೌನ್ಸಿಲ್.
ಕೌನ್ಸಿಲ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅವ್ರು ವಕಾಲತ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಟೈಮ್ ತಗೊಂಡ್ರು ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಟೈಮ್.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಬೇರೆಯವ್ರಿಗೆ. ಲಾಯರ್ ಹಾಕಿರೋದು ವಕಾಲತ್ ಬರೀ 2, 6, 7, 8, 10 ಮಾತ್ರ.
ಎಲ್ರಿಗೂ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಹಾಕಿಲ್ಲ.
I would recommend it as representing as SPA holder for petition number 193.
ನೀವೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ GP, ಅದ್ರ ಜೊತೆಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ಅಂತ ಇದೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಟೆಂಡ್ ಮಾಡಿ.
Okay.
The 14 person is also present before the court and directed to comply with the office objections regarding SPA copy filed by him on behalf of petition number 1 and 3. This matter on ಯಾವ್ದಾದ್ರು date ಕೊಡಿ.
28.
28
ಇದೆ.
28/3.
Hearing on IA 23, Chandramouli HS.
Filing a memo for retirement.
Retirement. Acknowledgement ಇದೆಯಾ?
2021 ಅಲ್ಲೇ ನಾವು ಕಳಿಸಿದ್ವಿ.
ಕೊಡಿ. ಮತ್ತೆ ಇದುವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
We could not apologize.
Memo for retirement. Acknowledgement ಎಲ್ಲಿದೆ ರೀ?
ಮೇಲ್ಗಡೆ ಮೇಲ್ಗಡೆ ಅದರಲ್ಲಿ in the first page ಇದೆ ಮೇಲ್ಗಡೆ.
ಕೊಡಿ ಅವ್ರಿಗೇನು ಅದೇನು ನಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ನಿಮ್ ಪಾರ್ಟಿಗೆ ಕಳ್ಸಿದ್ರಲ್ಲ, ಅದು ಜಾರಿಯಾಗಿದ್ ಬಗ್ಗೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳಿದ್ರು.
ಸೈನ್ ಮಾಡಿ ಅವ್ರದ್ದು ರಿಸೀವ್ ಸಿಗ್ನೇಚರ್ ಬರೀ ನಿಮ್ದು.
ಅವ್ರಿಗೆ ತಲುಪಿದಕ್ಕೆ ಎಲ್ಲಿದೆ ರೀ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್? ನಿಮ್ ಲೆಟರ್ ಕಾಪಿ ಅಲ್ಲ ನಾವು ಕೇಳ್ತಾ ಇರೋದು.
2021 ಅಲ್ಲಿ ಕಳಿಸಿದ್ವಿ.
ಆಯ್ತು, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿ?
ಅದ್ರದ್ದು acknowledgement
ಮತ್ ಬೇಕಲ್ಲ, ನೀವೊಂದ್ ಆಫೀಸಲ್ಲಿ ಒಂದು ಲೆಟರ್ ಟೈಪ್ ಮಾಡ್ಕೊಬಂದ್ ತಂದು ಹಾಕ್ಬಿಟ್ರೆ?
ಇದರಲ್ಲಿ ನಾವು ಇದು RPD ಕಳಿಸಿರೋದಕ್ಕೆ
ಸರಿ, ಎಲ್ಲಿದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್?
ಅದ್ರದ್ದು acknowledgement ಬಂದಿಲ್ಲ.
ಮತ್ ಬೇಕಲ್ಲ,
ಇನ್ನೊಂದು ಫ್ರೆಶ್ ಲೆಟರ್ ಕಳಿಸಿ.
ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್, ತಗೊಳ್ಳಿ ಅದು. Along with copy of the letter addressed to the petitioner dated 24/3/2021 and not produced any postal acknowledgement and hence not permitted to retire from the case. Argument ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ? The IA which is filed for condemnation of delay. It is the very same reason as to why we are not able to approach him. Not able to approach him. Magistrate court ಅಲ್ಲಿ he is convicted for the NI Act offense. 8 lakhs is the check amount, 11.5 lakhs ಗೆ conviction ಕೊಡ್ತಾರೆ. Thereafter my lord an appeal is preferred. ಆ appeal ಅಲ್ಲಿ the counsel who is appearing for him before the appellate court, sessions court, Lord, he does not appear and therefore the matter is dismissed as non-prosecuted.
Appeal also dismissed.
Appeal also dismissed. Thereafter my lord he comes to our office and he seeks that this order may be challenged. The appellate court's order may be challenged. Therefore we call revision. But the ground on which the IA is filed for condemnation of delay is also that he could not approach his advocate and his advocate could not communicate to him in equal time. The same issue, my lord, which the lower court advocate has faced, we are facing today. This is the issue, my lord. This is where.
Order the petition of counsel on IA 1 of 2018. And there is a delay of 877 days in filing this revision petition. And in support of this application, an affidavit is sworn to. Affidavit ilvalri, bari verifying affidavit anta haktari condonation of delay ge.
Para 7 and 8 my lord ಅದ್ರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ
ಅದು ಅಪ್ಲಿಕೇಶನ್ ಆಯ್ತು. Where is the affidavit? Condonation of delay ge. ಎಲ್ಲಿ ಮೇಡಮ್ ಇದೇನು ಡಿಲೇ ಇದು? ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಅಪ್ಲಿಕೇಶನ್.
ಅದು IA number 2 ಮಾಡಲ್ಲ. IA number 1 is application. ಅದಕ್ಕೆ affidavit detail ಇದೆ.
ಕಂಡೋನೇಷನ್ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ ಅಂದ್ರೆ ಆಯ್ತು ಬಿಟ್ಟು. Dismissal 2015 ಅಲ್ಲ.
2015 ಅಲ್ಲಿ dismissal.
ನೋಡಿ. While seeking for the condemnation of delay of 877 days, an affidavit is sworn to stating that the counsel, while filing at the time of appeal, he was advised that his presence is not required. He would be representing, and as soon as his present, as soon as, and when his presence is required, he would inform him. But he did not inform anything. And recently he came to know about the dismissal of the appeal on 19/3/2015. And counsel also informed him that he had tried to contact him on several occasions, but the same was vain. And he had not received any communication regarding dismissal of the appeal. And he was advised to approach this court, and immediately he applied for certified copy on 4/10/2017. And the same was delivered on 10/10/2017, and immediately obtaining the certified copy has filed this revision petition. And there is a delay. Having considered the reasons assigned in the application and affidavit, and record discloses that judgment of conviction order was passed on 12/4/2014, ordering him to pay fine of rupees 11,05,000 with default clause. A sentence also imposed. And appeal was filed in 2015. And an allegation is made against the counsel that he did not inform anything about him. When the appeal was filed in 2015, he has not explained what prevented him in contacting the counsel. The counsel appearing for the petitioner also would submit that very same difficulty the petitioner counsel is also facing. And even he has sent the letter in 2021. No response. And when the petitioner is not pursuing the matter diligently, though this petition was filed in 2017 and even not contacting the revision petitioner counsel. But he makes an allegation against the counsel on record who was appearing before the trial court. And though appeal was dismissed in 2015 itself, he did not contact the counsel appearing for the appellant in the trial court also. And when such being the case, I do not find any ground to condone the delay of 877 days in entertaining the revision petition, and hence no satisfactory reason has been assigned to condone the delay, and hence IAS dismissed. Consequently, revision petition is also dismissed.
24. AC Nagraj.
Suresh Subbaya. April 1.
Yes.
BMC report kept in B file ಅಂತ ಏನಾಗಿದೆ ನೋಡ್ರಿ. ಏನಾಗಿದೆ BMC report? Petitioner counsel is absent and respondent counsel is also absent. And also received the BMC report dated 17/2/21 that none appeared before the mediation center. And hence it is clear that the parties are not pursuing the matter diligently. And one more opportunity is given if petitioner counsel doesn't turn up in the state of hearing, appeal will be, revision petition will be dismissed. List this matter on 4/4.
25. Vijay Krishna Bhatt.
Vijay Krishna Bhatt, direction
Hari.
filed by the counsel for petitioner. ENT direction,
For the petitioner, my lord, we had deposited 50% amount in the trial court. And subsequent to that, we had filed an application to deposit the same amount in any nationalized bank.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ
ಕೊಟ್ಟಿಲ್ಲ.
ಕಾಪಿ ಕೊಡಿ ಅದೇನ ಅಯ್ಯ ಹಾಕಿದಿರಿ ಅವರಿಗೆ.
ನಾನ್ ಮೊನ್ನೆ ಅಷ್ಟೇ ವಕಾಲತ್ ಹಾಕಿದ್ದು 7-2 ಹಾಕಿದ್ದೀನಿ ಮತ್ತೆ ಅದಕ್ಕೆ ನೀವು ಕಾಪಿ ಕೊಡಿ ಅಯ್ಯೇ ಕಾಪಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಮೊದ್ಲಿದ್ದವ್ರಿಗೆ ಯಾರಿಗೋ ಸರ್ವ್ ಮಾಡಿದಾರಲ್ರಿ.
ಇಲ್ಲ ನಾನೇ ಫಸ್ಟ್ ಮೊನ್ನೆ ಹಾಕಿರೋದು ವಕಾಲತ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಾಟ್ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಅಂತ.
ನಾಟ್ ಫೈಲ್ಡ್ 7-2 ನಾನು ವಕಾಲತ್ ಹಾಕಿರೋದು. 7-24 ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದು. ಕಾಪೀಸ್ ಕೊಡಿ ಅಯ್ಯೇ ಕಾಪಿ.
Respondent counsel submits that he has not received the copy of IA2 of 24 and hence the petitioner counsel is directed to serve the copy of IA forthwith to respondent counsel. List this matter up to 2 weeks. Date ಕೊಡ್ತೀರಾ? ಸುಮ್ನೆ ಡೇಟ್ ಕೊಡೋದು ನಾವು. ಅವ್ರಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ನಾವ್ಯಾಕೆ ಡೇಟ್ ಕೊಡೋದು? ಆಯ್ತು, after 2 weeks.
Date may be given.
ಆಯ್ತು ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ. 5/4.
26. Vijay Kumar
Kumar SC, AM Vijay.
Appearing for petition.
Total of amount filed by counsel, respondent counsel.
That's why file objection to the application and recently Dharwad bench has passed order against the father-in-law. Maintenance petition is not maintainable. That's why we'll go through that and submit.
ಇದೇನ್ ಫಾದರ್ ಇನ್ ಲಾ ಅಪೀಲ್ ಇದು?
No, father-in-law appeal.
ಹಸ್ಬೆಂಡ್ ಇಲ್ವಾ?
Husband ಇಲ್ಲ.
Husband is no more.
ಮತ್ತೆ?
ಅಲ್ಲ
Then against whom they have to claim?
ಅಲ್ಲ she is earning. She is the earning person. I will file necessary.
ಧಾರವಾಡದ ಬೆಂಚ್ ಕೇಸಲ್ಲಿ
ಅಲ್ಲ ಅದಕ್ಕೆ ಅದನ್ನು
ಸಿಮಿಲರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸ್.
ಅಲ್ಲ ಅದನ್ನ ನೋಡು ಹೇಳ್ತೀನಿ.
ತೊಗೊಳ್ಳಿ.
ಇದನ್ನ ಡೀಟೇಲ್ಸ್ ಗೊತ್ತಿಲ್ಲ.
Petitioner counsel seeks a week's time to file objections to IA. And hence week's time granted. List this matter. ಒಂದ್ ವಾರ ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್.
28/3.
28/3.
27.
ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳುವಾಗ ಫಾದರ್ ಇಂದ ಹೋಗಿದ್ನ ಇಲ್ಲ?
ಇಲ್ಲ ಮದುವೆ ಮಾಡಕ್ಕೆ ಲವ್ ಮ್ಯಾರೇಜ್ ಅದು.
ಸರಿ, ಮದುವೆ ಮಾಡ್ಕೊಳಕ್ ಹೋಗಿದ್ರೆ ಲವ್ ಮ್ಯಾರೇಜ್ ಅಂದ್ರೆ ಲವ್ ಕಮ್ ಅರೇಂಜಾ ಅಥವಾ ಏನು?
ಇಲ್ಲ ಲವ್ ಮ್ಯಾರೇಜ್, ಅವ್ರಿಬ್ರು ಸಪರೇಟ್ ಆಗಾಗೆ ಮದುವೆ ಆಗಿದ್ದು.
ಹೌದಾ? ಅಪ್ಪ ಅಮ್ಮ ಏನ್ ಭಾಗವಹಿಸಿಲ್ಲ
ಇಲ್ಲ
ಮದುವೆಗೆ? ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳುವಾಗ
ಇಲ್ಲ.
ಆಯ್ತು ನೋಡಿ
ಪ್ಲೀಸ್.
27.
For
Raman.
petitioner in this case,
Respondent madam.
there is a delay of 9 days in filing of this.
ಅದರ್ ಸೈಡ್ ಇದಾರ ಡಿಲೇ ಕಂಡನ್ ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು.
Heard on IA 1/23 and there is a delay of 9 days in filing the revision petition and for the reasons stated in the accompanying application and affidavit, delay is condoned. ಅಷ್ಟೇ.
This honorable court has granted the time for 4 weeks for deposit of amount 50%. They have not deposited.
Deposit ಮಾಡಿದಿರಾ ಇಲ್ಲ?
He is a senior citizen.
Whatever it may be, ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಮಾಡಿಲ್ಲ.
ಕಂಡೀಷನ್ ಅಪ್ಲೈ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಇಲ್ಲ
ಮಾಡಿಲ್ಲ.
Say number 2 complaint, reason ಏನಂದ್ರೆ he is suffering from several health ailments.
ರೀಸನ್ ಇರ್ಲಿ, ಕಂಪ್ಲೈ ಮಾಡಿರಿ ಇಲ್ಲ?
ಮಾಡಿಲ್ಲ.
Counsel for the respondent submits that they have not complied with the order passed by this court. Even if the order has not been complied, the respondent is given liberty to proceed against the petitioner.
28.
Withdrawal of
Alright,
amount
sorry.
filed by the respondent counsel.
Anshuman.
ಇಬ್ರು ಇಲ್ವಾ? Both the counsels are absent. List this matter on. Other date ಕೊಡಿ ಮೇಡಮ್.
28/3.
28/3.
59. Akshata Shetty. Vishwas.
Viಶ್ವಾಸ್. Delay of 47 days.
I have filed a wakalat, my lord, for a presentation formal necessary, they probably ಅದರಲ್ಲಿ ವಕಾಲತ್ತಲ್ಲಿ ಸೈನ್ ಹಾಕಿರ್ಲಿ.
ವಿಶ್ವಾಸ್ ಅಂತ ಇದೆ.
ಅಂದ್ರೆ ಮೈ ಕಲೀಗ್, ಮೈ ಜೂನಿಯರ್ ಕಲೀಗ್.
ಕೊಲೀಗ
ಹೌದು.
ಬಟ್ ನಿಮ್ ಕೊಲೀಗೆ ಅಲ್ಲ ಅವರು.
ಹೌದು, ಬಟ್ ಮೈ ನೇಮ್ ಶುಡ್ ಬಿ ನಿಶಿತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ.
ಆಯ್ತು, ನಿಮ್ದು ತೋರ್ಸೋಣ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ತೋರ್ಸುವಾಗ. ಈಗೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಅಬ್ಜೆಕ್ಟಿವ್.
Heard on IA 2/23 and there is a delay of 47 days in filing the revision petition.
There is already stay.
And counsel for the respondent not filed objections to IA. And for the reasons stated in the accompanying application and affidavit, and the delay is also for only 47 days and hence the same is condoned. Registry is directed to show the name of counsel
Nishit Kumar Shetty.
Nishit Kumar Shetty for along with Vishwas. ಹೌದಾ ಅವ್ರದ್ದು ವಕಾಲತ್ ಇದೆ. For respondent.
And
List-
interim order is granted, my lord. Unconditional interim order is granted, my lord. 40,000 for the
Unconditional.
the education expense, says the 40,000 is granted by the trial court, which was upheld by the appellate court, my lord. Till today, he has not paid anything, my lord.
No, my lord, the fact is not like that, my lord. The petitioner has already taken up.
Order counsel revision petitioner issue notice respondent on IN number 2 of 23 and delay na. In the meantime, there shall be a stay of the operation of the order dated 10/10/22 passed in criminal miscellaneous number 64 of 2000 on the file of the learned James Mangalore DK and the judgment and order dated session judge DK Mangalore till next date of hearing. ಹೇಳಿ.
Yes, my lord. The order granted was 40,000, my lord. The marriage between the petitioner and the respondent is in the year 1994. After that, they resided together at Oman till 2018, my lord, from 1994. In the year 2018, she left the petitioner along with son and daughter. Son now aged about 27 years and daughter 19 years, my lord. In the year 2018, she files a DV petition. And she takes a ex parte order against the petitioner to not to operate his bank accounts, FDs, or the joint properties taken in their joint names, my lord. The ex parte order has been granted in the year 2018 in the month of June, my lord. After that, she doesn't take steps to issue notice to the petitioner. Till the year 2022, and she also remains absent before the JMFC court. 2022, the petitioner, it has came to the knowledge of the petitioner. He himself appeared before the court and he files application for vacating stay under 25 clause
The
2.
order passed earlier.
Howdu, ex parte order, my lord. After that has been filed, this respondent files application under 23 clause 2. Seeking maintenance, my lord. My application has not been decided and on this application, 40,000 has been passed. I have challenged it before Sessions Court. The Sessions Court upholds the order, my lord. Now my contention is that, my lord.
Now, what is the status of the criminal miscellaneous number 64 of 2018?
ಅದು ಹಾಗೆ ಇದೆ, it is
The
stay
FLW
ಆಗಿದೆ.
is-
Pending ಇದೆಯಾ?
Now stay, because of the stay, my lord, it is pending, my lord.
It is pending.
Stay ಆಗಿದೆಯಾ?
ಹೌದು.
Now my point is, my lord, in the year 2005 itself, daughter ಈಗ majority ಬಂದಿದ್ದಾರೆ, ಮಕ್ಕಳು majority ಬಂದಿದ್ದಾರೆ. Son is aged about 27 years and daughter is aged about 19 years. In the year 2005 itself, I have taken a professional educational policy in the life insurance for my daughter. I have produced the document in page number 147, my lord. I have invested the sum assured is $25,000, my lord. It is she is going to benefit from that.
For the daughter.
How the daughter. From her 18 years to 23 years, she is going to get $5,000 per annum towards her educational expenses, my lord. 25,000 is the sum assured. It comes more than this maintenance, this thing, my lord. And moreover, before the lower court,
Whether she is getting this amount?
ಹೌದು, ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ.
That she is getting, my lord.
She is getting this.
4 lakhs per year it is, she is getting. In the page 29, my lord, it was discussed in the order, my lord. As per the both the parties have submitted that in terms of Indian rupees, the minor daughter will get 4 lakhs per year. Admittedly, minor daughter of the applicant prosecuting a study in foreign country, the amount of 4 lakhs is not sufficient for such education. Now the respondent is spending 25 lakhs for her education. Now she is prosecuting her engineering in Tokyo, in Waseda University, for now September 2022. Now she is in second year, my lord. 25 lakhs is needed for our education, my lord. Now the amount is granted only for the educational expenses. For that insurance, my lord, it is jointly obtained by the petitioner and the respondent, my lord. Though the respondent name is not appearing in the insurance policy, because that time they are living together, my lord, there is no dispute between them. 2018, my lord, he has assaulted the respondent, my lord, in the Oman, my lord. She lodged a complaint there also, my lord, and even Indian embassy also notified. He flee from there, my lord. Then he came to India, my lord. Even after there is an order of not alienate, my lord. He is alienated his property to her sister. Most of the property he has alienated in the name of the sister, and he has taken a GPA. Some property is sold also, my lord. In one of the fixed deposit, which is naming the respondent also, my lord, 1 crore 19 lakhs he was withdrawn from her account, my lord, without her consent by forging her signature. With regard to, she has filed a separate criminal proceeding against the petitioner, my lord. There are several that even he is also filed a voice suit against the respondent, my lord. Now here is the only concern about that, my lord, that that I am not able to bear the educational expenses of the daughter, my lord. Already I have the expenses with regard to the son, my lord. I bear the expenses of the son, my lord. Not claimed anything about the son, my lord. Son is also prosecuted engineer, my lord. He studied, now he is working, my lord. So with regard to son, I am not claimed anything, my lord. Daughter, my lord, now she is in Tokyo, my lord. She is prosecuting, my lord. And her expenses 25 lakhs, my lord. I have the, even if I'll produce the receipt also, my lord. Nearly, my lord, 25 lakhs Indian equivalent money, my lord. I'm spending for education, my lord. The standard of living of both the parties, my lord, they lived in the abroad, my lord, they're earned well, my lord. So she, the daughter is also that she's also till getting the marriage, my lord. Now she's prosecuting her studies, my lord. She's also that she's responsible to get that money, my lord. Now the expenses which is bear by the respondent alone, my lord.
Milord, I may be permitted to continue my submissions, Milord. These are all the bare allegations for which I have produced the documents. She withdrawn the amount from my bank accounts, Milord. She withdrawn the joint FD held by me. I have produced the document.
According to him, now she is pursuing her education
Yes.
outside.
Howdu.
And also her expenses is 25 lakhs.
Howdu. Which the respondent can bear, Milord, because I have purchased a property in her name, Milord. Bombay 2.5 crore, I have purchased property in the name of respondent, which is fetching 70,000 rent, Milord. And I have purchased this thing, agricultural property in the name of respondent in Mudabidre, which is fetching 8 lakhs agricultural income, Milord. Other than that,
Agricultural.
There is no income. That's a false allegation.
Milord.
No such.
Milord.
I'm not getting any rent, my lord. I'm not getting any rent.
Milord, she has withdrawn. None the FD is 1 crore 39 lakhs, the joint FD. She has withdrawn, Milord. I have filed application for.
When it was withdrawn?
It was withdrawn, Milord.
1 crore?
1 crore 39 lakhs, joint FD. I have produced the document for that, Milord. In page number.
Joint FD, how she alone can withdraw the amount?
Madidare, Milord. I'll show, Milord. In page number 138. Page number 138. This is the joint FD held in. ಹೌದು ಜಾಯಿಂಟ್ ಎಫ್ ಡಿ ಹೆಲ್ಡ್ ಇನ್ ಯೂನಿಯನ್ ಬ್ಯಾಂಕ್ ಅಲಂಗಾರ ಬ್ರಾಂಚ್ ಮೂಡಬಿದ್ರೆ ಮಿಲಾಡ್. ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ತಾವು ನೋಡಬಹುದು ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ ಹೋಲ್ಡರ್ ಆಫ್ರಿಮ್ ಬಾಪ್ಟಿಸ್ಟ್ ಲೋಬೋ ಇಸ್ ದ ಪಿಟಿಷನರ್ ಮಿಲಾಡ್. ಇದು ಮೈ ಐಎ ಗಾಟ್ ಡಿಸ್ಮಿಸ್ಡ್. ಅದನ್ನ ಫ್ರೀಸ್ ಮಾಡೋದಕ್ಕೆ ಐ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ ಐಎ ಬಿಫೋರ್ ದಿ ಮೂಡಬಿದ್ರೆ ಕೋರ್ಟ್ ದಟ್ ಗಾಟ್ ಡಿಸ್ಮಿಸ್ಡ್. ಈವನ್ ಬಿಫೋರ್ ಐ ಕುಡ್ ಚಾಲೆಂಜ್ ಇಟ್, ಶಿ ಹರಿಡ್ಲಿ ವಿಡ್ರಾ ದಿಸ್ ಎಫ್ ಡಿ ಫಾರ್ ಶೋಯಿಂಗ್ ದಿಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ವಿಡ್ರಾನ್. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್
38.
ಹೌದು 138 ಅಲ್ಲಿ ಮಿಲಾಡ್ ಕೆಳಗಡೆ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಅಂತ ಒಂದು ಬಾಕ್ಸ್ ಇದೆ. ಎಫ್ ಡಿ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ ಹೋಲ್ಡರ್ ನೇಮ್ ಆಫ್ರಿಮ್ ಬಾಪ್ಟಿಸ್ಟ್ ಲೋಬೋ ಅಂತ ಇದೆ. ದೀಸ್ ಆರ್ ದ ಎಫ್ ಡಿಸ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್. ಹೌದು
ಸಿಂಥಿಯಾ ಲೋಬೋ ಅಂತ ಇದೆ. ಇಲ್ಲ,
ಕೆಳಗಡೆ ನೋಡಿ ಮಿಲಾಡ್,
ಹಸ್ಬೆಂಡ್
ಕೆಳಗಡೆ ಜಾಯಿಂಟ್ ಹೋಲ್ಡರ್, ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ ಹೋಲ್ಡರ್ ಇದು. ನಾನು
ಹಸ್ಬೆಂಡ್ ಬೋತ್
137, 138, 139 ಅಲ್ಲಿ ಈ ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ ಅಂಡ್ ದೆನ್ ಇಟ್ ಕಂಟಿನ್ಯೂಸ್. ಇದೆಲ್ಲ ವಿಡ್ರಾ ಆಗಿದೆ. ಫಾರ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಅ ಪ್ರೂಫ್ ಮಿಲಾಡ್. 143 ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಪೆರೋಸ್ ಫಾರ್ ಅ ಸೆಕೆಂಡ್ ಮಿಲಾಡ್. ಮೇಲ್ ಸೆಂಟ್ ಬೈ ದಿ ಬ್ಯಾಂಕ್. ನಾನು ಕೇಳ್ತೇನೆ ವಾಟ್ ಇಸ್ ದ ಸ್ಟೇಟಸ್ ಆಫ್ ಮೈ ಎಫ್ ಡಿ ಅಂತ ಕೇಳಿದ್ರೆ ಡೀಟೇಲ್ಸ್, ಡೆಪಾಸಿಟ್ ಡೀಟೇಲ್ಸ್ ಪ್ರೊವೈಡೆಡ್ ಬೈ ಯು ಇನ್ ದ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ ಅಟ್ ಪ್ರೆಸೆಂಟ್ ನಾಟ್ ಇನ್ ಯುವರ್ ನೇಮ್. ಇನ್ ಪೇಜ್ ನಂಬರ್ 143 ಮಿಲಾಡ್. 143 ಅಲ್ಲಿ
deposit details provided by you in the attachment
are at present not in your name, so we cannot provide you any information ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡಿರೋ ಬಗ್ಗೆ ಆಗ್ಲಿ. and then it continues to 144 page. 7th January and earlier to
provide the statement of the attached joint NRAs fixed deposit same also highlighted the joint. ಏನ್ರಿ ಇದು ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ನೀವು?
No, I am not finding anything, my lord. I will verify, my lord. That I'll
verify ಮಾಡಿ ನೋಡಿ ಹೇಳಿ.
I'll verify.
amount which is
My
in
lord,
the
because
joint
the-
deposit,
Because my lord, he was my lord, he was my lord by forging my signature, my lord, which is in my,
ಆಯ್ತು ಅದೆಲ್ಲ
for
criminal
that,
case
my
ಅಲ್ಲಿ
lord,
ನೀವು
ma'am, she might taken a precaution, my lord.
forgery separate proceedings.
Separate proceeding. For that precaution, she might inform the bank, my lord.
Total ಇರಿ.
She might
100
inform the bank not to release that amount to her.
Amount release ಆಗಿದೆಯಾ ಇಲ್ಲ?
I'll verify and.
For forging, my lord. In respect,
1.5 crore is taken ಅಂತಂದ್ರೆ
I will verify.
will consider this awarding of 40,000.
I will verify, my lord. My lord,
forging
now
is concerned, my lord.
My lord, even other.
This forging is concerned, 113, I have produced the document where she has withdrawn the amount from my bank account at Oman, my lord. ಅದ್ರಲ್ಲಿ ನಾನು ತೋರಿಸಿದ್ದೇನೆ. It is in reals, 800 reals, 400 reals. This is at the time of
My
her
lord,
separation in the
my-
year
my lord,
2018.
that is
When
in the
she
Oman,
was,
my lord.
when she has left the petitioner, she has withdrawn it. ಹೇಗೆ withdraw ಮಾಡ್ತಾರೆ ಅವ್ರ bank account?
Details ಕೊಡಿ ಎಷ್ಟು ದುಡ್ಡು withdraw
My
ಮಾಡಿದ್ದಾರೆ.
lord, that with
Total.
regard to that, my lord.
Total, yes, ma'am.
Including FD
Yes, my lord.
ಅಲ್ಲಿ ಏನು ಅಮೌಂಟ್ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಅಂತ. Then
Yes,
we'll
ma'am.
consider.
Clear.
ಹೇಗಿರು matter is pending before the trial court.
ಹೌದು. So,
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಆಗ್ಲಿ. ಫಸ್ಟ್ ದುಡ್ಡು ಎಷ್ಟು ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಅದು ಡೀಟೇಲ್ಸ್ ಕೊಡಿ. ನೀವು ನೋಡ್ರಿ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಿ.
With regard to the Oman, my lord, he has given the check, 2 checks in my, he left me, my lord, by assaulting me, my lord. That 2 check was issued, my lord, 300 MR, which was withdrawn for the purpose of daughter going for abroad, my lord. Education purpose, she has withdrawn, which is using the check, my lord, which is given by the petitioner.
ಆಯ್ತು.
With regard to the FD, my lord, I'll give an explanation.
ಎಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ ಜೊತೆಗೆ FD ಎಷ್ಟು ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಿ?
FD, I'll verify the FD and I'll.
So, respondent counsel seeks time to submit regarding withdrawal of joint FD amount. Counsel for the petitioner is also directed to furnish the details of payments made in favor of the respondent. List this matter on ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಒಂದು ವಾರ?
ಒಂದು 2
Weeks
weeks,
time.
my lord. 2 weeks.
2 weeks ಬೇಕಾ?
2 weeks.
ಕೊಡಿ 2 weeks ಕೊಡಿ ಮೇಡಮ್, ಡೇಟ್ ಕೊಡಿ.
5-4.
5-4.
The stay may continue.
Entry order granted earlier is extended. ಏನ್ ಸ್ಟೇ ಅದು?
Stay for
40,000.
operation is 40,000 payment.
ಬೇಕಾಗಿತ್ತು ದುಡ್ಡಿಗೆ.
Payment. ಹೌದು. ಅಲ್ಲ ಅದ್ರ ಕೊಡ್ಲಿಕ್ಕೆ ಬಂದ್ರು ಅದನ್ನು ಮ್ಯೂಚುವಲ್ ಆಗಿ ಮಾತಾಡ್ಕೊಂಡು ಮಾಡ್ಬೋದು. ತಂದೆಗೆ ಇಲ್ಲಿ ತನಕ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ. ದುಡ್ಡಿ ಕೇಳ್ತಾ ಇದೆ. ಈಗ ಇವರು ಈಸ್ ಅಟೈನಿಂಗ್ 60 years. ಇನ್ನು ಮಕ್ಕಳು ನೋಡ್ಕೋಬೇಕು ಅವ್ರನ್ನ. ಇನ್ನು ರ್ಯಾನ್ಸಾಕ್ ಮಾಡಿ ಟೋಟಲಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿ FD ಎಲ್ಲ ತಗೊಂಡು ನಾವು ಸ್ಟಿಲ್ ದೇ ಆರ್ ಡಿಮಾಂಡಿಂಗ್. ನಾನು 60 ವರ್ಷದಲ್ಲಿದ್ದೇನೆ.
ಆಯ್ತು ಬನ್ನಿ 5ನೇ ತಾರೀಕು ಇಬ್ರು ನೋಡ್ ಏನಾಗಿದೆ ಇಬ್ರದ್ದು. ಹಾ,
Serial number 30.
86 day in filing. ಕಲ್ಯಾಣ ಅದರ್ ಸೈಡ್ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಯಾರು ಸ್ಟೇಟ್
ಸ್ಟೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿ
ಹೊರಡಾನ ಏನ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯೇನ್ರಿ? 86 ಡೇಸ್ಗೆ ಏನ್ ರಿವಿಷನ್ ಇದು?
discharge application, 39 application is rejected. My lord, in the offences, my lord, on the basis of a complaint dated 24 to 22, yes, came to the register under section 304A. Painting ಮಾಡುವಾಗ 3rd floor ಇಂದ ಕೆಳಗೆ ಬಿದ್ದು ಸತ್ರು. Accused number 2 is discharged. Lord, the complaint is at page number 22. The allegation is that, my lord, the deceased was doing, my lord, painting work.
ಆಯ್ತು ಅದೆಲ್ಲ ಆಯ್ತು ನೋಡ್ದೆ
At
order
ಮೂರನೇ
ಓದಿ.
ಫ್ಲೋರ್ ಅಲ್ಲಿ he was doing painting work. ಆಯ ತಪ್ಪಿ ಕೆಳಗ್ ಬಿದ್ದರು ಅಂತ.
ಎಲ್ಲಿದೆ ಕಂಪ್ಲೇಂಟ್?
ಕಂಪ್ಲೇಂಟ್ ಪೇಜ್ ನಂಬರ್ 22, 22.
22ರಲ್ಲಿ ಇಲ್ರಿ ಅದು ಆರ್ಡರ್ ಶೀಟ್. ಆರ್ಡರ್ ಶೀಟ್ ನಿಮ್ಮ ಪಿಟಿಷನ್ ಅಲ್ಲೇ ನಿಮಗೆ ಎಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅದು. ನೀವೇನಾಗ್ತೀರಿ ಅದು ನಿಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಕಂಪ್ಲೇಂಟ್ ಅಟ್ ಪೇಜ್ 46, ಇಂಕ್ ಪೇಜ್ 46. ಮೊದ್ಲು ಯಾವ್ದೋ ಒಂದು ಹಾಕಿದಿರಿ 22 ಅಂತ ಮತ್ತೆ ರೌಂಡ್ ಅಪ್ ಮಾಡಿದಿರಿ.
ಅದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಆದಾಗ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ ಮನವಿ ಕಾರ್ಡ್ ಮಾಡಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ತಮ್ಮ ತಂದೆ ತಾಯಿಗೆ 3 ಜನ ಮಕ್ಕಳು, ವಿನೋದ್ ಕುಮಾರ್, ಅನೀಶ್ ಕುಮಾರ್, ಸ್ನೇಹ ಆಗಿದ್ದು, ನಮ್ಮ ಅಣ್ಣ 6 ವರ್ಷಗಳಿಂದ ಪೇಂಟಿಂಗ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು, ಹೀಗೆ 3 ವರ್ಷಗಳಿಂದ ದೇವಿನಗರದ ಮಂಜೂರು ನಿವಾಸಿ ರಾಜು ಎಂಬುವರ ಬಳಿ ಪೇಂಟಿಂಗ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ. ರಾಜುರವರು ಕಟ್ಟಡಗಳ
ಪಿಟಿಷನರ್ ಇವನ್ ಕಾಂಟ್ರಾಕ್ಟರ್.
ರಾಜು ಮೇಲೆ ರಾಜು ಇಸ್ ಡಿಸ್ಚಾರ್ಜ್ ನಾ. ರಾಜು ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ.
ರಾಜು ಯಾರು?
Raju is also one of the contractor according to the complaint.
Contractor Rajuna.
A1 and A1 and A2.
The A2 na discharge ಮಾಡಿದ್ದಾರೆ.
A2 discharge ಮಾಡಿದ್ದಾರೆ. On the ground that there are no materials and no allegations are made against the.
But agreement ಇದೆಯಂತಲ್ಲ ನಿಮ್ದು. ಹಾಸ್ಪಿಟಲ್ ಅವ್ರ ಜೊತೆ ಅಗ್ರಿಮೆಂಟ್ ಇರೋದು ನಿಮ್ ಜೊತೆ ಅಂತಲ್ಲ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಲೇಬರರ್ಸ್ ನ ಕರ್ಕೊಂಡ್ ಬಂದಿರೋದು ರಾಜು. That's what they stated in the complaint.
ಕರ್ಕ ಬಂದಿರೋದು ಅವನು ಇರಬಹುದು, ಬಟ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರೋದು ಬಿಟ್ವೀನ್.
ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರೋದು ಆಸ್ಪತ್ರೆ ಜೊತೆಗೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and Lord the doctor or the proprietor of the hospital.
ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡವ್ರನ್ನೇ ಸೇಫ್ಟಿ ಮೆಜರ್ಮೆಂಟ್ಸ್ ತಗೋಬೇಕಲ್ವಾ?
The person who supplies my lord the laborers.
That is between you and him ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ದೇಸೆ
ಏನಂತ
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ರಾಜು ಅವರೇ ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದು ಅಂತ. ರಾಜು ಅವರೇ ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದು, ರಾಜು ಮತ್ತು
ಸಬ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ಅವನಷ್ಟೇ.
ರಾಜು ಮತ್ತು ಇವರು ಮಾಡ್ತಾ ಇದ್ರು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
He used to supply the employees. But you have taken the painting contract from the hospital.
ಅದರಲ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ಇಂದ ಈವನ್ ಮಹಜರ್ ಆಯಾ ತಪ್ಪಿ 3ನೇ ಮಹಡಿಯಿಂದ ಬಿದ್ದಿದ್ದು ಅಂತ. ಇಟ್ ಇಸ್ ನಾಟ್ ಅನ್ ಅಕೌಂಟ್ ಆಫ್ ನಾಟ್ ಪ್ರೊವೈಡಿಂಗ್ ಸೇಫ್ಟಿ ಗೇರ್. ಆಯಾ ತಪ್ಪಿ 3ನೇ ಮಹಡಿಯಿಂದ ಬಿದ್ದಿದ್ದಾರೆ ಅಂತ. Nurse may kindly my lord sir.
ಏನ್ರಿ ಅಫೆನ್ಸ್ ಅಂದ್ರೆ ಅಟ್ರಾಕ್ಟ್
Offense,
304.
he is not providing the safety measures.
ಸೇಫ್ಟಿ ಗೇರ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಸೇಫ್ಟಿ ಏನು ಪೇಂಟಿಂಗ್ ಮಾಡೋರ್ಗೆ ಏನ್ ಸೇಫ್ಟಿ
Helmet.
ಕೊಡ್ತಾರೆ? ಕೆಲಸ ಮಾಡೋನ್ ಜಾಗೃತವಾಗಿರ್ಬೇಕು ಅಷ್ಟೇನೆ. ಈಗ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಪೇಂಟ್ ಹೊಡಿತಾ ಇರ್ತಾನೆ, ಅದಕ್ಕೆ ಯಾರು ಜಾಗೃತ ಇರ್ಬೇಕು? ಕೆಲಸ ಮಾಡೋನೆ ಪೇಂಟಿಂಗ್ ಅಲ್ಲಿ ಜಾಗೃತತೆ ವಹಿಸ್ಬೇಕು, ಹೌದಲ್ಲ?
Contract.
ಹಾ?
Contract.
ಕ್ರಿಮಿನಲ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹೆಂಗ್ರಿ? ಏನ್ ಅಫೆನ್ಸ್ ಇನ್ವೋಕ್ ಮಾಡ್ರು? 304A ಏನ?
ಹಾ ಸರಿ.
Prima facie case is made out against the prima facie case made out against the accused.
ಏನ್ prima facie ಕೇಸ್?
Yes, main contractor.
ಮೇನ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, ಆದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ಅವನು? ಈಗ ಪೇಂಟಿಂಗ್ ಈಗ ಅವ್ನು ಬಿಟ್ಟಿರ್ತಾನೆ, ಹೌದಲ್ಲ? ಕೆಲ್ಸಕ್ಕೆ ಬಿಡ್ತಾನೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು. Who has to work with diligence? ಬಟ್ ನೀವು ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದೀರಿ ಹಾಸ್ಪಿಟಲ್ ಅವ್ರ ಜೊತೆ?
ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ
ಜೊತೆ.
11 ಜೊತೆ.
Ganesh.
ಸರಿ. ಅಲ್ಲ ಮಾಜರ್ ಅಲ್ಲಿ ಡೂಯಿಂಗ್ ಪೇಂಟಿಂಗ್ ವರ್ಕ್ ಇನ್ ಥರ್ಡ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಪೇಂಟಿಂಗ್ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದಾಗ ಆಯತಪ್ಪಿ ಕೆಳಗೆ ಕಾಂಪೌಂಡ್ ಮೇಲೆ ಬಿದ್ದು, ಕಾಂಪೌಂಡ್ ನಿಂದ ಮತ್ತೆ ಚರಂಡಿ ಸ್ಲಾಬ್ ಮೇಲೆ ಬಿದ್ದು he was injured. There should be nexus between the allegations made and the injuries suffered. My lord, even, my lord, assuming for an argument's sake, safety gear was not provided. If he falls from third floor on the compound wall, the kind of injuries he would have suffered. Compound well middu ನಂತರ ಚರಂಡಿ slab ಮೇಲೆ ಬಿದ್ದಿದ್ದಾನೆ.
If he was wearing the helmet, my lord,
ಕಟ್ಟಡದ 3ನೇ ಅಂತಸ್ತಿನಲ್ಲಿ ಪೈಂಟ್ ಮಾಡುವಾಗ ಆಯತಪ್ಪಿ ಕೆಳಗೆ ಬಿದ್ದು ಗಾಯಗೊಂಡಿರುವುದಾಗಿ ತಿಳಿದು ಬಂದಿದೆ.
ಹೆಲ್ಮೆಟ್ ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ.
My lord, as per the, my lord, post-mortem report.
ಹೆಲ್ಮೆಟ್ ಕೊಟ್ರು ಹೆಲ್ಮೆಟ್ ಹಾಕೊಂಡು ಪೇಂಟ್ ಮಾಡ್ತಾರೇನ್ರಿ?
ಮಾಡ್ತಾರೆ. ಥರ್ಡ್ ಫ್ಲೋರ್ ಇಂದ ಹೆಲ್ಮೆಟ್ ಹಾಕೊಳ್ತಾರೆ ಸುಮ್ಮನೆ.
ಯಾವ್ದಾರು ಪೇಂಟರ್ ನ ನೋಡಿದಿರ ನೀವು ಹೆಲ್ಮೆಟ್ ಹಾಕೊಂಡು ಪೇಂಟ್ ಹೊಡೆಯದ?
ಅಲ್ಲ, ದೊಡ್ಡ ಬಿಲ್ಡಿಂಗ್
ಬಿ ಪ್ರಾಕ್ಟಿಕಲ್. ಯು ಬಿ ಪ್ರಾಕ್ಟಿಕಲ್.
ಯಾ ಶುಡ್ ಪ್ರೊವೈಡ್ ದ ಸೇಫ್ಟಿ ಕಿಟ್.
ಏನ್ ಸೆಕ್ಯೂರಿಟಿ ಕೊಡ್ಬೇಕ್ರಿ ಪೇಂಟ್ ಮಾಡುವಾಗ?
ಸೇಫ್ಟಿ
ಅವನ್ ಜಾಗ್ರತೆಯಲ್ಲಿ ಇರ್ಬೇಕು. ಇದು ಆಯತಪ್ಪಿ ಬಿದ್ದಾಗ ಏನ್ ಇಂಟೆನ್ಷನಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇರುತ್ತೆ ಇಲ್ಲಿ?
It has to be decided in full-fledged trial. It has to be decided in full-fledged trial. There is a prima facie case made out against this accused.
Heard. I1 of 24. And there is a delay of 86 days in filing the revision petition. And for the reasons stated in the accompanying application and affidavit, delay of 86 days is condoned. List this matter for admission along with IA 2/24. Yadar on this accord.
Lord,
Admission.
notice to respondent number 2. Notice to respondent number 2 may be.
Issue notice against respondent number 2.
Notice may be dispensed.
ಯಾರಿಗೆ?
Yes, respondent number 2.
Notice ಕೊಟ್ಬಿಡೋಣ ಬಿಡಿ, ಅವ್ರೇನ್ ಬಂದು ಹೇಳ್ತಾರೆ ಬರ್ಲಿ. Please. Issue notice against R2. List this matter on April. Second week.
10th April.
10/4.
Much.
31, Sampath A.
This matter, my lord, the application for dispensation.
Dispensation of production of CC na.
Please, my lord, that judgment was produced before the learned appellate court, my lord.
Why the same has to be dispensed? You copy ತಗೊಳ್ಳೋದು ಹಾಕೋದು ಅಷ್ಟೇನೆ.
Please, my lord, but that was by oversight. It was not applied with the appellate court judgment order. That apply, my lord. That shall be produced, my lord, the judgment certified copy which was produced before the appellate court.
ಏನು judgment ಏನು?
My lord, the 138 matter, my lord, the accused petition has been convicted. The check amount is, my lord, the 1,67,78 rupees. I'm lord convicted for 1,75 lakhs, my lord, and is confirmed. The defense is that, my lord, it's a construction contract. The respondent, my lord, is a developer. But the company is not been made in party, my lord. The check is issued in favor of by the company. The petitioner is a partner. My lord, that contention is, though, my lord, there are several materials to show, my lord, the invoices and other materials was purchased in the name of company, and my lord, the petitioner is made as a partner. Or the learned trial court says that, my lord, you have not produced the partnership deed, my lord, and it holds that it's a proprietorship concern.
40% deposit ಮಾಡಿ, then we'll see.
Please, my lord.
ಜಾಸ್ತಿ ಅಮೌಂಟ್ ಇರೋದ್ರಿಂದ 40% ಮಾಡಿದ್ವಿ. ತೊಗೊಳ್ಳಿ.
Please.
Heard on IA 1 of 24 for dispensation of production of certificate copy. And for the reasons stated in the accompanying application and affidavit, IA is allowed subject to producing the same within 4 weeks.
Please, my lord.
Heard on IA number 2 of 24 for suspension of sentence. The counsel appearing for the revision petitioner would submits that the main contention urged in the revision petition is that then company party ಮಾಡಿಲ್ಲ ಅಂತ.
Company has not been made a party.
Company has not been made as party to the proceedings, and without arraying the company, the complainant cannot proceed against the revision petitioner. On perusal of judgment of the trial court, accused is sentenced to pay a fine of rupees 1,75,05,000. and the same is confirmed in the first appellate court. And in view of the grounds urged in the revision petition, the matter requires reconsideration. ಮಾಡ್ಕೊಳ್ಳಿ surety ಇದು bond for 5 lakhs with two sureties. So two sureties and payment of rupees 40%. So appellate court ಅಲ್ಲಿ ಏನಾದ್ರು ಡೆಪಾಸಿಟ್
We were
ಮಾಡಿದ್ರಾ?
deposited Milord certain amount.
Excluding ಹಿಂಗ ಹಾಕ್ಬಿಡಿ, including ಅಂತ
Please, I'm obliged.
40%. Notice also, issue notice against the respondent.
Admission matter 32.
Petitioner, my lord. Trial court record.
CCR awaited ಅಂತ ಇದು ಬಂದಿದೆ ಇಲ್ಲ? ಇದು ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು? ಬೆಂಗಳೂರು ಪಾಸ್ ಓವರ್ ಮಧ್ಯಾಹ್ನ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಾಲ್ ಮಾಡಿದ್ದೀವಿ ಪಾಸ್ ಓವರ್.
And also 35 minor, 35 also TCR.
ಅದು 35 ಆಲ್ಸೋನಾ?
ಹೌದು.
ಇದು
35
ಬೆಂಗಳೂರಿನ?
ನಾನ್ ಪಿಟಿಷನರ್.
ಹಾ?
TCR
CCR awaited.
ಹೌದು.
ಇದೆಲ್ಲ ಬೆಂಗಳೂರು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್.
Bangalore.
ಬರ್ಲಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಬರ್ಲಿ ಮಧ್ಯಾಹ್ನ. PO.
Afternoon.
ಹ್ಮ್.
Both the matter.
2:30.
33. SPP.
35 also.
35. 35 also 2:30. Number 33. ಯಾರು ಇಲ್ವಾ? ನಿಮ್ದೇ ರೀ SPP. Maintainability ಅಂತ ಏನೋ ಇದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದು ಅಲ್ಲ?
Appeal also.
Against the acquittal, how revision will maintain?
Against the acquittal, we are already filed appeal.
Offense ಏನ್ರಿ?
Offense excise. 13(1).
Excise Act.
Excise.
ಹಾ
13(1) AF.
ಇಲ್ಲ acquittal ಆಗಿದೆ ಅಲ್ವಾ?
Acquittal ಆಗಿದೆ, but announcement ನಾವು ಕೇಳಿದ್ವಿ.
ಎನಾನ್ಸ್ಮೆಂಟ್ ನೀವು ಕೇಳಿರೋದಂದ್ರೆ ಎಲ್ಲಿ? ಎಲ್ಲಿ ನೀವು ಎನಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿರೋದು?
ಅಲ್ಲಿ ಇದು
ನೀವು ಎನಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದ್ರಿ?
appellate court ಅಲ್ಲಿ.
ಹಾ ಅವ್ರ ಅಪೀಲ್ ಹಾಕಿದ್ರು.
ಅವ್ರ appeal ಹಾಕಿದ್ರು.
ಈಗ ನೀವು ಅಕ್ವಿಟಲ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಸರ್.
ಹಾ
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
ಮತ್ತೆ how you can maintain a revision against the order of acquittal?
Kindly accommodate.
ಹಾ
Kindly accommodate.
ಅಕಾಮಡೇಟ್ ಮಾಡಿದ್ನಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ಮೇಲೆ ನಿಮಗೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ವಿ ಇವತ್ತು ಹೇಳಿ how revision petition will maintainable ಅಂತ. Maybe have challenged the inadequate sentence before the appellate court.
Please.
But at the same time, the accused also challenged the order of conviction.
3 days time.
Now conviction is set aside.
3 days time.
ಮತ್ತೆ 3 days time ರೀ. Revision not maintainable. ಆಯ್ತು ತಗೊಳ್ಳಿ. Revision ತಗೊಳ್ಳಿ. HGP 6 3 days time to submit regarding maintainability. List this matter on next week ಕೊಡಿ ಆಗ್ಲಾರ weekend ಅಲ್ಲಿ.
28.
28/3.
34. Vagishian.
For respondents. The cost has been paid.
Hmm. 38,90,000 ಏನಿದು?
Check amount
9
is,
lakhs.
check amount the complainant paid the amount.
ಚೆಕ್ ಅಮೌಂಟ್ ಎಷ್ಟು?
ಚೆಕ್ ಅಮೌಂಟ್ 32,50,50,500 ರೂಪಾಯಿ. ಆದ್ರೆ ದುಡ್ಡು ಕೊಟ್ಟಿರೋದು 24,05,500 ರೂಪಾಯಿ. 24,55,500 ರೂಪಾಯಿ. It was towards a land transaction. The transaction took place. Lordship may kindly peruse. The complainant is a British citizen. And she wanted to reap some benefits by investing in lands in and around Mysore. And she requested the help of the accused who is her best friend. Both are doctors by profession. Therefore, on her say, the accused started searching for some lands and ultimately zeroed in on a particular land and sought the opinion of the complainant in purchasing the said land. And both the complainant and the accused did not know the
ಯಾವಾಗ ರಿಸೀವ್ ಮಾಡಿದ ಅಮೌಂಟ್ 2014?
2013ರಲ್ಲಿ 10ನೇ ತಿಂಗಳಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, 2014ರಲ್ಲಿ ಎಂಡ್ ಆಗುತ್ತೆ.
Subsequently, both the persons came to know that the complainant is unable to purchase the property on account of the bar under Karnataka Land Reforms Act because she is a British citizen. Therefore, she sought for the return of the money. By that time, the accused had already invested the said money in the purchase of the land by entering into memorandum of understanding with the landowners. And she, in fact, it is her case that this 24 lakhs 5,000 rupees will be repaid if given some time. And at no point of time, the accused never stated that she will not return the amount because this amount has been invested there. The primary object of the complainant was to invest the money in a land, and she was in Britain. She is a British citizen, and she took the services of the accused, and on the promise and assurance of the complainant, she in fact parted with the money. She paid whatever the money which has been paid to her, it has been paid to the landowners. And when she came to know that she could not purchase the land on account of the bar contained under 79 A and B of Karnataka Land Reforms Act, she started pressuring the accused that ನಾನು ತಗೊಳಕ್ಕಾಗೋದಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನೀವು 24 ಲಕ್ಷಕ್ಕೆ 1 ಕೋಟಿ ರೂಪಾಯಿ ಕೊಡು ಅಂತ ಹೇಳಿ ಪ್ರೆಷರ್ ಮಾಡಿದಾಗ ಒಪ್ಪದೇ ಇದ್ದಾಗ she came down to Mysore, filed a police complaint.
ಚೆಕ್ ಯಾವ ಇಯರ್ ಕೊಟ್ಟಿದ್ದು?
ಚೆಕ್ಕು 2015ರಲ್ಲಿ
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ 2014.
19/4/2015ರಲ್ಲಿ ಚೆಕ್ಕು ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. But it is the case of the accused that she approached the police and through the police exerted pressure and took the check for 32,50,000. How this 32,50,000 has come into existence, what calculation, she does not disclose. And it is her contention that 32,50,500 rupees is calculated at 3% interest. That amounts to 36% interest per year. ಆ ರೀತಿ ಅವರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಹೇಳ್ತಾರೆ. My respectful submission is that it is her own admission that
ಏನ್ರಿ ಇಬ್ರು ನೋಡ್ರಿ ಸೆಟಲ್ ಮಾಡ್ಕೋತಾರೆ ನೋಡ್ರಿ 24 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಇದರ ದುಡ್ಡು.
ಎಸ್ ಮ್ಯಾಮ್.
ಮತ್ 39 ಲಕ್ಷ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅಲ್ಲೇನಾಗಿದೆ 2013 ಅಲ್ಲಿ ಅಮೌಂಟ್ ತೆಗೆದುಕೊಂಡಿರ್ತಕ್ಕಂಥದ್ದು. 2013 ಇಂದ 2014 ಮತ್ತೆ ಸಿ ವಾಲಂಟ್ಲಿ ಮೇಲ್ ಟು ದಿ ಪೆಟಿಷನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಡಿಲೇ ಆಗಿದೆ, ನನ್ನ ಕಡೆಯಿಂದ ಸೈಟ್ ಪರ್ಚೇಸ್ ಮಾಡಕ್ ಆಗ್ತಲ್ಲ, ಅಲಾಂಗ್ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಸೇರ್ಸ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಅವರೇ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ
ಮೇಲ್ ಮಾಡಿದಾರ.
ಹೌದು, ಮೇಲ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು. ಆಮೇಲೆ ಅವ್ರು ಅದಕ್ಕೋಸ್ಕರನೇ ಅಮೌಂಟ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಬ್ರಿಟನ್ ಇಂದ ಬಂದಿರ್ತಕ್ಕಂಥದ್ದು ಇಲ್ಲಿ. ಆಗ ನೆಗೋಷಿಯೇಟ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು, ನೆಗೋಷಿಯೇಟ್ ಆಗಿ ಫಸ್ಟ್ ಏನ್ ಮಾಡ್ತಾರೆ 32,50,000ಗೆ ಫಸ್ಟ್ ಬ್ಲಾಂಕ್ ಚೆಕ್ ಕೊಡ್ತಾರೆ. ಚೆಕ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟು ವಿತೌಟ್ ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ, ನಾನು ಅರೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಒಂದು ಲೀಗಲ್ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ ಇವ್ರಿಗೆ. ಈಗ ಈ ರೀತಿ ಇದೆ, ನನ್ನ ಹತ್ರ ಟ್ಯಾಕ್ಟ್ಫುಲ್ ನೀವು 32,50,000 ತಗೊಂಡಿದ್ದೀರಿ ಅಂತ. ಎಗೈನ್ ತಿರ್ಗಾ ಹೋಗಿ ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಅಂತ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಂತ ಸಂದರ್ಭದಲ್ಲಿ ಆವಾಗ ಮತ್ತೆ ನೆಗೋಷಿಯೇಟ್ ಆಗಿ ಅವರೇ ವಾಲಂಟರಿಲಿ ಡೇಟು ಸಹ ಫಿಲ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಡೇಟು ಫಿಲ್ ಮಾಡಿಕೊಟ್ಟಾದ್ಮೇಲೆ ಶಿ ಇಸ್ ನಾಟ್ ಆನರ್ಡ್ ದಿ ಚೆಕ್. Now 2024 ಮೇಲೆ already 1 decade has been lapsed.
ನಾನು ಮೇಲ್
ಅಟ್ಲೀಸ್ಟ್ ಈ ಕೂಡ ಬೋನಫೈಡ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರೆ she could have ಇಬ್ರು ಡಾಕ್ಟರ್ಸ್ ಇದ್ರು 24,05,000 ಅವಾಗಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪ್ಯೂಟ್ ಸಾಲ್ವ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ.
ಅಲ್ಲ, ನಾನು ಮೇಲ್ ಕಳಿಸಿದೀನಿ.
ಅವ್ರು ಹೇಳ್ತಕ್ಕಂಥ ಒಂದು ಆಲ್ವೇಸ್
ಮೇಲ್ ಮಾರ್ಕ್ ಆಗಿದೆಯಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಆಗಿದೆ, ಅದನ್ನ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಆ ಮೇಲನ್ನು ಅವರೇ ಕಳಿಸ್ಕೊಂಡು ಅವ್ರ ಮೇಲಿಂದನೇ ಬಂದಿದೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಇಟ್ ಈಸ್ ನಾಟ್ ಸೆಂಟ್ ಬೈ ಮೀ ಅಂತ ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಇನ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ I have never agreed that I will give 36 lakhs of rupees. Your Lordship may kindly see.
What is ಸವಾಲ್?
ಸವಾಲಲ್ಲಿ
ಎಕ್ಸಿಬಿಟ್ P9 ವಾಟ್ಸ್ಆಪ್ ಕಾನ್ವರ್ಜೇಷನ್ ನ ಕನ್ವರ್ಟೆಡ್ ಎಸ್ ಎ ಮೇಲ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು. ಅವರು ಆ ವಾಟ್ಸ್ಆಪ್ ಕಾನ್ವರ್ಜೇಷನ್ ನ ಮೇಲ್ಗೆ ತೆಗೆದುಕೊಂಡು ಅದನ್ನ ಪ್ರಿಂಟ್ ಔಟ್ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು. ಇವರು ಅದನ್ನ ವಾಟ್ಸ್ಆಪ್ ಕಾನ್ವರ್ಜೇಷನ್ ನಿಮ್ಮ ಮೇಲಿಂದ, ಅಂದ್ರೆ ಯಾವಾಗ್ಲೂ ಮೇಲ್ ಕಾನ್ವರ್ಜೇಷನ್ ನ ಇಮೇಲ್ ಚಾಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಮ್ಮ ಮೇಲಿಂದ ನಮ್ಗೆ ಬರ್ತಕ್ಕಂಥದ್ದು.
65B certificate has not been given. That is also taken a contention. That your Lordship may kindly see this page 7 of the cross examination. 6/1/2017
Exhibit P5 ಏನು?
Exhibit P5 postal receipts. Exhibit P6 acknowledgement. Exhibit P7 also acknowledgement. Exhibit P8 reply notice. There are 3 notice. First one notice ಕೊಡ್ತಾರೆ, subsequent reply notice ಕೊಡ್ತಾರೆ, ಆಮೇಲೆ demand notice ಕೊಡ್ತಾರೆ, demand notice reply ಕೊಡಲ್ಲ.
May I submit?
Exhibit P9 ಹೋಗಿ.
P9 ಇವರೇ ಕಳ್ಸ್ಕೊಂಡಿರೋದು ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಇವರೇ ಕಳ್ಸ್ಕೊಂಡಿದ್ದಾರೆ, ನಾನ್ ಕಳ್ಸಿರೋದಲ್ಲ ಅದು. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ, ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ
ಅದು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಬಂದಿದ್ದನ್ನ ಕಳ್ಸ್ಕೊಂಡಿದೀವಿ.
ಅದನ್ನ ನಾನ್ ಕಳಿಸಿದ್ದಲ್ಲ ಅದು. 65
P10.
ಸದರಿ ಆರೋಪಿ ನನಗೆ ನನ್ನಿಂದ ಪಡೆದುಕೊಂಡ ಹಣವನ್ನು 3% ಮಾಸಿಕ ಬಡ್ಡಿಯೊಂದಿಗೆ.
Before that, kindly peruse the exhibit P11 7/7/2015. They have issued the first notice. They have issued the first notice.
ಅಲ್ಲ, ನಾನು ಹೇಳೋದು ಸ್ವಲ್ಪ.
Before presentation, they have issued their notice only.
ಸದರಿ ಆರೋಪಿ ಎಕ್ಸೆಟ್ರಾ ಸಂಪೂರ್ಣ ಹಣ ಪಾವತಿ ಮಾಡುವುದಾಗಿ ಇಮೇಲ್ ಮೂಲಕ ಕೊಡುವುದಾಗಿ ಹೇಳಿರುತ್ತಾಳೆ. ಸದರಿ ಆರೋಪಿ ನನ್ನಿಂದ ಪಡೆದುಕೊಂಡ ಹಣಕ್ಕೆ ಮಾಸಿಕ 3% ಬಡ್ಡಿಯನ್ನು 13/1/2015.
ಪೇಜ್ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು?
ಇದು
ಪೇಜ್
ನಂಬರ್ 8 ಆಫ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಏಜ್ 8 ಅಂತ ಇದೆ. 6/1/2017 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಅದರಲ್ಲಿ regarding this exhibit P9 and 10, kindly peruse page 8. ಸಿಗ್ತದೆ. ಅದರಲ್ಲಿ ಆರೋಪಿ ಸದರಿ ನನ್ನಿಂದ ಪಡೆದುಕೊಂಡ ಹಣಕ್ಕೆ 3% ಮಾಸಿಕ ಬಡ್ಡಿಯೊಂದಿಗೆ 15ರಿಂದ ಸಂಪೂರ್ಣ ಹಣ ಪಾವತಿಸುವವರೆಗೆ ಕೊಡುತ್ತೇನೆಂದು ಆರೋಪಿ ನನಗೆ ಇಮೇಲ್ ಅಥವಾ ವಾಟ್ಸಾಪ್ ಮೂಲಕ ತಿಳಿಸಿರುವುದಿಲ್ಲ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ನಿಶಾನೆ P9 ಮತ್ತು 10ರಲ್ಲಿ ನಮೂದಾಗಿರುವಂತೆ ಸದರಿ ವಾಟ್ಸಾಪ್ನಲ್ಲಿ ನಾನೇ ನನ್ನ ಹೆಸರಿಗೆ ಕಳಿಸಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ ಎನ್ನುವುದು ಸರಿ. ಅವರೇ ಕಳಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು that she has produced it. It is not that I have produced, I have sent any message. ಮುಂದುವರೆದು ಸಾಕ್ಷಿ, ನಾನು 13/7/2015 ಶ್ರೀನಾಥ್ ಅನ್ನುವರಿಗೆ ಇಮೇಲ್ ಕಳಿಸಿದ್ದು, ಶ್ರೀನಾಥ್ ಅನ್ನುವರಿಗೆ ಕಳಿಸಲು ಇಮೇಲ್ ಅನ್ನು ರೆಡಿಯಾಗಿ ಇಟ್ಟುಕೊಂಡಿದ್ದೆ, ಅದನ್ನೇ ಶ್ರೀನಾಥ್ ಅನ್ನುವರಿಗೆ ಕಳಿಸಿದ್ದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. There is a contradiction. Where is the admission, specific admission from the side of the accused? ಸದರಿ ನಿಶಾನೆ 9 ಮತ್ತು 10ರಲ್ಲಿ ನಮೂದಿಸಿದಂತ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಅನ್ನು ನಾನೇ ನನ್ನ ವಿಳಾಸಕ್ಕೆ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ ಎನ್ನುವುದು ಸರಿ.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು ಡಿಸ್ಕಸ್, ಅವರ ಮೆಸೇಜ್ ಮೇಲೆ ಎಲ್ಲಿದ್ದಾರೆ?
ವಾಟ್ಸ್ಆಪ್ ಕಾನ್ವರ್ಸೇಷನ್, ವಾಟ್ಸ್ಆಪ್ ಚಾಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು.
ಆಯ್ತು, ಅದು ಎಲ್ಲಿದೆ ವಾಟ್ಸ್ಆಪ್? ನಿಮ್ದು ಅವ್ರದ್ದು ವಾಟ್ಸ್ಆಪ್ ಕಾನ್ವರ್ಸೇಷನ್ ಎಲ್ಲಿದೆ?
ಎಸ್, ಅದನ್ನ ಮೇಲ್ ತಗೊಂಡ್ಕೊಂಡಿರ್ತಕ್ಕ, ಅದನ್ನ ನೀವು ಹೇಳ್ತಾರೆ ಲಾಸ್ಟ್ 4th ಲೈನ್ ಈಗ ಓದಿದ್ದು, ನಾನೇ ನನ್ನ ವಿಳಾಸಕ್ಕೆ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ ಅದು ಸರಿ. ಅದ್ರ ಮೇಲ್ಗಡೆ ನೀಪಿ 9 ಮತ್ತು 10ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಅನ್ನು, ದಟ್ಸ್ ಅವರ್ ಸಜೆಷನ್. ದಿಸ್
ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಎಲ್ಲಿದೆ ಈಗ?
ಸೇಮ್ ಅದನ್ನ ಕನ್ವರ್ಟೆಡ್ ಇಂಟು ಮೇಲ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಅಷ್ಟೇ. ನಾವು ಚಾಟ್ ಮೇಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ವಾಟ್ಸ್ಆಪ್ ಮಾಡಿದ್ದು ಎಲ್ಲಿದೆ ರೀ ದಾಖಲೆ?
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ದಾಖಲೆ ಇದೆ, ಅವ್ರ ಮೊಬೈಲ್ ಅಲ್ಲಿ ದಾಖಲೆ ಇದೆ, ಅದನ್ನ ಕನ್ವರ್ಟೆಡ್ ಆಸ್ ಇಮೇಲ್ ಮಾಡ್ಕೊಂಡಾಗ
ಇಮೇಲ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅವ್ರು ಕಳ್ಸ್ಕೊಂಡಿದ್ದಾಯ್ತು. ಬಟ್ ನೀವು ಅವ್ರು ನಿಮಗೆ ಕಳ್ಸಿರೋದ ವಾಟ್ಸ್ಆಪ್ ಎಲ್ಲಿದೆ?
ಸ್ಟೋರ್ಡ್ ಇನ್ ಮೊಬೈಲ್ ಮೇಲೆ.
ವಾಟ್ಸ್ಆಪಿನ ದಾಖಲಾತಿ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿದಿರಲ್ಲ ನೀವು?
ಹೌದು, ಸ್ಟೋರ್ಡ್ ಇನ್ ಮೊಬೈಲ್ ಅಷ್ಟೇ, ಅದನ್ನ ಹಾಜರುಪಡಿಸಿಲ್ಲ, ಇಮೇಲ್ ಅಷ್ಟೇ.
ನನ್ನಿಂದ ಪಡೆದುಕೊಂಡ ಹಣಕ್ಕೆ ಮಾಸಿಕ 3% ಬಡ್ಡಿಯನ್ನು 13/1ರಿಂದ ಸಂಪೂರ್ಣ ಹಣ ಪಾವತಿಸುವವರೆಗೆ ಪಾವತಿಸುವುದಾಗಿ ವಾಟ್ಸ್ಆಪ್ ಮೂಲಕ ಮೆಸೇಜ್ ಕಳಿಸಿದ ಕುರಿತು ವಾಟ್ಸ್ಆಪಿನ ದಾಖಲಾತಿ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ ಅಂತಿದೆ. ಅದನ್ನ ಹಾಜರುಪಡಿಸಿದ್ರೆ ಮುಗ್ದೋಗ್ತಿತ್ತು. ನೀವು ನಿಮ್ಗೆ ಕಳ್ಸ್ಕೊಂಡಿದ್ದೆ ಯಾಕೆ ಕಳ್ಸಿರಿ?
ವಾಟ್ಸ್ಆಪ್ ಚಾಟ್ ಕಳಿಸುವಂತ ಸಂದರ್ಭದಲ್ಲಿ ಬಂದು ಪ್ರಿಂಟ್ ಔಟ್ ನ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು. ದೇರ್ ಆರ್ ಸೆವರಲ್ ಕಮ್ಯುನಿಕೇಶನ್ ಬಿಟ್ವೀನ್ ದಿ ಅಕ್ಯೂಸ್ ಅಂಡ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲ್.
Even before the trial court also, I was ready.
Anyhow, you have received the amount of fees.
I was ready. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ನಾನು ಹೇಳಿದೆ ನಮ್ಮ ಸ್ನೇಹಿತರಿಗೆ,
ಈಗಲೂ ಕೊಡಿ,
ಕೊಡ್ತೀನಿ ಸರ್.
ಅದನ್ನೆಲ್ಲ ಅದ್ರ ಜೊತೆ ಕೊಡಿ. 2013ರಲ್ಲಿ ನೀವು ತಗೊಂಡ್ರ ದುಡ್ಡು ಅದು
ಅಷ್ಟೇ. ಟಿಲ್ ಟುಡೇ 1% ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಕೊಡಿ,
ಕೊಡ್ತೀರಿ ಹೇಳಿ. ಈಗ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ರಿಸೀಟ್ ಆಫ್ rupees of 24 lakhs.
ಅದನ್ನ ಇನ್ನೊಬ್ರಿಗೆ ನಾನು ಕೊಡ್ತೀನಿ. ಅದು ದಟ್ ವಾಸ್
ನೀವು ಇನ್ನೊಬ್ರಿಗೆ ಹಾಕೊಂಡಿದ್ರೆ ಅದಲ್ಲ. ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ವಾಸ್ ನಾಟ್ ಮೆಟೀರಿಯಲೈಸ್ಡ್. ಆ ಕತೆ ಹೇಳಂಗಿಲ್ಲ ಇಲ್ಲಿ. ದುಡ್ಡು ತಗೊಂಡಿದ್ರೆ ಕೊಡಿ ವಾಪಸ್ ಅಷ್ಟೇ.
ನಾನು ಕೇಳ್ಬಿಟ್ಟು ಇದ್ ಮಾಡ್ತೀನಿ. ಎನಿ ಟೈಮ್.
Next week. The petitioner counsel seeks time. List this matter on, put your date, put. Budwara,
ಆಯ್ತು ಸರ್.
28/3.
Twenty-five Passover 36. Rakshit Act.
Behalf of petition council, have it on Monday or date, have it on Monday, my lord. Behalf of petitioner council, my lord, is a native place, my lord.
ಇವತ್ತು ಒಳ್ಳೆ ದಿವಸ ಗುರುವಾರ ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
On behalf of petitioner council, my lord. I'm the proxy council. I'm the proxy council, my lord.
ಅವ್ರೆಲ್ಲ ಹೋದ್ರು?
ಇಲ್ಲ ಅವ್ರು have it.
ರಕ್ಷಿತ್ ಯಾರು ಎಲ್ಲ ಹೋದ್ರಿ?
Some personal inconvenience, my lord, he went to the native place, my lord.
Personal inconvenience is not the ground.
First time ಬರ್ತಾ ಇದೆ.
First time ಮಾತ್ರ
40% deposit
ಮಾಡಿದೀರಾ? ಮಾಡಿದಿರಿ?
ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು. Proxy counsel seeks time on behalf of the petitioner counsel and counsel for the respondent is present. List this matter on. Other date ಕೊಡಿ madam. 4/4. Please. Obliged.
37.
37 Shankar G.
Last
Yes,
occasion,
Nagaraj.
there was asked to whether it's complied or not. But the order, interim order, while granting interim order, your lordship directed me to deposit 50% of the amount. But there was a mistake. I am filing a memo. I will show what has happened.
Memo. Yen memo.
The
The
interim order was granted on 17/3
The sentence of the petitioner is complied or not.
within 4 weeks.
Huh?
Within 4 weeks. None of the 4 weeks comes as on 17/4/21/22. My lord, I asked him to get the DD. My lord, he brought the DD just 5 days. My lord, there was a delay. ಆ ಡಿ ಡಿ ಕೂಡ ಕಾಪಿ ಆಗ್ತದೆ ನನ್ನ ಹತ್ರ ಒರಿಜಿನಲ್ ಇದೆ ಸ್ವಾಮಿ. ಅದೇ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಅಲ್ಲಿ ಸ್ವಾಮಿ ಒಂದು ದಿನ ಲೇಟ್ ಆದ್ರೂ ಕಟ್ಟಿಸ್ಕೊಳ್ಳಲ್ಲ ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಇಟ್ ಹಸ್ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
ಆಯ್ತು 2022
ಅದು ನಮ್ಮ ಕಲಿಗೆ ಹೇಳಿದ್ರೆ ಕೆಪ್ಟ್ ದ ಫೈಲ್ ಇನ್ ದ ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಡಿ ಡಿ ಕೂಡ ಇದೆ ಸ್ವಾಮಿ. ಐ ವಾಟ್ ದ ಡಿ ಡಿ
ಯಾವಾಗ
ಲ್ಯಾಪ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಡಿ ಡಿ ತಗೊಂಡಿದ್ದೆ ಯಾವಾಗ?
ಅವಾಗಲೇ ಆ ಟೈಮ್ ನಲ್ಲಿ ಒಂದ್ 5 ದಿನ ಡಿಲೇ ಆಗಿತ್ತು.
ಅಕೌಂಟ್ ಮೇಲೆ ನೀವು ಟೈಮ್ ಲ್ಯಾಪ್ಸ್ ಆದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಪರ್ಮಿಷನ್ ತಗೋಬೇಕು.
ಅಲ್ಲೇ some mistake. ಅದಲ್ಲಿ ಮೈ ಕಲಿಗೆ kept the file in the usual course. ಅದು ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳೇ ಇಲ್ಲ.
The council submits that
ಅದು ರಿನ್ಯೂವಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕಟ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ ಇದನ್ನ.
Comply with the order passed by the court even though DD was taken. And though order was passed long back. ಯಾವಾಗ ಇದು 2022 on 17/3/22. 17/3 50% of the amount
35,000 already in first appellate court.
deposited.
I have to deposit 1,40,000. DD ಕೂಡ ಫೈಲ್ ಅಲ್ಲೇ ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಮಾಡಿಲ್ಲ ಅದು.
And hence the respondent is given liberty to proceed against the petitioner herein.
My lord.
ಏನು?
DD ತಗೊಂಡಿದ್ದೀವಿ, ಕಟ್ಟಿಲ್ಲ
DD ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದು?
ಅಲ್ಲ,
DD ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ.
ನಮ್ಗೆ ಒಂದು 3 days ಕೊಡಿ
DD
ಸ್ವಾಮಿ.
also lapse ಆಗಿದೆ.
ಅದು ಲ್ಯಾಬ್ ರಿನ್ಯೂವಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕಟ್ಬಿಡ್ತೀವಿ. ಒಂದು 3 days ಟೈಮ್ ಸ್ವಾಮಿ. Please my lord.
Liberty. ನೀವು proceed against him.
Please my lord, ಇದೆ. ಅಲ್ಲ ಬೈ ಮಿಸ್ಟೇಕ್ ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Next 38. ಇವೆಲ್ಲ ಡ್ರಾಮಾ ಬೇಡ.
ಇಲ್ಲ ಸ್ವಾಮಿ, DD ಇದೆ ಸ್ವಾಮಿ, ನನ್ನ ಹತ್ರ DD ತಗೊಂಡಿರೋದು.
ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದ್ರಿ?
ಅಲ್ಲ ಬೈ ಮಿಸ್ಟೇಕ್ ಆಫೀಸ್ ಅಲ್ಲಿ
ಮಾಡಕ್ಕಾಗಲ್ಲ. Why you have not sought for
ಅಲ್ಲ ರಿನ್ಯೂವಲ್ ಮಾಡ್ಬಿಟ್ಟು 2 days ಅಲ್ಲಿ ಕಟ್ತೀನಿ ಸ್ವಾಮಿ.
extension of time?
ಅಲ್ಲ 2 days ಅಲ್ಲ, ಫೈಲ್ ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ.
No, counsel. When you have not respected the order of the court,
ಅಲ್ಲ
why
ಸ್ವಾಮಿ,
court has
ಅಲ್ಲ
to-
DD ಇದೆ ಸ್ವಾಮಿ, ಬೈ
the
ಮಿಸ್ಟೇಕ್
court has to show lenience.
ಆಫೀಸ್ ಫೈಲ್ ವಾಸ್ ಕೆಪ್ಟ್, ಮೈ ಕಲೀಗ್ ಹಸ್ ಕೆಪ್ಟ್ ಆಫೀಸ್.
ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ. You are responsible.
ಅಲ್ಲ
for-
ರಿನ್ಯೂವಲ್ ಮಾಡ್ಬಿಟ್ಟು
You are
ಕಟ್ಬಿಡ್ತೀನಿ.
responsible for your client.
ಐ ಆಮ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಮೈ ಲಾರ್ಡ್, ಬೈ ಮಿಸ್ಟೇಕ್ ಇಟ್ ಹ್ಯಾಪನ್ ಮೈ ಲಾರ್ಡ್. I will deposit my renewal ಮಾಡಿಸ್ಬಿಟ್ಟು.
Next. 388. Prasad BS ಏನ್ರಿ settlement? ಹಿಂದೆ ಬನ್ನಿ, ಏನಾಯ್ತು settlement?
Your lordship, there is no settlement and there is also no compliance, your lordship.
No settlement. ಹೇಳಿ.
I already informed my counterpart because in trial court itself, my lord, they come for compromise. And till today, my party is not given money. That's the reason, my lord, 1 week.
Last time you took time.
Yes, my lord, I already informed. One last chance.
ಹೇಳ್ತಾರೆ ಏನು no settlement nothing ಅಂತ ಹೇಳಿ. ಹೇಳಿ.
Compliance ಆಗಿಲ್ಲ, your lordship. Settlement. Compliance ಆಗಿಲ್ಲ.
ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
Comply ಮಾಡಿಲ್ಲ.
ಕೊಡಿ ಆರ್ಡರ್. ಇಲ್ಲಿ ಬರೋದು ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು, ದುಡ್ಡು ಕೊಟ್ಟಂಗಿಲ್ಲ. This court wide order dated 31/3/23 suspended the sentence subject to depositing of 50% of the fine amount, which shall be inclusive of the amount, if any, already deposited by the petitioner. And counsel for the respondent submits that the said order has not been complied. And time is also given 4 weeks from the date of receipt of a certified copy of the order, until date not complied. The counsel appearing for the petitioner in the previous occasion took time for settlement. No progress in the matter. Hence, assuming the case in view of non-compliance of the order dated 31/3/23, the respondent is given liberty to proceed against the petitioner herein. List after 4 weeks. ನೀವು ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ.
39, Syed Umar.
451 application was rejected.
Yes, your lordship. Mobile phone, your lordship. Keeping in custody,
Order.
it will get restricted, your lordship, and it can be not be used in future, your lordship. Any conditions may be. It is a mobile phone, your lordship. Mobile phone, your lordship. They have seized the mobile phone. And keeping that for more time without unused, your lordship. Tomorrow it will, conditions will be, cannot be used for any more thing, your lordship. I have produced the purchase bill also, your lordship.
If you are sued for the commission of offence, if you are sued for the commission of offence, said mobile.
Committing the offense. ಏನ್ ನೀವು FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಿ ಅದರಲ್ಲಿ? ಮೊಬೈಲ್ ಸೀಸ್ ಮಾಡಿ ನೀವು ಇಟ್ಕೊಳ್ಳೋದಲ್ಲ. ಮೊಬೈಲ್ ಸೀಸ್ ಮಾಡಿದ್ಮೇಲೆ ಏನ್ ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಮೆಟೀರಿಯಲ್ ಅದರಲ್ಲಿ FSL ರಿಪೋರ್ಟ್ ತಗೊಂಡಿದ್ದೀರಿ?
Call details are collected from.
Petitioner has purchased the seized mobile from Purvika Mobiles Private Limited, but the seized mobile is involved to committing the crime. Hence, if release this mobile in favor of the petitioner, it is chances to destroy the evidence which are in seized mobile. If release seized mobile in favor of the petitioner, it is chance to sell, transfer and change the color.
Call
That's
details
why
are
answer
collected.
the point in negative.
Call details are collected. Call details are collected from.
Collect ಮಾಡಿದಿರಾ? That itself is enough. Why you are keeping the mobile? If any incriminating evidence, you can get the FSL report from the FSL ಎಲ್ಲ ಕಳಿಸಿ ತರ್ಸ್ಕೊಂಡಿದ್ದೀರಾ ರಿಪೋರ್ಟ್? ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಹತ್ರ? ಪ್ಲೇಸ್ ಮಾಡಿ ಅಷ್ಟೇ. Why you are keeping?
If you release the mobile, you may sell or change the color. You
I
may
will
sell.
undertake any conditions may be imposed, your lordship.
You may sell or change the color.
ಹಾಕ್ಬೋದ್ರಿ, ಅದು ಕಂಡೀಷನ್ ಹಾಕೋಣ, ನಾಟ್ ಟು ಸೆಲ್ ಅಂತ ಅಷ್ಟೇ. ನೋಡಿ,
Not to sell or
the
change.
petitioner counsel and also the counsel appearing for the state. Having heard the respective counsel, an application is filed under section 451 and 457 of CRPC seeking interim custody of Apple company iPhone mobile bearing number 900840899, which is seized by the Kumbalakode police in PF number 55 of 21. It is contended that seized mobile is required for his day-to-day purpose and he is the owner of said vehicle and he is only claimant of the above seized mobile and he is ready to obey any conditions that may be imposed by this court, even executing indemnity bond if mobile is released. On the other hand, it is a contention of the state that case is registered against the accused for the offences punishable under section 143, 147, 148, 427, 302, 307, 12, 201, 120B, read with section 149 of IPC. And if the mobile is seized, there is a chances of selling the same or changing the color of the seized mobile. ಯಾವಾಗ ಸೀಸ್ ಆಗಿದ್ರಿ ಇದು?
Your lordship.
The trial court having taken note of the seized mobile is involved in committing the crime and if it is released, there is a chances of selling the same. And hence rejected the application. Being agreed by the said order, present revision petition is filed before this court. The counsel appearing for the petition would submit that he is in need of mobile phone. ಅವನು accused.
Accused, one of the accused.
Accused number 15, your lordship.
He's provided money to the accused.
And petitioner is also produced bill of the iPhone phone to show that the same is purchased by him. And the same has not been released. Even investigation has been completed and charge sheet is also filed, howda?
Fine.
No need of custody of the mobile. Per contra, the counsel appearing for the state submits that if the same is released, there is chances of selling the mobile. And changing the color of the mobile also. Having heard the petitioner counsel and also the counsel appearing for the respondent, and police have also investigated the matter and filed the charge sheet. And the same was seized in 2021.
Okay, 15/6/2021.
2021. And even if any allegation is made against the petitioner that the same is used for committing the crime, and they cannot keep the mobile with them unless they get the report from the FSL. And even prosecution can rely upon the FSL report and also the call details of the petitioner. And no purpose will be served in keeping the same with the custody of the police. And also the article which is seized is also an I4. And hence, the very apprehension of the state is that there is a chances of selling the same and changing of the color. Some question of changing the color doesn't arise, and this court can impose the condition not to sell. And even not to change the nature of the color also. And hence, order to release the vehicle, mobile with a condition to execute in indemnity bond. Is to value history?
1 lakh rupees, sir.
1 lakh?
1 lakh rupees.
1 lakh. For an amount of rupees 1 lakh. With a condition not to change the color as well as not to sell the same. Accordingly, revision petition is allowed. Revision petition is disposed of. Next, Avinash Gowda GS 227. ಯಾರು ಇಲ್ವೇನ್ರಿ petitioner counsel? Last time here ಮಾಡಿದ್ವಲ್ಲ ಅದಲ್ಲ?
Last time,
Yeah, kindly pass over your.
discharge application dismissed, my lord, against that order, they filed this petition.
Who you want pass over counsel?
Senior counsel is.
Pass over.
Much of.
41. Pramod Chandra, Latif B.
For the petition. Yes, counsel. Last time I directed to produce some and ಹೇಳಿದ್ನಲ್ಲ?
They say that, my lord, they produced along with the charge sheet, a circular.
Circular and.
We have that fact, please, my lords. Now I'll go before the trial court, please, my lord, and urge I'll go before the trial court, please, my lords. I may be permitted to urge this ground, whether the circular produced before the court, my lord, can be acted upon or.
You want to withdraw this petition?
Not withdraw, please. No, my lord, may kindly see. No, I filed the discharge application. That has been dismissed.
Yes.
On the very same charge sheet, please, my lord, I was under the impression, and even the public prosecutor was also under the impression that the old charge sheet is filed. Now it appears, my lords, they have filed the circular in terms of, my lords, the order passed by this honorable court on an earlier occasion. In revision petition number 10007 of 2017. Where, please, my lords, this honorable court observed in para 7, page 37. Even if the contention of the revision petitioner is accepted by virtue of the circular issued by the government, the sanctioning authority who has already issued sanction order is perfectly valid. The same can be subject matter of fresh charge sheet or supplementary charge sheet. Now, my lord, now that it has become the subject matter of the supplementary charge sheet or the fresh charge sheet which is filed, I will urge the ground before the honorable court, please, my lords, I may be permitted to urge.
ಈಗ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ ಹೋಗಿ ಅರ್ಜಿ ಮಾಡಿ ಅಂತ.
ಅಲ್ಲ, ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರೆ ಅದು ಸೆಟ್ ಅಸೈಡ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ ಆರ್ಡರ್.
ಯಾವ ಸೆಟ್ ಅಸೈಡ್?
ಈಗ ಆರ್ಡರ್ ಡಿಸ್ಚಾರ್ಜಿಂಗ್ ದಿ ಆರ್ಡರ್
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಲ್ಲ ಅದು.
ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಆನ್ ದಿ ವೆರಿ ಸೇಮ್ ಗ್ರೌಂಡ್, ಪ್ಲೀಸ್, ಮೇಡಮ್, ಆನ್ ದಿ ವೆರಿ ಸೇಮ್ ಚಾರ್ಜ್ ಶೀಟ್
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಹೌದು, ನಾನು ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡೆ ಸ್ವಾಮಿ, ಬಿಕಾಸ್ ಆನ್ ದಿ ವೆರಿ ಸೇಮ್ ಚಾರ್ಜ್ ಶೀಟ್ now I was being prosecuted ಅಂತ, because this material was not produced, it was not brought to the notice of the court. There is, madam, kindly see, in the order that was passed, there is no reference to the circular. ನಾನು ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಅದು ಸ್ಥಳದಿಂದ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಸಿಗ್ಲಿಲ್ಲ ನನಗೆ.
ನಿಮ್ಮ ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಹಾಕಿದಿರೇನ್ರಿ ಅದು?
ಹಾಕಿದ್ರೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್
ಹಾಕಿದಿರಿ?
ಅದು ಏನಂತ ಸ್ವಾಮಿ ಸರ್,
Please, that is the additional
Not
documents.
brought
you
to
have
the
to-
notice of the.
Now additional charge sheet or ಹಾಕಿದ್ದಾರೆ
Correct,
supplementary
sir.
charge
Now,
sheet.
additional charge sheet ಅಲ್ಲಿ ಇದು ಒಂದೇ material extra ಇರೋದು, sir.
ಒಂದೇ?
ಇದು ಒಂದೇ material extra ಇರೋದು.
ಹಾ.
So,
The
based on
issue
this,
is-
please, my lord, now the charge sheet is filed.
Now is the small issue, my lord, whether while considering the discharge application, this material was considered or not. Lord, now the matter is remitted back to the trial court by this honorable court. It's the matter of trial, my lord, it has to authenticity of those documents, whether he is having a competent authority or not, has to be decided in the trial, not in the discharge application. That is my, his contention is saying that, once again, those documents has to be considered while discharging considering the application for discharge.
Let me kindly see the first revision petition which was filed, which is this honorable court.
Yes.
Liberty was given to the prosecution to file supplementary charge sheet.
ಈಗ ಮಾಡಿದ್ದಾರೆ
Which they have done, please, brothers, which they have done, along with the charge
whether
sheet.
that the sanction is valid or not, subject to the notification. ಅವ್ರ ಪ್ರಕಾರ ನೋಟಿಫಿಕೇಶನ್ ಒಂದು ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದಾರಲ್ಲ,
Produce.
in terms of that notification, ಆವಾಗ ನೀವು you have to face the trial only.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಆ ಒಂದು ಏನು ಸ್ಯಾಂಕ್ಷನ್ ಇತ್ತು, ಅರ್ಲಿಯರ್ ಸ್ಯಾಂಕ್ಷನ್ which was set aside by the London trial judge.
ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತ್ರಿ, ಅದನ್ನೇ ಈಗ
Discharge.
ಮತ್ತೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರಲ್ಲ,
Consider ಮಾಡಿ set aside ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಆರ್ಡರ್ set aside ಮಾಡಿಲ್ಲ.
ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿಲ್ಲ.
This court has not said, that is the reason, please, my lords, I submitted.
Necessary to word the use as set aside. And an
I'm
observation
sorry,
is
please, my lord.
made
I'm sorry, please, my lords.
in paragraph.
That was not the observation.
Paragraph number 7.
That is the exact contention, please, my lord. If the interpretation of this section 7,
Intention of the revision petitioner is accepted by virtue of the circular issued by the government, the sanctioning authority who has already issued sanction order is perfectly valid.
no, it is not, the court is not saying, my lord, that this.
The same can be subject matter of fresh charge sheet or supplementary charge sheet antide.
My lord, this is the exact reason, please, my lord. I pray this honorable court be pleased to, my lords, remit the matter before the same, and my lord took the exception for this particular my submission. My lord may kindly see what sections of these para 7 says is, even if the contention of the learned revision petitioner that the circular issued by the government is perfectly valid.
ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಬಗ್ಗೆ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರ ಇಲ್ಲ?
ಯಾವ್ದು ಸ್ವಾಮಿ?
ಈಗ ಇಂಪ್ಯೂಂಡ್
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. That is the reason, please, my lord, I submitted that let this order be set aside.
Let them file one more application and consider it. Just
Please, my lord.
if government notification is not considered by the trial court while passing the order, let the trial court decide it. That's all.
Still it is a matter of,
discharge application. ಅಷ್ಟೇ.
still it is matter of trial, my lord, it is to consider.
ಅವರು ಇದೇನು ಕಂಟೆನ್ಷನ್ ಏನ್ on the ground that no valid sanction ಅಂತ ಮತ್ತೆ earlier court comes to a conclusion that no sanction ಅಂತ. Now you are relying upon the government
Some circular.
notification. That the court decide the issue in discharge application itself.
Please, my lord.
Notification ಇದೆ, notification ಇರೋದ್ರಿಂದ that is whether it is a sanction is correct or not ಅಂತ ಮಾಡ್ಲಿ ಇವಾಗ ಅಷ್ಟೇ.
That is exactly my submission.
Ground ಅಷ್ಟೇ.
Please.
Please, my lord.
Heard the revision petitioner counsel and also the counsel appearing for the state. This revision petition is filed challenging the rejection of application filed by the revision petitioner ನೀವು ಡಿಸ್ಚಾರ್ಜ್ ಕೇಳಿದಿರಾ?
ಹೌದು ಸರ್.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ರೆಫರೆನ್ಸ್?
45.
45.
Section 45.
ಬೇರೆ ಆರ್ಡರ್
Application ಹಾಕಿದ್ದು.
Mediation.
45.
ಇದು ಕಾಗ್ನಿಷನ್ಸ್ ತಗೊಂಡ್ರ ಆರ್ಡರ್ ರೀ, ಡಿಸ್ಚಾರ್ಜ್ ಅಲ್ಲ. ಎಲ್ಲಿದೆ
ಸ್ವಾಮಿ?
ನಿಮ್ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಯಾವ್ದು?
ಅಲ್ಲ, ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ annexure A.
Annexure A, my lord.
Annexure A, page 22 is the operative portion of the order. It starts from page 17.
43 ಅಂತಾರೆ.
Sorry?
Annexure A, not page 43.
ಅಲ್ಲ, 43 ಬೇರೆ ಸರ್. 43 ಬಂದು
section of application filed under section 227 of CRPC.
No, 43 was
The trial court for discharge.
ಹೌದು. ಅಲ್ಲ 43 earlier order sir.
Earlier order, ಆಯ್ತು.
ಹೌದು. ಇದು
Discharge in
section-
respect of the offences punishment of section 7, 13(1)(a), read with section 13(2) of the Prevention of Corruption Act 1988.
17, page number 17 make kindly.
The
Implementing
trial
order is page 17 sir.
The trial court having taken note of the grounds which have been urged in the application and also the oral submission made by learned counsel for the Lokayukta, taken note of earlier order passed by the trial court as well as the order passed by this court in criminal revision petition number 1007 of 2017. And held that the said sanction order to be perfectly valid and can be subject matter to the charge sheet or supplementary charge sheet directed to be filed by the investigating agency. Thus, the question of insisting the investigating agency by this court to obtain the fresh sanction order would not arise. It is also observed that accused is not disputing the correctness or otherwise of the charge sheet. Rather, his grievance is that the prosecution sanction order is defective in nature. This type of contention is beyond the observations made by this court on the one hand and misleading the court on the other hand, and hence rejected the same. Being agreed by the said order, the present revision petition is filed before this court. During the course of argument, this court had noticed that when the court has already considered the issue in revision petition number 1007 of 2017 and in paragraph number 7 made an observation that even if the contention of the revision petitioner is accepted by virtue of the circular issued by the government, the sanctioning authority who has already issued sanction order is perfectly valid, comma, the same can be subject matter of fresh charge sheet or supplementary charge sheet and disposed of the revision petition by giving a liberty for the Lokayukta to file fresh supplementary charge sheet. After the disposal of this revision petition, the respondent have filed the fresh charge sheet along with
Circular.
circular notification, ಏನದು?
Circulars.
Notification.
Along with
notification.
ಯಾವ್ದದು? ಡೇಟ್ ಯಾವಾಗಂದ್ರಿ?
8/1/2004.
8/1/2004.
8/12?
8/1/2004.
Eight 2000?
4 ಮೂಲಡ್. Circular dated 8/1/2004.
8/1 ಇರ್ಬೇಕು ಅದ?
ಹೌದು. 8/1.
8/1/2004.
ಅದು ಸರ್ಕ್ಯುಲರ್ ಅದು ತಪ್ಪಾಗಿದೆ.
Notification.
ಅಧಿಸೂಚನೆ ನೋಟಿಫಿಕೇಶನ್.
Notification.
ಸುತ್ತೋಲೆ ಅಂದ್ರೆ ಸರ್ಕ್ಯುಲರ್ ಬರುತ್ತೆ.
ಅಧಿಸೂಚನೆ ನೋಟಿಫಿಕೇಶನ್.
ನೋಟಿಫಿಕೇಶನ್.
And this court earlier occasion wanted to know whether that notification is filed along with charge sheet or not. And now the counsel appearing for the Lokayukta submits that charge sheet is filed along with the said notification. And on perusal of the notification and also the very contention of the special Lokayukta plus special counsel is that in view of the said notification sanction is valid. This court also made an observation in the earlier revision petition And after filing of the supplementary charge sheet, fresh or oblique supplementary charge sheet before the trial court, an application is filed for discharge. And the trial court, while considering the discharge application, not considered the said notification, only an observation is made in paragraph number nine that. But while deciding the criminal revision petition number 1007 of 2017, this court has upheld the said sanction order to be perfectly valid and can be subject matter to the charge sheet or supplementary charge sheet directed to be filed by the investigating agency. Only taken note of the observations made by this court, but not discussed anything about in view of the said notification of the sanction order is valid. And the very contention of the applicant before the trial court that the trial court has committed an error in dismissing the application only on the ground that this court has already made an observation and passed an order. And having taken note of the order passed by this court as well as the order passed by the trial court, and when the no discussion was made by the trial court, when the fresh oblique supplementary charge sheet has been filed along with notification, and the contention of the special public prosecutor, learned prosecutor for the Lokaयुक्त also that charge sheet is filed along with the said notification. And the same can be said, and the said ground can be urged before the trial court by filing a fresh application, and hence the order impugned is set aside and liberty is given to the revision petitioner to approach the trial court with a fresh application.
Please, much.
The trial court is directed to consider the fresh application in view of the observations made by this court.
42. It's Ramachandra.
Inventory, order sheet ಕೊಡಿ. Comply ಮಾಡಿದಾರ earlier order ಏನಾರು?
No, they have not complied.
Huh?
Not complied.
Records ಬಂದಿದೆಯಾ ಮೇಡಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್?
ಬಂದಿದೆ.
ದುಡ್ಡು ಏನಾರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಕ್ಕೆ ಏನಾರು ಇದೆಯಾ ನೋಡಿ? ಆರ್ಡರ್ ಆಗಿರೋದೇ 21-24 ಅಲ್ಲಿ.
Please. 20th on 2024.
4 weeks.
6 week.
6 weeks ಆಗಿದ್ದು ಯಾವಾಗ?
20th on 2024. February complete.
ರೆಕಾರ್ಡ್ಸ್ ಈಗ ಬಂದಿರೋದಲ್ಲ ಮೇಡಮ್?
ಹೌದು ಸರ್.
Any endorsement? 21ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು. ಆಮೇಲೆ ದುಡ್ಡು ಕೊಟ್ಟಿದಾರ ಅಂತ ಕೇಳಿದೆ. 23ನಲ್ಲಿ ಮಾಡಿರೋದು ಇದು ಮಾಡಿಲ್ಲ, ಕಟ್ಟಿಲ್ಲ. ನೋಡಿ. The counsel appearing for the respondent submits that in terms of the order dated 21-24, the amount has not been deposited within 6 weeks. That is 40% of the amount.
40%.
And on perusal of the lower court records also, there is no any endorsement for having made the deposit. in terms of the order. And counsel for the petitioner is also absent, and hence, in view of non-compliance of the order, the respondent is given liberty to proceed against the petitioner. This is the matter after 4 weeks.
43, K. Subbareddy.
Yeah, for the petitioner, my lords, a request for a short accommodation.
Counsel last time also press time.
Lords, senior counsel wanted to appear in this matter. Some inconvenience, my lords.
ಎಷ್ಟನೇ ಸರಿ ಲಿಸ್ಟ್ ಆಗಿರೋದು?
Second time, lords. Last
Second
time.
Petitioner counsel again seeks time, and also in the earlier date of hearing also sought time, and hence list after 4 weeks.
44,
ಅದು petition. ಹಾಸ್ಪಿಟಲ್ಗೆ ಏನೋ ಚೆಕಪ್ ಹೋಗಿದಾರಂತೆ ಮಿಸ್ಟರ್ ತಿಗಡಿ. 1 week ಟೈಮ್ ಕೇಳಿದಾರೆ ಸರ್.
ಓನ್ಲಿ ರಿಮೈಂಡ್ ಮಾಡೋದು ಅಷ್ಟೇನೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ HBC ನಾಟ್ ನಿಲ್ ಅಂತ ಏನೋ ಮಾಡಿದ್ದಾರೆ, ನೋಡಿದ್ರೇನ್ರಿ? ಕೊಡಿ. Heard the petitioner counsel and also the counsel appearing for the state. And main contention of the counsel appearing for the petitioner that the trial court has not heard the matter. Even though case is set down for hearing before charge. The counsel also brought to notice of this court the order sheet dated 7/12/23, wherein the trial court made an observation that hearing before charge taken as nil and posted the matter for framing of charge. And thereafter on the very next day on 10/1/24, when the accused number 1 to 4 are present, matter was kept by for framing charge. And when the matter again taken for framing of charge, accused number 2 to 4 are present, accused number 1 was absent and EP was filed. And the same was rejected. And trial court framed the charge against accused number 2 to 4. And the accused persons did not plead any guilty and claims to be tried. And also issued NBW to accused number 1 for framing charge and posted the matter to 3/2/24. The main contention of the revision petitioner before this court that when the charge sheet is filed for the offence punishable 408, 420, 504, 506, read with section 34 of IPC. And when the case is also set down for HBC, and trial court has proceeded to record that hearing before charge is nil and not heard the matter and passed any order whether there is material to frame charge or not. And counsel appearing for the state also not dispute the said fact, and even having considered the order sheet also, the trial court mentioned that hearing before charge has taken nil. And trial court ought to have heard the respective counsel and considered the matter whether there is a material to frame the charge. No such order has been passed. And instead of, without hearing the respective counsel, proceeded to frame the charge. And hence, very framing of charge without hearing the respective counsel requires to be set aside. It is also noticed by this court that in all the dates of hearings, these petitioners have not regularly appearing before the trial court. And one or the other reasons, accused persons are filing an application for exemption And even when the case was posted for charge also, accused number 1 to 4 are present. And at the time of framing the charge, the accused number 1 was absent and trial court has issued the NBW. And court has to take note of conduct of the revision petitioners. And even though the matter of the year 2022 and not assisting the court in framing the charge, and instead of coming before this court on technicalities, and hence it is appropriate to order for, it is appropriate to give a direction to the petitioners not to seek any exemptions before the trial court without any genuine cause.
Please.
That is only in medical ground. And the very conduct of the accused persons is also deprecated. In view of the discussions made up, I pass the following order. The revision petition is allowed. The order of proceeding to frame the charge with order dated 7/12/23 is set aside. And trial court is directed to hear both the counsels and pass an appropriate order to proceed against the accused persons. The petitioners are directed be present before the trial court. And also the counsel for the accused is directed to assist the trial court in hearing before the charge. And so also the learned public prosecutor in a state of hearing. The charge framed without hearing before charge dated 10/1/24 against accused number 2 to 4 is also set aside, and trial court if found material, then proceed in accordance with law.
Please.
45. B.S. Prasad.
Petition number 138% murder, suspension of sentence murder. Suspension of sentence murder. So check amount is 15 lakh. The fine amount is 20 lakh murder. The check was admitted and signature admitted. That is only ground murder. The trial court come to consider that murder. The accused convicted the accused murder. I told you exhibit D1 is the exhibit D1. Diary was marked murder. The as per exhibit D1 murder is 67,500 rupees murder.
Right, Madam Tole, 50% of the fine amount ಅಂತ ಮಾಡಿ ಚೆಕ್ ಅಮೌಂಟ್ ಅಲ್ಲ ಫೈನ್ ಅಮೌಂಟ್ ಅಂತ ಮಾಡಿ suspended with 2 lakh rupees with 2 sureties.
46. R.K. Mahadeva.
36 murder. Arguing counsel was hospitalized murder. Next week.
Told. Proxy counsel seeks time on the ground that arguing counsel is hospitalized and hence list after 4 weeks.
47.
Manjunatha V.
138 proceedings. Check amount 2 ಲಕ್ಷ ಸಮಯ 2 ಲಕ್ಷ
2,10,000 ಮಾಡಿದ್ದಾರೆ.
2,10,000
ಡಿಫೆನ್ಸ್ ಏನು?
ನಮ್ ಡಿಫೆನ್ಸ್ ಬಂದ್ಬಿಟ್ಟು ಚೆಕ್ ಅನ್ನ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಗೆ ಕೊಟ್ಟಿಲ್ಲ. ನಾವು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಇದ್ವಿ, ಒಂದೇ ಮನೆಯಲ್ಲಿ ಬೇರೆ ಬೇರೆ ವಾಸ ಇದ್ವಿ. ಆ ಚೆಕ್ ಮತ್ತೆ ಕೆಲವು ಇಂಪಾರ್ಟೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನ ಮನೆಯಲ್ಲಿ ಜೋಪಾನ ಪಡಿಸೋದಕ್ಕೆ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಆರೋಪಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಂತ ಸುಧಾಕರ್ ಅವ್ರ ಅಂಗಡಿಯಲ್ಲಿ ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನ ಇಟ್ಟಿದ್ರು. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಚೆಕ್ ಅನ್ನ ಮಿಸ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಕಂಪ್ಲೇಂಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಈ ಕೇಸ್ ಹಾಕ್ಸಿದ್ದಾರೆ ಅಂತ ಸೊನ್ನೆ. ಅದನ್ನ ಸುಧಾಕರ್ ಅವ್ರ ಅಂಗಡಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಿದ್ದನ್ನ ಆ ಚೆಕ್ ದುರುಪಯೋಗ ಸುಧಾಕರ್ ಅವರೇ ಮಾಡ್ಕೊಂತಾ ಇದ್ರು ಅನ್ನೋ ವಿಚಾರವನ್ನ ಈ ಕಂಪ್ಲೇಂಟ್ ಕೌನ್ಸಿಲ್ ಅಡ್ಮಿಷನ್ ಮಾಡ್ಕೊಂತಾರೆ ಸೊನ್ನೆ.
ಇಡಕ್ಕಾಗ್ಲಿಲ್ಲ, ತಗೊಂಡೋಗಿ ಬೇರೆಯವ್ರ ಅಂಗಡಿಲಿ ಇಟ್ರಿ ಅಂತ.
ಅಂಗಡಿಯಲ್ಲಿ ಇಟ್ಟಿದ್ವಿ, ಅದನ್ನ ಮಿಸ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ. ಮತ್ತೆ ಇನ್ನೊಂದು ಚೆಕ್ ಮೇಲೆ ಇರ್ತಕ್ಕಂಥ ಸಿಗ್ನೇಚರ್ ನಮ್ದೇ ಅಲ್ಲ.
Suspended 50%, 50,000 with 1 surety.
50%, 25% ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ ಸೊನ್ನೆ ಅಪೀಲ್ ಕೋರ್ಟ್.
ಅದನ್ನು ಕಳೆದೇನೆ. Next, 48.
Parted in hearing, 48.
ಏನ ಕಾಸ್ಟ್ ಬೇರೆ ಇದ್ದಂಗಿದೆ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ನಿಮ್ದಲ್ಲ? ಸರಿ ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ನಿಮ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ವಾ?
ನಂದಾಗಿದೆ ಅದರ್ ಸೈಡ್ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೆಸರೇನೋ ಸರಿ ಇಲ್ವೋ ನೋಡ್ಕೊಂಡು ಇದ್ ಮಾಡಿದ್ರೆ ಅದನ್ನೇನು ಮೋಸ್ಟ್ಲಿ ಕರೆಕ್ಷನ್ ಆಗಿದೆ.
ಹೆಸರೇನೋ ಸರಿ ಇರ್ಲಿಲ್ಲ ಅಂತಲೇನೋ ಮಾಡಿದ್ವಲ್ಲ ಇದ?
ಹೌದೌದು.
SH ಇತ್ತು ಅಂತ ಬಂದಿಲ್ವ ಈಗ? ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ ನೋಡು. R1 to R5 RV ಜಯಪ್ರಕಾಶ್ ಫಾರ್ R6 ಅವ್ರದ್ದು ಆಗಿದೆ ಅಲ್ಲ?
ಹೌದಾಗಿದೆ.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ತಗೊಂಡು ರಿಸರ್ವ್ ಮಾಡ್ಕೋತೀವಿ.
49 adjourn 50 ಶಿವಶಂಕರ್ K.
It's appeal for the petitioner. That's 279. 337. That's 134 AB. Read with section 184. Motor Vehicles MV Act. That's the trial court has convicted the accused. But for 279, ₹1 fine and that's in default imprisonment for 1 month. That's for 337, ₹500 in default 10 days imprisonment. 134 A and B, that's ₹500. And in default, that's 10 days.
ಯಾವ್ದು imprisonment ಇಲ್ಲ.
Imprisonment. In case they fail to pay the amount, that's undergo
Here
simple
evidence.
imprisonment for 1 month, 10 days and 10 days.
ಒಟ್ಟಿಗೆ ಫೈನ್ 1,000, 1,500,
1,500,
2,000. ಅದಕ್ಕೊಂದು ರಿವಿಷನ್.
That's actually, it's a government BTS KSRTC driver. That's the only on the basis of evidence of PW1 and PW2, that's the convicted the accused. Exhibit P3, it is very important. The sketch minutes indicates how the bus came from and entered into the depot and how these people, PW1 and PW2, came in a rash and negligent minutes in a two-wheeler. At early morning, 3 AM minutes.
Sketch ಕೊಡಿ ಮೇಡಮ್.
Exhibit P3. Trial court has considered only the evidence of PW1 and 2. Pillion rider is driving the vehicle at morning 3 AM.
Kinetic Honda.
Kinetic Honda. That's morning at 3 PM. They are doing wheeling two-wheelers. They came in a rash and negligent manner. Bus and KSRTC bus, they came and just take the right turn side to enter into the bus depot. Immediately they came and sit the bus and now they sustained injuries. Doctor certificate, they issued exhibit P4 and P5, simple injuries. All the injuries sustained by these PW1 and PW2 are simple injuries. But the trial court has convicted the accused that he came.
While taking the right turn, is it not the duty of the driver of the bus to observe the vehicle, whether any vehicles are moving or not?
Yes, observed, because there is a turning. At the morning 3 ಗಂಟೆ ಬೆಳಗಿನ ಜಾವದಲ್ಲಿ. He came and just he has take the right turn to enter into the depot.
ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದಾನಾ?
ಮಾಡಿದ್ದಾರೆ.
ಈಗೇನ ನೀವು ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನ ಎಕ್ಸಾಮ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾನಾ? ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾನಾ?
ಮಾಡಿದ್ದಾನೆ.
ಎಲ್ಲಿದೆ ಎವಿಡೆನ್ಸ್? ಎಲ್ಲಿದೆ?
PW1 and PW2.
PW1 ಅಲ್ರಿ, DW1. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದಾನ ಅಂದ?
ಇಲ್ಲ, ಅದೇನ್ ಮಾಡಿಲ್ಲ.
ಹೇಳಿದ್ರಿ ವೀಲಿಂಗ್ ಏನೇನೋ ಕತೆ ಹೇಳಿದ್ರ.
ಅಲ್ಲ, ಅವರು ರ್ಯಾಶ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ.
ವೀಲಿಂಗ್ ಬಗ್ಗೆ ಯಾರು ಹೇಳ್ಬೇಕು?
ಆಕ್ಚುಲಿ ಇವ್ರು ಹೇಳ್ಬೇಕು. ಇವರು ಏನು ಹೇಳಿಲ್ಲ, ಬಂದಿದ್ದಾರೆ ಮಾರ್ನಿಂಗ್ ಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ ಡಿಪೋ ಒಳಗಡೆ ಹೋಗೋದಕ್ಕೆ. ಇವರು ಆ ಕಡೆಯಿಂದ ಫಾಸ್ಟ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ, ಇದ್ ಮಾಡಿದ್ದಾರೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಲೇಟ್ ಅಪ್ ಆನ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW1 and 2.
1 and 2 ಅಷ್ಟೇ. ಬೇರೆ ಯಾರು ದೇ ಆರ್ ಆಲ್ ಹಾಸ್ಟೈಲ್ ವಿಟ್.
ಹೇಳ್ಬೇಕು, ಬೇರೆಯವ್ರು ಯಾರು ಹೇಳ್ತಾರೆ? ಅವರೇನೆ
ಅವರು ಇಂಟೆನ್ಷನಲಿ ಮೆಲಟ್ಸ್ ದೇ ಹ್ಯಾವ್ ಡಿಪೋಸ್ ಕೈಂಡ್ಲಿ ಮೆಲಟ್ ಎಕ್ಸಿಬಿಟ್
ಚಲಾಯಿಸುತ್ತಿದ್ದು. ನಾನು ಹಿಂಬದಿಯ ಸವಾರನಾಗಿದ್ದೇನೆ. ಮಿಲೇನಿಯಂ ಸರ್ಕಲ್ ಹೈವೇ ಸರ್ಕಲ್ ಕಡೆಗೆ ನಮ್ಮ ವಿರುದ್ಧ ದಿಕ್ಕಿಗೆ ಒಂದು KSRTC ಬಸ್ ಅನ್ನು ಡಿಪೋ ಒಳಗಡೆ ಹೋಗುವ ಸಲುವಾಗಿ ಬಲಗಡೆ ತಿರುಗಿಸಿದ್ದು ನಮ್ಮ ವಾಹನಕ್ಕೆ ಡಿಕ್ಕಿಪಡಿಸಿತ್ತು. ಕೂಡಲೇ ನಾವಿಬ್ಬರು ವಾಹನ ಸಮೇತ ರಸ್ತೆಗೆ ಬಿದ್ದಿರುತ್ತೇವೆ.
ಕೆಳಗೆ ಬಿದ್ದು
ನನ್ನ ಬೆನ್ನಿನ ಕೆಳಭಾಗ ಕಾಲಿಗೆ ಏಟಾಗಿತ್ತು. ನನ್ನ ಸ್ನೇಹಿತನ ಕೈಗೆ ಮತ್ತು ತಲೆ ಗಾಯವಾಗಿತ್ತು. ನಮ್ಮ ಸಾರ್ವಜನಿಕ
ಚಾಲಕನಾಗಿದ್ದ ಆತನ ಗುರುತಿಸಿದ
ಆರೋಪಿ ಸರಿ ಬಸ್ ಅನ್ನು ಬಂದ ಅದೇ ವೇಗದಲ್ಲಿ ಗಮನಿಸದೆ
ಬಲಗಡೆಗೆ
ತಿರುವು ಕಾರಣ ಆತನ ತಪ್ಪಿನಿಂದ ಅಪಘಾತವಾಗಿರುತ್ತದೆ. ನಿಮ್ಮ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನೇಳಿ ಸಿಟ್ ಮಾಡಿಸಿರಿ ಹೇಳಿ.
ನೆಕ್ಸ್ಟ್ ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ನಾನು ಸದರಿ ಚಾಸ 2ರವರ ಜೊತೆ ಅಂಗಡಿ ವ್ಯವಹಾರ ಮುಗಿಸಿ ಬರುತ್ತಿದ್ದೇನೆ. ಚಾಸ ಎರಡರವರು ಎಷ್ಟು ಅಂಗಡಿ ಮುಚ್ಚಿರ್ತಾರೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿರೋದಿಲ್ಲ. ಚಾಸ ಎರಡರವರು ಸೂಪರ್ ಮಾರ್ಕೆಟ್ ಇರುತ್ತೆ. ಸದರಿ ವ್ಯವಹಾರ ರಾತ್ರಿ 10 ಗಂಟೆ
ಆಕ್ಸಿಡೆಂಟ್
ಮಾರ್ನಿಂಗ್ 3 AM 3 ಗಂಟೆ ಬೆಳಗಿನ ಜಾವ 3 ಗಂಟೆನಲ್ಲಿ.
ಇವನೇನ್ ಚಾಸ 2 ಹಚ್ಚದ ಅಂಗಡಿ
ಅವರು 10 ಗಂಟೆಗೆ ಕ್ಲೋಸ್ ಅವ್ರ ಅಂಗಡಿ. ಸೊ ಬೆಳಗಿನ 3 ಗಂಟೆಗೆ ಏನಕ್ಕೆ ಮಾಡ್ತಿದ್ರು ಅನ್ನೋದಕ್ಕೆ ಅದಕ್ಕೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇಲ್ಲ. 10 ಗಂಟೆಗೆ ಅಂಗಡಿ ಕ್ಲೋಸ್, ರಾತ್ರಿ 10 ಗಂಟೆಗೆ ಮುಗಿಯುತ್ತದೆ ಅಂದ್ರೆ ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ.
ಏಜ್ ಎಷ್ಟು ಹೇಳಿ?
ಎಲ್ಲ ಮಲಡದಿ 36 years and 36 years.
36 years ಅಲ್ಲಿ ಏನು ವೀಲಿಂಗ್ ಮಾಡ್ತಾನೆ?
36 39. 3 ಗಂಟೆ ಜಾವದಲ್ಲಿ ಅಷ್ಟೊತ್ತಲ್ಲಿ ಬಿಸ್ನೆಸ್ ಇಲ್ಲ, ಬೇರೆ ಕೆಲಸನೂ ಇಲ್ಲ. ಸೊ ದೇ ಕೇಮ್ ಇನ್ ಅದರ್ ಟು ಪಿಲ್ಲನ್ ರೈಡರ್ ಈಸ್ ಫ್ರೆಂಡ್ ಈಸ್ ಡ್ರೈವಿಂಗ್ ದಿ ವೆಹಿಕಲ್, ದಿ 2-wheeler. ನೆಲ್ಸನ್ ಮಂಡೇಲ ರಸ್ತೆಯ ಮಧ್ಯದಲ್ಲಿ ಬಿಳಿ ಪಟ್ಟೆ ಹಾಕಲಾಗಿದೆ ಎಂದರೆ ನಿಜ. ನಮ್ಮ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ನಾವು ಚಾಲನೆ ಮಾಡಬೇಕು ಎಂದರೆ ನಿಜ. ಎದುರುಗಡೆಯಿಂದ ಬರುವ ವಾಹನಗಳು ನಮ್ಮ ಬಲಭಾಗದಲ್ಲಿ ಹೋಗಬೇಕು ಎಂದರೆ ನಿಜ. ಡಿಪೋದಲ್ಲಿ ಹೋಗಲು ಮತ್ತು ಬರಲು ಬೇರೆ ಬೇರೆ ಗೇಟುಗಳಿವೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. ಬಸ್ ಗೇಟ್ ಬಳಿ ನಿಂತು ಒಳಗಡೆ ತಿರುವು ತೆಗೆದುಕೊಳ್ಳಬೇಕು ಎಂದರೆ ಸಾಕ್ಷಿಯು ಸದರಿ ದಿನ ಬಸ್ಸು ನಿಲ್ಲಿಸದೆ ಬಂದಿರುತ್ತಾರೆ ಎಂದು ಉತ್ತರಿಸಿರುತ್ತಾರೆ. ನಾವು ಹೋಗುತ್ತಿದ್ದ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಗೇಟು ಇತ್ತು ಎಂದರೆ ನಿಜ. ಅಲ್ಲಿ ಕೂಡ ಗೇಟ್ ಇತ್ತು. ಬಿಕಾಸ್ ಅಲ್ಲಿ ಗೇಟ್ ಇತ್ತು. ಈ ಕಡೆಯಿಂದ ಬಂದು ಬಸ್ ಟರ್ನ್ ಆಗಿ
ಡಿಪೋ ಗೇಟ್ ಇತ್ತು ಅಷ್ಟೇ.
ಹೌದು.
ಎಡಭಾಗದಲ್ಲಿ.
ಸಾಮಾನ್ಯವಾಗಿ ಸದರಿ ಗೇಟ್ಗೆ ಹೋಗಬೇಕಾದರೆ ರಸ್ತೆಯಲ್ಲಿ ನಿಂತೇ ಹೋಗಬೇಕಾಗುತ್ತದೆ ಎಂದರೆ ನಿಜ. ನಾನು ನೋಡಿದ ತಕ್ಷಣವೇ ಬಸ್ ಕೂಡಲೇ ಬಂದು ತಿರುವು ತೆಗೆದುಕೊಂಡು ಡಿಕ್ಕಿ ಪಡಿಸಿರುತ್ತದೆ. ನಾನು ಬಸ್ಸನ್ನು ತಿರುಗಿ ತೆಗೆದುಕೊಳ್ಳುವಾಗ ನೋಡಿರುತ್ತೇನೆ. ನಾನು ಸುಮಾರು 4 ಅಡಿ ಅಂತರದಿಂದ ಬಸ್ಸನ್ನು ನೋಡಿದ್ದೇನೆ. ಎಷ್ಟು ಜನ ಸಾರ್ವಜನಿಕರು ಸೇರಿದ್ದರು ಎಂದು ನಾನು ನೋಡಿರಲಿಲ್ಲ. ಆಗ ಕತ್ತಲೆ ಇತ್ತು. ನಮ್ಮ ವಾಹನದ ಬಲಬದಿಗೆ ಬಸ್ಸು ಡಿಕ್ಕಿ ಹೊಡೆದಿರುತ್ತದೆ. ವಾಹನದ ಬಲಬದಿಗೆ ಜಖಮ್ ಆಗಿರುತ್ತದೆ. ಚಾಸ ಎರಡರವರೆಗೆ ಅನುಕೂಲವಾಗಲೆಂದು ನಾನು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಅನಿಸಿದೆ. ಬಸ್ಸು ನಾನು ಹೇಳುವಂತೆ ಅಪಘಾತ ಪಡಿಸಿರಲಿಲ್ಲವೆಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತ ಪಡಿಸಿದಾಗ
ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
ಅಷ್ಟೇ.
PW2
ಈಸ್ ದಿ ಡ್ರೈವರ್ ಸೇರಿದ PW1 ಪ್ರಾಸ 1ರವರಿಗೆ ಸೇರಿದ ಕೈನೆಟಿಕ್ ಹೊಂಡದಲ್ಲಿ ಹೈವೇ ಸರ್ಕಲ್ ನಿಂದ ಬನ್ನಿ ಮಂಟಪ ನೆಲ್ಸನ್ ಮಂಡೇಲ ರಸ್ತೆಯಲ್ಲಿ ಮಿಲೇನಿಯಂ ಸರ್ಕಲ್ ಕಡೆಗೆ ಹೋಗುತ್ತಿದ್ದೆವು.
ಬಟ್ ಡ್ರೈವ್ ಮಾಡ್ತಾ ಇದ್ದ ನೀವ್ನ?
ಇವನು
ವೆಹಿಕಲ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ PW1.
ದ್ವಿಚಕ್ರ ವಾಹನವನ್ನು ನಾನು ಚಲಾಯಿಸುತ್ತಿದ್ದು. ಚಾಸ 2 ಹಿಂಬದಿಯ ಸವಾರನಾಗಿದ್ದನು. ಮಿಲೇನಿಯಂ ಸರ್ಕಲ್ ಕಡೆಯಿಂದ ಹೈವೇ ಸರ್ಕಲ್ ಕಡೆಗೆ ನಮ್ಮ ವಿರುದ್ಧ ದಿಕ್ಕಿಗೆ ಬಂದ KSRTC ಬಸ್ಸನ್ನು ಆ ಚಾಲಕ ಬಸ್ಸನ್ನು ಡಿಪೋ ಒಳಗಡೆ ಹೋಗುವ ಸಲುವಾಗಿ ಬಲಗಡೆ ತಿರುಗಿಸಿದ್ದು ನಮ್ಮ ವಾಹನಕ್ಕೆ ಡಿಕ್ಕಿ ಪಡಿಸಿತು.
ಆಯ್ತಾ? PW1 ಲೈಸೆನ್ಸ್ ಇದೆಯಾ?
ಇಲ್ಲ.
ಕೇಳಿದಿರಾ ನೀವು? ವೆಹಿಕಲ್ ರೈಡ್ ಮಾಡ್ತಿದ್ನಲ್ಲ ಅವನಿಗೆ.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ PW2
ಕೇಳಿದಿರಾ ಅಂತ?
ನನಗೆ ಪ್ರಾವಿಷನ್ ಸ್ಟೋರ್ ಹನುಮಂತ ನಗರದ ದಿನಾಂಕ 24 3 ಗಂಟೆಗೆ ಅಪಘಾತವಾಗಿರುತ್ತದೆ. ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 3 ಗಂಟೆ ಸಮಯಕ್ಕೆ ಅಪಘಾತವಾದ ಬಗ್ಗೆ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಸದರಿ ಭಾಗವನ್ನು ನಿಶಾನೆ D ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಾವು ಅಪಘಾತವಾದ ದಿನ ಇರ್ವಿನ್ ರಸ್ತೆಯಲ್ಲಿ ನಮ್ಮ ಅಂಗಡಿಗೆ ಹೋಗಿ ಬರುತ್ತಿದ್ದೆವು. ಸದರಿ ದಿನ ನಾನು ಅಂಗಡಿಯನ್ನು ಮುಚ್ಚಿ ಸಿಟಿ ಕಡೆಗೆ ಹೋಗಿ ಬರುತ್ತಿದ್ದೆವು. ನಮ್ಮ ಅಂಗಡಿ ರಾತ್ರಿ 10:30 ಗಂಟೆಗೆ ಗಂಟೆಯವರೆಗೆ ಅಂಗಡಿ ತೆರೆದಿರುತ್ತೇನೆ.
ಎಲ್ಲೂ ನೀವು ಕ್ರಾಸೇ ಮಾಡಿಲ್ಲ. ಅವನಿಗೆ ಲೈಸೆನ್ಸ್ ಇದೆಯೋ ಏನು ಎಂತ
ಹೇಳಿಕೆ ಪಡೆದ ನೆಲ್ಸನ್
ಏನ್ ಎಲಿಸಿಟ್ ಮಾಡ್ಸಿದ್ರಿ PW1 and 2 ಇಂದ?
ಜಸ್ಟ್ ಡಿನೈ ಮಾಡಿಸಿದ್ದಾರೆ. 3 AM ಅಲ್ಲಿ
ನಮ್ಮ ಅಂಗಡಿ ರಾತ್ರಿ 10:30 ಗಂಟೆಯವರೆಗೆ ಅಂಗಡಿ ತೆರೆದಿರುತ್ತೇನೆ. ಅಪಘಾತದ 2ನೇ ದಿನ ನನ್ನ ಹೇಳಿಕೆ ಪಡೆದಿದ್ದರು. ನೆಲ್ಸನ್ ಮಂಡೇಲ ರಸ್ತೆ ಮಧ್ಯದಲ್ಲಿ ಬ್ಯಾರಿಕೇಡ್ ಆಗಿರುತ್ತಾರೆ ಅಂದ್ರೆ ಸರಿ ಇಲ್ಲ. ನಾವು ಹೋಗುತ್ತಿದ್ದ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಗೇಟ್ ಇದೆ ಅಂದ್ರೆ ನಿಜ. ಸರಿ, ಗೇಟಿನ ಮೂಲಕ ಏಕಕಾಲದಲ್ಲಿ ಬಂದು ಬಸ್ಸು ಹೋಗಬಹುದು ಎಂದರೆ ನಿಜ. ಬಸ್ ಗೇಟ್ ಬಳಿ ನಿಂತು ನಿಲುಗಡೆ ತೆಗೆದುಕೊಳ್ಳಬೇಕು ಎಂದರೆ ನಿಜ. ಹೇಳಿಕೆ ಕೊಡುವಾಗ ನಾನು ಬಸ್ ಸಂಖ್ಯೆಯನ್ನು ಹೇಳಿರುವುದಿಲ್ಲ. ನನಗೆ ಬಸ್ ಸಂಖ್ಯೆಯನ್ನು ಹೇಳಲು ತೊಂದರೆ ಇತ್ತು. ನಮ್ಮನ್ನು ಆಸ್ಪತ್ರೆಗೆ 5-6 ಜನರು ಸಾರ್ವಜನಿಕರು ಸೇರಿ ನಮ್ಮ ವಾಹನದ ಮುಂಭಾಗಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳುತ್ತಾರೆ. IME ರಿಪೋರ್ಟ್ಗೆ ಹೋಗಿ. IME ರಿಪೋರ್ಟ್. ಇವರಿಬ್ರು ಬಿಟ್ಟರೆ ಬೇರೆ ಏನಿಲ್ವಾ?
ಬೇರೆ ಏನು ಯಾರು ನಾಟ್ ಸಪೋರ್ಟೆಡ್.
ಯಾರು?
PW3 and 4
3, 4
they are also to students.
No visible fresh damages were found on the motorcycle ಅಂತಿದೆ.
ಹೌದು.
ನಿಮ್ಮ ಬಸ್ ಮತ್ತೆ ಬಂದು ರೈಟ್ ಸೈಡಿಗೆ ಡಿಕ್ಕಿ ಮಾಡ್ದಂದ್ರೆ ಏನ್ರಿ ನೀವ್ ಹೇಳ್ಬೇಕು.
In this case, my lord, PW 1 and 2 are the eyewitness to the incident. PW 1 and 2 are the eyewitness to the incident.
ಫ್ರಂಟ್
PW 1 and 2 and also 3 and 4 are
ಡ್ಯಾಮೇಜ್. ಇದು ಯಾವ್ದು ವೆಹಿಕಲ್ ಯಾವ್ದು ಇದು? ಇದು ಬಸ್ಸಿಗ?
ಬಸ್.
ಟೂ ವೀಲರ್ ಫ್ರಂಟ್ ಬೋತ್ ಸೈಡ್.
PW 1 to 4 are the eyewitness.
ಹೋಗಿ ಹೊಡ್ಕೊಂಡವ್ರು. ಐ ಎಂ ರಿಪೋರ್ಟ್ ನೋಡಿ. ನಿಮ್ಮ ಪ್ರಕಾರ ಹೊಡೆದಿಲ್ಲ. ನೀವ್ ಹೇಳ್ದಂಗೆ ಅವ್ರು ಬಸ್ ಬಂದು ರೈಟ್ ಸೈಡಿಗೆ ಹೊಡೀತು ಅಂತಿಲ್ಲ. ಇವರೇ ಹೋಗಿ ಮೋಟರ್ ಸೈಕಲ್ ಹೋಗಿ ಹೊಡೆದಿರೋದು ಬಸ್ಸಿಗೆ. ಎಲ್ಲ ಫ್ರಂಟ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ನೋಡಿ.
ಅದು ಆಕ್ಚುಲಿ ಏನಾಗಿ
ಫ್ರಂಟ್ ಹೆಡ್ಲೈಟ್ ಅಸೆಂಬ್ಲಿ ಇಸ್ ಡ್ಯಾಮೇಜ್ಡ್. ಫ್ರಂಟ್ ಬೋತ್ ಸೈಡ್ ಇಂಡಿಕೇಟರ್ are broken. Front left side body is dead. ಅವ್ರ ಹೇಳಕ್ ಬೆಳಗಿನ ರಾತ್ರಿ ಬೆಳಗಿನ ಟೈಮ್ ಹೋಗಿ ಏನೋ ವೀಲರ್
3 ಗಂಟೆಗೆ ಫಾಸ್ಟ್ ಆಗಿ ಬಂದಿರ್ತಾರೆ, ಯಾರು ಇರಲ್ಲ ಅಂತ ಮಾರ್ನಿಂಗ್ ಅರ್ಲಿ ಮಾರ್ನಿಂಗ್.
ಐ ಎಂ ರಿಪೋರ್ಟೇ ನೋಡಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of case of prosecution is that on 29/4/2013 at about 3 AM, Nelson Mandela Public Road, in front of KSRTC depot number 1. The accused being the driver of bus bearing registration number K09F4074 drove the same in a rash and negligent manner so as to endanger human life and thereby dash against the two-wheeler. As a result, both CW1 and CW2 have sustained the injuries. The case has been registered and investigated the matter and filed the charge sheet. For the offence punishment on section 279, 337 of IPC and section 134A within bracket small, within bracket B small, read with section 187 of Motor Vehicles Act. The accused persons were secured and the accused is secured and he did not plead guilty, and hence the prosecution examined prosecution witnesses PW 1 to 6. The court marked document exhibit P1 1 to 9A. The accused not examined. The accused not led any defense evidence. Statement of PW3 was recorded in terms of exhibit D1 and statement of PW2 recorded in terms of exhibit D2. The trial court, having considered the material on record, convicted the driver for the deposit offences. Being agreed by the said judgment of conviction and sentence, and appeal is filed in criminal appeal number 110 of 2015. And the first appellate court also on reappreciation of both oral and documentary evidence. Confirmed the judgment, and hence the present revision petition is filed. The counsel appearing for the petitioner would vehemently contend that both the courts failed to take note of exhibit P3. P3 alla?
P3.
P3 sketch.
Yes, sketch.
Exhibit P3 sketch, wherein it is clear that there is a depot and driver of the bus depot, in order to go to depot, he took the vehicle turn towards the depot, and at that time PW1 and 2 who came in the motorcycle, that too in the early morning at 3 AM, came and suddenly dashed against the bus. The trial court also failed to consider both document exhibit P3 as well as IMA report, particularly exhibit P8, which clearly indicate that P7 clearly indicate that motorcyclists themselves went and dashed against the bus and damages in respect of the front portion and not as contended by the prosecution that bus went and dashed against the right portion of the motorcycle and no damage to the right portion of the motorcycle. And these are the aspects has not been considered and only and blindly believed the evidence of PW 1 and 2. And even though other witnesses have not supported the case of prosecution. Per contra, the counsel appearing for the state would contend that both the courts have taken note of the evidence of PW 1 and 2 and nothing is elicited from the mouth of PW 1 and 2 to disbelieve the case of the prosecution. The counsel also submits that though accident was taken place in the early hours at 3 a.m. and while taking the right turn, the KSRTC driver has to observe the vehicle which were proceeding in the main road and the same has not been observed and also even not led any defense evidence how an accident was occurred and hence while exercising the revisional powers, the court cannot exercise the same when there is no any error on the part of trial court as well as the first appellate court. And hence, no grounds are made out to exercise the revisional jurisdiction. Having heard the revision petitioner counsel and also the counsel appearing for the state and also having perused the material available on record, the prosecution mainly relies upon the evidence of PW 1 and 2. No doubt PW 1 and 2 have deposed that the driver of the bus, in order to enter the depot, he took the right turn. And on perusal of the evidence of PW 1 and 2, in their chief evidence, they have not stated anything about rashness on the part of driver of the KSRTC bus. And only it is stated that while taking the right turn, came and dashed against the motorcycle. As a result, both of them have fell down. It is the evidence of PW 1 that in the same speed, he took the right turn, but not stated anything about the speed at which he came. And PW 2 also reiterated the evidence of PW 1. And PW 2 also says that in order to go to the depot, took the vehicle right turn. And he also reiterates the same that in the very same speed, he took the right turn. And both the witnesses have not spoken about the rashness on the part of the driver. And in order to invoke the ingredients of offense under section 279, there must be a rational negligence on the part of the driver of the KSRTC. It is also important to note that the document exhibit P3 is also very clear that in the junction, an accident was taken place. And also sketch clearly discloses that the bus which came in the other direction took the vehicle to go to the depot. And both the PW 1 and 2 have categorically admitted that there is a depot gate on the left side of their direction. And also it has to be noted that when the bus was taken, at the distance in order to go to the depot, and the bus was almost at the 11 feet at the distance of footpath. And it appears that the riders themselves have driven the vehicle in a rash and negligent manner and dashed against the motorcycle. Also, I dashed against the bus. And there was a distance from the other end footpath, almost 31 feet. And apart from that, AMA report doesn't disclose any damages to the bus. Motorcycle front portion was damaged, that is front headlight assembly is damaged, front both side. Indicator are broken and front left side body is dent inwards. And hence it is clear that motorcyclists themselves went and dashed against the bus and fell down on the left side. As a result, there was a damage on the left side of the motorcycle. And the very document of exhibit P3 and exhibit P7 were not taken note of by the trial court and also the first appellate, also the appellate court, and both the courts have lost the documentary evidence available on record. Last sight of the documentary evidence of exhibit P3 as well as exhibit P7. And also no explanation on the part of PW1 and 2. Though PW2 says that they have closed the office, they closed the shop at 10:30 PM itself. And both of them are proceeding at 3 AM. And no any explanation on the part of PW1 and 2. And both the courts blindly accepted the evidence of PW1 and 2 and erroneously comes to the conclusion and not consider the admissions elicited from the mouth of PW1 and 2. And both of them have categorically admitted that there is a gate on their left side and also failed to take note of the accident spot which was taken place. And I have already pointed out that both the PW1 and 2 have not spoken anything about rashness and negligence on the part of the driver of the bus. And in order to invoke section 279, there must be a rashness and negligence on the part of the driver. And in the absence of the same, they cannot be. And hence, in the absence of the same, the accused cannot be convicted. And hence, both the courts committed an error in not appreciating documentary evidence of exhibit P3 as well as exhibit P7, and the other witnesses have not supported the case of the prosecution. And no doubt PW1 and 2 are the injured witnesses who have sustained the injuries and failed to take note of negligence at whose instance. And hence, it is a fit case to exercise the revisional jurisdiction, and material evidence has not been considered by the trial court and also the
Subdivision 3 and 4.
appellate court.
3 and 4.
Huh?
3 and 4. PW 3 and 4.
3 and 4.
ಅದು eyewitness to the incident.
ಅವರು ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Support ಮಾಡಿದ್ರು, party
ಇಲ್ಲ ಅಂದ್ರೆ
supported.
ನೀವು
ಇಲ್ಲ, party
ಹೇಳ್ರಿ
supported.
ನೀವುಗಳು
Party
ಹೇಳ್ಬೇಕು.
supported.
ನೀವು ತಪ್ಪು ಮಾಡೋದಲ್ಲ.
ಇಲ್ಲ, 3 and no, my lords, 3 and 4, just a scene ಅಷ್ಟೇ.
Party supported me. Also,
He has not seen the,
supported.
ನಾನು ನೋಡಿದಾಗ ಬಿದ್ದಿದ್ದರು.
ಅಷ್ಟೇ. He has seen the incident.
Not supported the case of prosecution. ಅಷ್ಟೇ. PW3 ಇಲ್ಲ, ಬಸ್ ಇತ್ತು ಅಷ್ಟೇ. ಬಿದ್ದಿದ್ದರು ಬಸ್ ಇತ್ತು. ಬಸ್ಸಿನ
ಅಷ್ಟೇ,
ಸಂಖ್ಯೆ
ಅಷ್ಟೇ.
ನೋಡೋದಿಲ್ಲ. ಎಲ್ಲಿ ಸಪೋರ್ಟ್ ಮಾಡೋದು? ಅಪಘಾತ KSRTC ಬಸ್ ಚಾಲಕನಿಂದ ಆಗಿರುತ್ತದೆ ಅಂತ ಹೇಳ್ತಾನೆ. ಆಲ್ರೆಡಿ ಬಿದ್ದಿದ್ರು. ಹಾ.
ಮತ್ತೆ ಏನಾಗಿತ್ತು ಅಂದ್ರೂ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಬ್ಯಾರಿಕೇಡ್ ಹಾಕಿದ್ದರು,
ನಾಸ
ಡಿಪೋ
ಒಂದು
ಒಳಗಡೆ ಹೋಗಬೇಕಾದರೆ ಬಸ್ ಅನ್ನು ನಿಧಾನಿಸಿ ಹೋಗಬೇಕು ಎಂದು ನಿಜ ಅಷ್ಟೇ. ಅವ್ರದ್ದು ಎಲ್ಲಿ ಸಪೋರ್ಟ್ ಇಲ್ವಲ್ರಿ? ಅಷ್ಟೇ ಇಲ್ಲ.
ಅಷ್ಟೇ.
While cross examination,
ಇದ್ ಮಾಡಿದ
cross examination.
ಮಾಜರ್ ಅದು. ಮಾಜರ್ ಅಷ್ಟೇ, ಏನಿಲ್ಲ. The revision petition is allowed and impugned judgment of conviction and sentence passed by the trial court and confirmation order passed by the appellate court in criminal appeal number so and so are set aside. Consequently, the accused is acquitted for the offences, and if any fine amount is deposited, there is order to be refunded on proper identification.
61, V. Anand.
Yes, I am
Deepak
the petitioner,
Desai.
my lord. Petition is arising out of 138 proceeding. Idರಲ್ಲಿ, the case of the complainant is that she had given a hand loan of 4,75,000 to the mother of the petitioner. And the mother had given 5 of her checks. And also 1 check belonging to the petitioner was taken.
ಇದೇನೋ ಒಂದು criminal revision order copy ಹಾಕಿದ್ರಲ್ಲ ಯಾರು?
ಅದು allow ಆಗಿದೆ ಸ್ವಾಮಿ, connected matter. Main matter has been allowed.
ಹಾ.
And hence, based on that, this petition will not survive.
Main matter ಅಂದ್ರೆ?
ಅದೇ ಮದರ್ ಮೇಲೆ ಹಾಕಿದಂತ ಕೇಸು. ಅದರಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಡಿಪೋಸಿಷನ್ ಮತ್ತೆ ಡಿಫೆನ್ಸ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ಎಲ್ಲ ಆ ಕೇಸಲ್ಲಿ ಇದೆ. So ಅದರಲ್ಲಿ this honorable court has come to the conclusion that the complainant has failed to show her capacity and also the exact amount which was due from the accused ಅಂತ ಹೇಳಿ this honorable court was pleased to allow the revision petition of the case which was filed against the mother. Now this is the son.
ಈಗ ಈ ಕೇಸಿನ ಎಕ್ಸಿಬಿಟ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇಲ್ವಾ?
ಈ ಕೇಸ್ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಬಟ್ ಮೇನ್ ಡಿಫೆನ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆ ಕೇಸಲ್ಲಿ ಇದೆ.
ಅದನ್ನ ಇಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ?
ಇಲ್ಲ, ಅದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ ಈಗ ಹೆಂಗ್ ರಿಲೇ ಮಾಡಕತ್ತ ಈ ಕೇಸ್?
ಅಲ್ಲ, ಸೇಮ್ ಕನೆಕ್ಟೆಡ್, ಸೇಮ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್.
ಕನೆಕ್ಟೆಡ್ ಪ್ರಶ್ನೆ ಬರಲ್ರಿ. ಅನ್ಲೆಸ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಎಕ್ಸಿಬಿಟೆಡ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್, ದಿಸ್ ಕೋರ್ಟ್ ಕೆನಾಟ್ ಲುಕ್ ಇನ್ ಟು ದಿ ಎಕ್ಸಿಬಿಟ್ಸ್ ಮಾರ್ಕ್ಡ್ ಇನ್ ಅದರ್ ಕೇಸ್.
Because same transaction.
Maybe a same transaction counts.
The accused, the complainant says.
Alla, whether this court can consider the exhibits in other case for consideration of this case.
For the same transaction.
Maybe a same transaction.
Separate case ಹಾಕಿರೋದು ಏನಕ್ಕೆ ಅಂದ್ರೆ ಇವ್ರದ್ದು ಚೆಕ್ ಇದೆ ಅಂತ ಅಷ್ಟೇ.
Understand the criminal jurisprudence.
Separate case ಹಾಕಿರೋದು ಏನಂದ್ರೆ in both the cases the contention is same.
Contention may be same.
Complaint is same.
ಆ ಕೇಸಲ್ಲಿ ಆಗಿದೆ ಅಂತ ಈ ಕೇಸಲ್ಲೂ ಡಿಸೈಡ್.
There is no transaction between the complainant and this petitioner. She has admitted. ನಾನು ₹1 ನಾನು ಆರೋಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಒಪ್ಕೊಳ್ತಾರೆ.
ಆಯ್ತು, ಅದೇ ಸಾಕು, ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳಿ ಈಗ ಅಷ್ಟೇ.
ಅದೇ ಅಷ್ಟೇ
ಈ ಕೇಸ್ ಅದಕ್ಕೆ ಬೇಕು.
ಅದೇ ಇದೆ.
ಕೊಡಿ ಮೇಡಮ್.
Respondent amicus curiae.
Huh?
About the respondent amicus curiae.
ಏನು ಅಮಿಕಸ್ ಕ್ಯೂರಿನ? ಆಯ್ತು, ಅಮಿಕಸ್ ಕ್ಯೂರಿನೇ ಸಪೋರ್ಟ್ ಮಾಡಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಬಿ ಉಮೇಶ್ ಅಂತ ಇದೆ.
ಹೌದಾ, ನಾನೇ ಉಮೇಶ್.
ಹಾ, ಕೊಡಿ.
And moreover, the complainant was a tenant under the mother of the accused. She was staying on.
The accused.
Accused ಮನೆ ಮೇಲೆನೆ ಒಂದು ರೂಮ್ ಟೆನೆಂಟ್ ಆಗಿದ್ರು. Complainant. That fact was completely suppressed in the entire case before the court. ಅವ್ರು ಎಲ್ಲೂ ನೋಟಿಸ್ ಅಲ್ಲಾಗ್ಲಿ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಾಗ್ಲಿ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಾಗ್ಲಿ ಎಲ್ಲೂ ಹೇಳ್ಕೊಂಡಿಲ್ಲ. ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಅದರಲ್ಲಿ ಒಂದು ₹1.5 ಲಕ್ಷ ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ, ಲೀಸ್ ಅಮೌಂಟ್. ಅದನ್ನ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಹೋಗಿ ವಾಪಸ್ ತಗೊಳ್ತಾರೆ. ಸೊ ನಮ್ಮ ಕಂಟೆನ್ಷನ್ ಏನಂದ್ರೆ ₹1.5 ಲಕ್ಷ she has claimed that she has paid by check. That amount has been returned to her in the police station by the mother of the accused.
ಕ್ಲಾಸ್ ಹೋಗಿ ನೋಡೋಣ, ಕಂಪ್ಲೇಂಟ್ ಏನು ಅಡ್ಮಿಷನ್ ಇಲ್ಲಿ ಸೀಟ್ ಮಾಡಿಸಿದ್ರು.
ಆರೋಪಿಗೆ ನೋಟಿಸು ಕಳುಹಿಸಿದಾಗ ನಾನು ನಮ್ಮ ತಂದೆ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಮೇ 2014 ನಾನು ಆರೋಪಿಯ ತಾಯಿಯ ಮನೆಯಲ್ಲಿ ಬಾಡಿಗೆಗೆಂದು ಇದ್ದನೆಂದು ಎಂದರೆ ನಿಜ. ಅವರ ಮನೆಗೆ ಯಾವ ತಿಂಗಳು ವರ್ಷ ಬಾಡಿಗೆಗೆಂದು ಹೋಗಿದ್ದೇನು ನೆನಪಿಲ್ಲ. ಆದ್ರೆ ಸನ್ 2011 ಮಾರ್ಚ್ ತಿಂಗಳು ಇರಬಹುದು. ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರ ಆಗಿರುತ್ತದೆ. ಈಗ ನನಗೆ ತೋರಿಸುತ್ತಿರುವ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅದೇ ಇರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆ D1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದನ್ನು ದಿನಾಂಕ 1/11/2010 ಮಾಡಿದ್ದು ಇರುತ್ತದೆ ಎಂದರೆ ನಿಜ. ಸನ್ 2013 ಆರೋಪಿಗೆ ವಕೀಲರ ಮುಖಾಂತರ ನೋಟಿಸ್ ಕಳುಹಿಸಿರುತ್ತೇನೆ. ಸದರಿ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ಆರೋಪಿಯ ತಾಯಿಯ ಮನೆಯಲ್ಲೇ ಬಾಡಿಗೆಗಿದ್ದೇನೋ ಎಂದರೆ ನಿಜ. ನೋಟಿಸ್ನಲ್ಲಿ, ದೂರಿನಲ್ಲಿ, ಹೇಳಿಕೆಯಲ್ಲಿ ಹಾಗೂ ನನ್ನ ಸಾಕ್ಷ್ಯದಲ್ಲಿ ಆರೋಪಿಯ ತಾಯಿಯ ಮನೆಯಲ್ಲಿ ಬಾಡಿಗೆಗೆ ಇದ್ದ ವಿಷಯ ಹೇಳಲಿಲ್ಲ ಎಂದರೆ ನಿಜ. ಹಾಗೆ ಹೇಳಲಿಕ್ಕೆ ಅಡಚಣೆ ಇರಲಿಲ್ಲ. ಆರೋಪಿ ಕೂಡ ಅವರ ತಾಯಿ ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಾನೆ ಎಂದರೆ ನಿಜ. ಆರೋಪಿ ಮತ್ತು ಆತನ ತಾಯಿ ರೂಪಾಯಿ 4,75,000 ಹಣ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಅಂತ ಹೇಳಿರುತ್ತೇನೆ. ಆರೋಪಿಯ ಮನೆಯಲ್ಲಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಆರೋಪಿ ಸುರೇಶ್ ನಮ್ಮ ಹತ್ತಿರ ಬಂದು ದುಡ್ಡು ಕೇಳಿರುತ್ತಾನೆ ಎಂದು ಎಲ್ಲೂ ಹೇಳಲಿಲ್ಲ. ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿಯು ಚೆಕ್ ಅನ್ನು ಕೊಡುವಾಗ ಆತನ ತಂದೆ ತಾಯಿ ಹಾಗೂ ನನ್ನ ತಂದೆ ಹಾಜರಿದ್ದರು. ಆರೋಪಿಯು ಚೆಕ್ ಅನ್ನು ಮೊದಲೇ ಬರೆದುಕೊಂಡು ಬಂದಿದ್ದರು. ಆದರೆ ಅದರಲ್ಲಿರುವ ಹೆಸರನ್ನು ಮಾತ್ರ ನಾನು ಬರೆದಿರುತ್ತೇನೆ. ಕಾಂಟ್ರಡಿಕ್ಷರಿ ಸ್ಟೇಟ್ಮೆಂಟ್. ಚೆಕ್ ನಲ್ಲಿರುವ ಸಹಿ ಒಂದು ಕರಲಿನಲ್ಲಿ ಉಳಿದ ಬರಹ ಇನ್ನೊಂದು ಬಣ್ಣದ ಶಾಹಿಯಲ್ಲಿ ಇರುತ್ತದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಗೊತ್ತಾಗುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಆದರೆ ಸಹಿಯನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಬರವಣಿಗೆಯನ್ನು ನಾನೇ ಮಾಡಿರುತ್ತೇನೆ. ಶಿ ಅಗ್ರೀಸ್. ಅಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಪುನಃ ದಿನಾಂಕವನ್ನು ನಾನೇ ಹಾಕಿರುತ್ತೇನೆ ಅಂತ ಹೇಳುತ್ತಾರೆ. ಸೊ ಶಿ ಅಡ್ಮಿಟ್ಸ್ ದಟ್ ಪಾರ್ಟ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಆರೋಪಿ ಹೇಳಿದ್ದರಿಂದ ಅವರ ತಾಯಿಗೆ ಒಟ್ಟು 4,75,000 ಹಣವನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಆರೋಪಿಯ ಕೈಗೆ ನೇರವಾಗಿ ಹಣ ಕೊಟ್ಟಿಲ್ಲ. ದಿಸ್ ಇಸ್ ದ ಕ್ಲಿಯರ್ ಕಟ್ ಅಡ್ಮಿಷನ್. ನನ್ನ ತಂಗಿ ಸುನೀತಾ ಅವರಿಂದ ₹50,000 ಪಡೆದಿದ್ದೆನು. ನನ್ನ ತಂದೆಯಿಂದ ₹50,000 ಹಣ ಪಡೆದಿದ್ದೆನು. ನನ್ನ ಸ್ನೇಹಿತೆ ವೈಜಯಂತಿ ಅವರಿಂದ ₹50,000 ಹಣ ಪಡೆದಿದ್ದೆನು. ಇನ್ನೊಬ್ಬರು ಶ್ರೀದೇವಿ ಎನ್ನುವರಿಂದ 50,000 ಹಣ ಪಡೆದಿದ್ದೆನು. ಆರೋಪಿಯ ತಾಯಿ ಯಾವಾಗ ಫೋನ್ ಮಾಡಿ ಕೇಳಿದಾಗ ಸ್ವಲ್ಪ ಹಣ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಮೇಲೆ ಹೇಳಿದವರಿಂದ ಹಣ ಪಡೆದ ಬಗ್ಗೆ ದಾಖಲೆ ಇರುವುದಿಲ್ಲ. MVC ಪ್ರಕರಣದಲ್ಲಿ ಪರಿಹಾರ ಎಂದು ತನ್ನ 2005ರಲ್ಲಿ ₹2,75,000 ಹಣ ಬಂದಿತ್ತು. ನನಗೆ ಬೇರೆ ಆದಾಯ ಇರುವುದಿಲ್ಲ. ನನ್ನ ವಿಚ್ಛೇದಿತ ಪತಿಯಿಂದ ಪ್ರತಿ ತಿಂಗಳು 2,000 ಜೀವನಾಂಶ ಬರುತ್ತದೆ. ಪುನಃ ಹೇಳುತ್ತಾನೆ, ಬಟ್ಟೆ ಹೊಲಿಯುವುದರಿಂದ ಕೂಡ ಆದಾಯ ಬರುತ್ತದೆ. ಎಷ್ಟು ಅಂತ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಸದರಿ ಸಾಲದ ಹಣವನ್ನು ಆರೋಪಿಯ ತಾಯಿಗೆ ಪ್ರತಿ ತಿಂಗಳಿಗೆ ಪ್ರತಿಶತ 2% ಬಡ್ಡಿ ಕೊಡುವ ಷರತ್ತಿನ ಮೇಲೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನೋಟಿಸ್ನಲ್ಲಾಗಲಿ ದೂರಿನಲ್ಲಾಗಲಿ ಅಥವಾ ನನ್ನ ಸಾಕ್ಷ್ಯದಲ್ಲಾಗಲಿ ಬಡ್ಡಿ ವಿಚಾರವನ್ನು ಹೇಳಲಿಲ್ಲ ಎಂದರೆ ನಿಜ. ಆರೋಪಿ ಯಾವ ದಿನಾಂಕದಂದು ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರುತ್ತಾನೆ ನೆನಪಿರುವುದಿಲ್ಲ. ಆರೋಪಿಯ ತಾಯಿ ಹತ್ತಿರ 2ನೇ ಮಹಡಿಯ ಮೇಲೆ ನನಗೊಂದು ರೂಮ್ ಕಟ್ಟಿಸಿಕೊಡಿ ಎಂದು ಕೇಳಿದ್ದೆನು ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿಯ ತಾಯಿ ಮನೆಯಲ್ಲಿ 2 ವರ್ಷಗಳವರೆಗೆ ಬಾಡಿಗೆಗೆಂದು ಇದ್ದೆನು. ಬಾಡಿಗೆ ಮನೆ ಖಾಲಿ ಮಾಡುವ ವಿಚಾರವಾಗಿ ಆರೋಪಿಯ ತಾಯಿ ವಿರುದ್ಧ ರಾಮಮೂರ್ತಿ ನಗರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ಸಲ್ಲಿಸಿದನು ಎಂದರೆ ನಿಜ. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮುಂಗಡ ಹಣವನ್ನು ವಾಪಸ್ ಪಡೆದು ಮನೆಯನ್ನು ಖಾಲಿ ಮಾಡಿರುತ್ತೇನೆ ಎಂದರೆ ನಿಜ. ಮನೆ ಖಾಲಿ ಮಾಡು ಅಂತ ಹೇಳಿದ್ದರಿಂದಲೇ ದೂರು ಸಲ್ಲಿಸಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನನಗೆ ₹4,75,000 ಹಣವನ್ನು ಸಾಲವಾಗಿ ಕೊಡುವ ಸಾಮರ್ಥ್ಯ ಇರಲಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿಯು ಪ್ರತಿ ತಿಂಗಳು 4,000ದಂತೆ 1 ವರ್ಷದವರೆಗೆ ಬಡ್ಡಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. 1.5 ಲಕ್ಷ ಮುಂಗಡ ಹಣವನ್ನು ನಗದಾಗಿ ಕೊಟ್ಟಿದ್ದೆನು. ನನ್ನ ಸಹೋದರಿಯಿಂದ ಸದರಿ ಹಣವನ್ನು ಪಡೆದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡುವ 1 ವಾರಕ್ಕಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಆರೋಪಿಯ ತಾಯಿಯ ವಿರುದ್ಧ ದಾಖಲು ಮಾಡಿದ CC ಸಂಖ್ಯೆ 50961 ಆಫ್ 2014ರಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ ನಿಶಾನೆ P12 ದೃಢೀಕೃತ ನಕಲು ನೋಡುತ್ತಿದ್ದು, ಅದರಲ್ಲಿ ಕಟ್ಟಡಕ್ಕೋಸ್ಕರ ₹1,50,000 ಹಣವನ್ನು ಆರೋಪಿಯ ತಾಯಿ ನನ್ನಿಂದ ಪಡೆದಿದ್ದಾರೆ ಎಂದು ನಮೂದು ಇದೆ ಎಂದರೆ ನಿಜ. ಸದರಿ ಹಣವನ್ನು ರೂಮ್ ಕಟ್ಟಿಸಿಕೊಡುವುದಕ್ಕೋಸ್ಕರ ಮುಂಗಡ ಹಣ ಎಂದು ಕೊಟ್ಟಿದ್ದೇನು ಎಂದರೆ ಸುಳ್ಳು. ಸದರಿ ಹಣವನ್ನು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ವಾಪಸ್ ಪಡೆದಿರುತ್ತೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆಗಸ್ಟ್ 2010ರಲ್ಲಿ ಸದರಿ ಹಣವನ್ನು ನನ್ನಿಂದ ಪಡೆದು ರೂಮನ್ನು ಕಟ್ಟಡ ಕೆಲಸ ಪೂರೈಸಿ ನನಗೆ ಕೊಟ್ಟಿದ್ದರು ಎಂದರೆ ನಿಜ. Once she denies, immediately she admits. ಆರೋಪಿ ಖುದ್ದಾಗಿ ನನ್ನಿಂದ ಸಾಲ ಕೇಳಲಿಲ್ಲ ಎಂದರೆ ನಿಜ. This petitioner, my lord. He has never asked for any loan. ಆರೋಪಿಯ ತಾಯಿ ನನ್ನಿಂದ ಪಡೆದಂತ ₹30,000 ಸಾಲದ ಭದ್ರತೆಗೋಸ್ಕರ ಆರೋಪಿ ಸುರೇಶ್ ಅವರಿಂದ ಒಂದು ಸಹಿ ಮಾಡಿದ ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ಪಡೆದಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿಯ ತಾಯಿ ನನ್ನಿಂದ ಪಡೆದಂತ ಎಲ್ಲ ಹಣವನ್ನು ವಾಪಸ್ ಮಾಡಿರುತ್ತಾಳೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಮನೆ ಖಾಲಿ ಮಾಡಿಸಿದ್ದರಿಂದ ಆ ಸಿಟ್ಟಿನಿಂದ ಅವರ ವಿರುದ್ಧ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿರುತ್ತೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ಸುರೇಶ್ ಅವರು ನನಗೆ ₹1 ಕೂಡ ಕೊಡಬೇಕಾಗಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. This is the entire cross examination. So the entire transaction is between the mother of the petitioner and the complainant. And mother of the petitioner has repaid much of the amount whichever has been claimed by the complainant, and those documents are marked in the other case.
Whether petitioner has laid any evidence?
No defense evidence. Because she has admitted.
Yes,
My
Councillor.
lord, my submission, first submission is that, my lord, he has suppressed the address of the address, my lord. Kindly see the complaint as well as the legal notice, my lord. The address of the complainant as well as the address of the accused are one and the same, my lord. First submission, my lord.
She was staying at that
No, my
time.
lord. At the time of the complaint, my lord, and at the time of the legal notice, my lord, address mentioned in the complaint as well as the address in the legal notice, my lord, one and the same. As well as the complainant and the accused, my lord. In the present case, my lord, the check belong to the accused is not disputed, my lord. Signature on the check, it is not disputed. After issuance of the legal notice, my lord, he has not replied to the legal notice, my lord.
I have replied.
My lord, it is not exhibited, my lord. He may be replied. He has not replied to the notice, my lord. Moreover, my lord, he has not entered to the witness box, my lord, to his defense, my lord. On the other hand, my lord, I proved in this case, my lord, in the cross-examination, it is very clearly elicited by the PW1, my lord, stating that, my lord, ROP ಅವರು ನನಗೆ 4 something kindly see that, my lord, in the cross-examination, they clearly admitted, my lord, ROP ಪ್ರತಿ ತಿಂಗಳು 4,000 ರೂಪಾಯಿ ಅಂತ 1 ವರ್ಷ ಒಳಗೆ ಬಡ್ಡಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. 1.5 ವರ್ಷ ಒಂದು ವರ್ಷದವರೆಗೆ ಬಡ್ಡಿ ಕೊಟ್ಟಿರ್ತಾರೆ. That means, my lord, he has obtained the loan from the kindly see the cross-examination, my lord. ROP ಪ್ರತಿ ತಿಂಗಳು ₹400 ಅಂತ 1 ವರ್ಷ.
Agreement.
Exhibit D1, my lord.
Exhibit D1, my lord. D1, my lord.
D1.
D1, my lord.
ಏನದು agreement?
Agreement, lease agreement between the complainant and
Lease agreement.
Lease agreement, my lord. It is nothing but it is the lease agreement between in this course, my lord. My lord, kindly see the my
ಬಾಡಿಗೆಗಿದ್ರು ಅಂತ ತೋರ್ಸಕ್ಕೆ.
ಬಾಡಿಗೆ ಅಂತ. Kindly see that, my lord, this my allegation so far as my complaint is concerned, accused is concerned, my lord. In my evidence chief examination, my lord. In the second paragraph, my lord, I depose that myself and accused, including accused mother, Srimati Jalaja and Jalajasi, are known to each other for the past 10 years as family friend. Taking advantage of the said acquaintance, on the first week of 2008, the accused and his mother had approached me seeking financial assistance. My lord, this is the chief examination, my lord. Even along with the complaint, my lord, that accused, my lord, and his mother, my lord, approached the complainant, my lord, for financial assistance. For that reason, my lord, I have paid the rupees 4,80,000, my lord. In turn, my lord, the accused as well as his mother, my lord, has paid the as a security check as issued. For that, my lord, to misuse of the check amount, my lord, they are not filed any complaint against. They are not taken any action against this complaint is concerned. The influence of the 138, my lord, is approved, my lord. Because, my lord, they are not disputed the signature, they are not disputed the issuance of check. How check has gone to my hand, my lord, there is nothing is there on record.
ಏನ್ರಿ ಎಲ್ಲ ಚೆಕ್ ಪೇಮೆಂಟ್ ಇದೆಯಲ್ರಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 4 ಅಲ್ಲಿ
ಅದೆಲ್ಲ ವಾಪಸ್ ಆಗಿದೆ. ಅದು
ವಾಪಸ್ ಆಗಿದೆ
85,000 ಒಂದು
ಇಲ್ರಿ
65,000
ಚೆಕ್ ಮೂಲಕ ರಿಸೀವ್ ಮಾಡಿರೋದು 85,000 ಒಂದ್ ಸಾಲ.
ಅದು 65 ಅದು ಲೀಸ್ ಅಮೌಂಟ್.
ಮತ್ತೊಂದ್ ಸರಿ 65,000
ಲೀಸ್ ಅಮೌಂಟ್. ಅದು
ಅದರ ಲೀಸ್ ಅಮೌಂಟ್ ಮನೆ ಲೀಸ್ಗೆ ಹಾಕೊಂಡಿದ್ರಾ?
ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅದೇ D1 1.5 lakhs. There is no other document to show that she has paid extra 1.5 to us as a loan. ಇದು ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಗೆ ಕೊಟ್ಟಿರೋದು 1.5 lakhs. ಅವಾಗ ಮನೆ ಇರ್ಲಿಲ್ಲ, ಒಂದು ರೂಮ್ ಕಟ್ಕೊಡಿ ಅಂತ ಹೇಳಿ 1.5 lakhs ನಾನು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಎರಡು ಪಾರ್ಟ್ ಅಲ್ಲಿ ದುಡ್ಡು ತಗೊಂಡು ಅವ್ರಿಗೆ ಮನೆ ಕಟ್ಕೊಟ್ಟು ಕೊಟ್ಟಿರೋದು ಬಾಡಿಗೆ ಲೀಸ್ಗೆ.
ಅದೇ ದುಡ್ಡನ್ನ ಇವ್ರ ಲೋನ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಇವ್ರ ಲೋನ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದೇ ದುಡ್ಡನ್ನ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ವಾಪಸ್.
ಎಕ್ಸಿಬಿಟ್ D1 ಅಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇದೆಯಾ ಅದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿಲ್ಲ.
ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಮೇಡ್ ದಿ ಪೇಮೆಂಟ್.
Having made the payment, she has admitted all that, and the document is produced also in the other case. Other case alli payments. This complainant has received payments up to nearly 42,000.
Madam, heard the petitioner counsel and also the counsel appearing to the respondent. That is amicus curiae. The factual matrix of case of complainant before the trial court in CC number 50960 of 2014 that accused availed a loan for construction of his house from the complainant for rupees 4 lakhs and issued a check dated 27/7/2013 when the same was presented and the same was dishonored with an endorsement fund insufficient, and hence legal notice was issued. And in spite of service of notice has not paid the check amount. And hence he initiated the proceedings for the offence punishment section 138 of an act. The trial court has taken the cognizance and thereafter secured the accused. And he denies the charges leveled against him and hence prosecution. And hence the complainant, not prosecution, examined himself as PW1 and got marked document exhibit P1 to 8. On the other hand, accused has not laid any evidence, however, confronted the document of exhibit D1, lease agreement. The trial court, having considered both oral and documentary evidence, has convicted the accused for the offence punishment section 138 of an act. Being agreed by the said judgment of conviction and sentence, criminal appeal number 25019 of 2016 is filed. And the first appellate court on reappreciation of both oral and documentary evidence comes to the conclusion that complainant has succeeded in proving the exhibit P1 and issuance of check was not disputed, and the same is also issued for legally enforceable debt. And on the other hand, accused has not made out his case as set out in his defense and confirmed the judgment, and hence the present revision petition is filed. The counsel appearing for the petitioner would vehemently contend that both the courts failed to consider the admission available on records. ಯಾರು ಸ್ಟೇಪ್ಲರ್ ಯಾರ ಕೊಟ್ಬಿಡ್ತಾರೆ ಅನ್ಸುತ್ತೆ ಈಗ ಜಡ್ಜ್ಮೆಂಟ್ಗೆಲ್ಲ ಮಧ್ಯದಲ್ಲೇ ಹೊಡ್ತದೆ ರಿವಿಷನ್ ಪಿಟಿಷನ್. Counsel also vehemently contend that the judgment of both the courts are perverse and contrary to the admissions elicited from the mouth of PW1, and specifically admitted that he has not made any transaction with this revision petitioner, and the transaction is only with the mother. The counsel also submits that the very complainant has filed the case against the mother, and mother had filed criminal revision petition number 849 of 2018, and this court allowed the revision petition and set aside the judgment of conviction and also the confirmation. The counsel also vehemently contend that the very admissions on the part of the complainant that she has not disclosed the very fact that she was the tenant under the mother of this accused. And the same is also admitted, and also admitted in the cross-examination that she only put the date in respect of the said check, and also contend that she has availed the loan from different persons to make the payment, but none of the persons have been examined before the trial court. The PW1 also in the cross-examination categorically admitted with regard to vacating of the premises, matter has reached to the Ramurtha Nagara police, and she has given the complaint, and she has vacated the house after collecting the advance amount which she has paid to the mother of the complainant. The PW1 also categorically admitted in exhibit P12, there is a reference for having made the payment of rupees 1.5 lakh for the construction of the building. And though earlier denied, she categorically admitted that she gave the money and out of that money only building was constructed. And all these admissions on the part of the PW1 has not been considered. The council also would submit that when the very transaction is doubtful and no need to examine the accused before the trial court when the answers elicited from the mouth of PW1 itself is clear that there was no any transaction between the petitioner and the complainant, and hence it requires interference. For contra, the counsel appearing for the respondent, that is amicus curiae, would vehemently contend that in the complaint specific governments are made with regard to the transaction. And the same is also reiterated in the evidence of PW1. And also counsel would submit that when the legal notice was given, no reply was given. And also the address mentioned in the legal notice is also clear, not in respect of the tenanted premises. And the same is in respect of different premises. But also counsel would contend that even though PW1 admitted that no transaction between the accused and complainant, and specifically pleaded in the complaint that amount is advanced in favor of both the mother and the son, and hence cannot contend that there was no any transaction between them.
Check is not disputed, signature and
The council also would submit that the check is not disputed. And both the courts also taken note of the presumption in favor of the complainant, invoking section 139 of the Act. But when the check was not disputed, and now cannot contend that there was no any transaction, and hence it doesn't require any interference. Having heard the revision petitioner counsel and also the counsel appearing for the respondent, and also taking into note of the averments made in the complaint, no doubt there is an averment in the complaint for having made the payment, and also both of them are having acquaintance with each other. And also it is her claim that he was having the amount he received from MUC number 3237 of 2001 and 3238 of 2001. And in paragraph number 4, given the details of payment made through the check. And having taken note of the pleading is very clear in paragraph number 4 that the amount was given to the accused mother on several occasions. That is 85,000, 65,000, and an amount of rupees 7,000, and an amount of rupees 10,000. And in the cross-examination of PW1, she categorically admitted that she was the tenant of mother of this accused. And when the notice was given to the accused, at that time also she was residing in the house of her father, and admits the lease agreement exhibit D1. And the same came into existence on 1/11/2010. It is also admitted that when the notice was given to the accused in 2013, at that time also, he was staying in the house of accused mother. But she has not stated anything in her complaint and also in her legal notice about she is a tenant of the house of mother of the accused, and there was no any impediment. It is rightly pointed out by the counsel appearing to the revision petitioner that, and the said fact that she was a tenant of the house of the accused, the mother of the house of the accused, has not been disclosed. It is also important to note that the check contains the signature of accused is not in dispute. And when the suggestion was made that signature and other writings are in different name, but she says that she cannot tell the same. However, she categorically admits that she only put the date to the said check. When such admission is given, that it is very clear that she only put the date and no date was put on the check. And also it is rightly pointed out by the counsel for the revision petitioner that when the amount was paid as claimed by the complainant, that to the tune of rupees 4,75,000, she has paid the amount to the mother of the accused. She has disclosed the name of some of the persons from whom she has received the money, and none of the persons have been examined before the trial court. It is also important to note that PW1 categorically admitted that she has not given any amount to the accused. But she claims that she advanced the money on the interest of 2%. That to the mother of the accused. And also categorically admits that for having given the amount for interest, either in the notice or in her evidence, she has not stated anything. And also categorically admits that they cannot tell on what date the accused has given the check. It is also illustrated that she was a tenant for a period of 2 years in the house of the accused mother. It is also clear that in respect of vacating of the premises is concerned, she herself has lodged the complaint with the police. That is Ramamurthy Nagara Police Station. And further admission is given that whatever the advance amount she has given, that has been recollected by her in the police station itself, and thereafter she has vacated the house. When all these admissions are given that she has received the amount in the police station itself, and hence it is clear that she has filed the case against the accused mother as well as this accused. And also categorically admitted that in terms of Exhibit P12, whatever the amount she has given for construction, that is 1,50,000. There is a reference in the document Exhibit P12, that is 1,50,000. The PW1 also categorically admitted that whatever the amount she has given for construction and advance, the same was obtained in the police station itself. It is also important to note that he has further admitted that and though at the first instance denied the receipt of the amount which was given for the construction, but categorically admits that the same was returned and the said amount was given for the completion of the construction of the building. It is also categorical admission that accused never asked any loan personally from her. And having taken note of this admission that accused never asked any money, and also categorical admission that she has not given any money to the accused. And also all these answers illustrated from the mouth of the PW1 has not been considered by the trial court while passing the judgment of conviction. The trial court ought to have taken note of the fact that when there is a clear admission on the part of the PW1 that she was a tenant, and even at the time of vacating the premises also she had approached the police and taken the money in the police station itself, and she vacated the premises. And when she has filed the case against the mother as well as the accused, not to have been considered the evidence meticulously, and whatever pleaded in the complaint for having given the money by way of check also, that is in favor of the mother. And this court already acquitted the mother of this revision petitioner in the criminal revision petition number 849 of 2018. In coming to the conclusion that the very transaction is doubtful. And also it is very clear that in the present case also she categorically admitted that transaction was with the mother only, and no transaction between this petitioner and the complainant, and amount was given to the mother and not in favor of this petitioner. Hence it is clear that the check which was in the hands of the complainant and made use of the same, and she categorically admitted that she only put the date to the said check, and mere check case in custody itself is not enough to come to the conclusion that there was a transaction taken place between both of them. In order to convict the accused under section 138 of Negotiable Instrument Act, the complainant has to prove the very legally recoverable debt, and the same has not been proved by the complainant. And both the courts have lost sight of the admissions given by the PW1 during the course of cross-examination, and also failed to take note of the strained relationship between the complainant as well as the accused. Since the complainant was a tenant under the mother of this accused, and with regard to the vacating of the premises in which she was residing as a tenant, also dispute was gone to the police station, and she has received the amount which she has paid in the police station itself, and thereafter she has vacated the premises. Under the circumstances, the trial court as well as the appellate court would have examined the material meticulously, and both the courts failed to take note of respective admissions on the part of the PW1. And when there is no any financial transaction between the complainant and the accused, and ought not to have invoked the section 138 of Negotiable Instrument Act, and also drawing the presumption only on account of the check contains the signature, cannot be a ground when the accused himself has rebutted the evidence of PW1 in the cross-examination. Even accused has not entered into the witness box to put forth his defense, and the same cannot be a ground as contended by the respondent, complainant, complainant counsel. And even if the evidence available on the record PW1, if it is sufficient that there was no any such transaction, that itself is enough to acquit the accused. And hence, I am of the opinion that both the courts have committed an error in convicting the accused for the offence punishable under section 138 of Negotiable Instrument Act. In view of discussions made up, I pass the following order. Revision petition is allowed. Judgment and judgment of conviction and sentence passed by the trial court as well as the confirmation made by the first appellate court are hereby set aside. The accused is acquitted for the offence pursuant to Section 138 of Negotiable Instrument Act. If any amount is deposited, is ordered to be refunded in favor of the petitioner on proper identification. ಅವ್ರೇನಾದ್ರು ದುಡ್ಡು ಡ್ರಾ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಡ್ರಾ ಮಾಡಿಲ್ಲ. Highly obliged madam.
Remaining matters 230.
Serial number 13 madam.
Serial number
13.
13. ಅವೆಲ್ಲ ಆಮೇಲೆ.
But the request for the cost to be waived.
ಹಾ ಆಗಿದೆಯಲ್ಲ, ಕಾಸ್ಟ್ ಹಾಕಿದ್ವಿ.
Cost waived.
No council, no. Next.
Permission. Serial number 48 in the final hearing.
48
of the final hearing, appear for the R1.
Final hearing,
R1, R5 ಇದೆ. ಅದರಲ್ಲಿ ನಮಗೆ
R125 BS ವಿಶ್ವನಾಥ್.
ಅದರಲ್ಲಿ ನಮಗೆ ಮಾಹಿತಿ yesterday came to my knowledge from one advocate. So I intimated my clients. So 10 days ಅವಕಾಶ ಕೊಟ್ರೆ ನಾನು I get the papers ಇಲ್ಲ ಏನಿಲ್ಲ ಸರ್. ಅದಕ್ಕೋಸ್ಕರ ಒಂದು 10 days ಬೇಕು.
ಇಲ್ಲ, ಏನ್ ನೀವು ವಕಾಲತ್ ಹಾಕ್ತೀರಾ?
ಇಲ್ಲ, ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ನಮ್ಗೆ ಮೆಸೇಜ್
ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ರಿ, BS ವಿಶ್ವನಾಥ್ ಇದಾರಲ್ಲ ಫಾರ್ R1 to R5.
I am also in record.
ನೀವು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ
My name is Dilkantaya. So
ನಿಮ್ಮ ಹೆಸರು ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ?
ಇಲ್ವಾ ಸರ್?
ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ
ಅದಕ್ಕೆ ಪ್ರೆಸೆಂಟ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಟು.
ಈಗೇನ್ BS ವಿಶ್ವನಾಥ್ ಬರಲ್ವಾ ಏನು?
ಇಲ್ಲ, ಬರ್ತಾ ಇಲ್ಲ ಸರ್ ಅವರು ನಮ್ಮ ಆಫೀಸ್.
ಲಾಸ್ಟ್ ಟೈಮು ಬಂದಿಲ್ಲ ಅವರು. ಇವತ್ತು ಇಟ್ಟಿದ್ದೀನಿ, ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್. ಅದಕ್ಕೋಸ್ಕರ ನನ್ನ ಹತ್ರ ಪೀಸ್ ಆಫ್ ಪೇಪರ್ಸ್ ಇಲ್ಲ ಸರ್. ನಾನು
ಸರಿ ರೀ, ನೀವೇನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
ನಾನು ಐ ಅಡ್ರೆಸ್ ಎ ಲೆಟರ್ ಟು ದಿ ಮೈ ಕ್ಲೈಂಟ್ಸ್.
ನೀವು
ನಾನು ವಿಶ್ವನಾಥ್ ಕೊಲೀಗ್ ಸರ್. ನಾನು
ವಿಶ್ವನಾಥ್ ಅವ್ರ ಕೊಲೀಗ್,
ನಮ್ಮ ಒಂದೇ ಆಫೀಸ್ ಸರ್. ಸೊ ನಾನು ಅಟೆಂಡ್ ಮಾಡ್ತಿದ್ದೆ, ಅವ್ರು ಗೊತ್ತಾ ಇಲ್ಲ ನನಗೆ.
ನೀವು ಈಗ ವಿಶ್ವನಾಥ್ ಅವ್ರ ಆಫೀಸ್ಗೆ ಹೋಗ್ತಿಲ್ವಾ?
ಈಗ ಇದ್ದೀನಿ ಸ್ವಾಮಿ, ಬರ್ತಾ ಇಲ್ಲ ಅವರು.
ವಿಶ್ವನಾಥ್ ಅವರೇ ಬರ್ತಾ ಇಲ್ವಾ ಆಫೀಸ್ಗೆ?
ನಾನು ರಾತ್ರಿ ವಿಚಾರ ತಿಳಿಸಿದ್ದೆ ಅವ್ರಿಗೆ. ಅವರೆಲ್ಲ ಬೇರೆ ಅವರು ಪರ್ಸನಲ್ ವರ್ಕ್ ಹೋಗಿದ್ದಾರೆ.
ನೀವು ಅವ್ರ ಕೊಲೀಗ್, ನಿಮ್ದು ಸಿಗ್ನೇಚರ್ ಇದೆಯಾ ವಕಾಲತ್ತಲ್ಲಿ?
ಇದೆ ಸ್ವಾಮಿ.
ಇದೆ ಮೇಡಮ್ ಫೈಲು. ಏನ್ ಟೈಮ್ ಬೇಕಾ ನಿಮ್ಗೆ? ವಕಾಲತ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ಏನೋ ನೀಲಕಂಠ ಏನಾಗಿದೆ ಅವ್ರು ವಿಶ್ವನಾಥ್ ಅವ್ರಿಗೆ? ಹುಷಾರಿಲ್ವಾ ಏನು?
ಹುಷಾರಿಲ್ಲ ಅಂತ ಕಾಣಿಸ್ಕೊಂಡು ಬರ್ತಾ ಇಲ್ಲ.
ಸೇಮ್ ಆಫೀಸ್ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಇದೆಯಾ? ಆಯ್ತು, ನೀವೇ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ವಕಾಲತ್ತಿನ ಮೇಲೆ
ಪೇಪರ್ಸ್ ಬೇಕಲ್ಲ ಸರ್? ವಿತೌಟ್
ಪೇಪರ್ಸ್ ನೀವು ಸೀನಿಯರ್ ಆಫೀಸ್ಗೆ ಹೋಗಲ್ವಾ? ಒಂದೇ ಆಫೀಸ್ ಅಂತೀರಿ?
ಹೌದು ಸರ್.
ಮತ್ತೆ
ಅದಕ್ಕೊಂದು ಅಟ್ಲೀಸ್ಟ್ ರಾಶಿಪ್ 10 days ಅವಕಾಶ ಕೊಟ್ರೆ.
ಅಲ್ಲ, ನೀವು ಅದೇ ಆಫೀಸಲ್ಲಿ ಇರ್ತೀನಿ ಇದೀನಿ ನಿಂತೀರಿ, ನಿಮ್ಮ ಹತ್ರ ಪೇಪರ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಇಲ್ಲ ಸರ್, ಫೈಲ್ ನಾವು ಅದಕ್ಕೋಸ್ಕರ ಸರ್.
ತಗೊಳ್ಳಿ, 48 ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ದಿ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ನೀಲಕಂಠಯ್ಯ seeks time to argue the matter on the ground that he is not having the brief with him and the other his colleague. ಏನೋ ನಿಮ್ಮಲ್ಲಿ ನೀವು ಹೋಗ್ತಾ ಇಲ್ವಾ ಆಫೀಸ್ಗೆ? ಅದೇ ಆಫೀಸಲ್ಲಿ ಇದೀರೋ ಇಲ್ವೋ ಏನು?
ನಾನು ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಸರ್, ಬರ್ತಾ ಇಲ್ಲ.
ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ.
ಟೆಕ್ನಿಕಲ್ ಗ್ರೌಂಡ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ ಸರ್ ಅವರು. ಅದಕ್ಕೋಸ್ಕರ ಬೆಳಿಗ್ಗೆ ಎಸ್ಟರ್ಡೇ ಕಾಲ್ ಅಪ್ ಅವನು
ಬಿಟ್ಬಿಡಿ. The counsel Sri Neelakantaya seeks time and hence another 10 days time is granted. List this matter on ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. RFA ದಿವಸ 8/4 ಮತ್ತೆ ಟೈಮ್ ಕೊಡೋದಿಲ್ಲ. ಲಾಸ್ಟ್ 2 occasions ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ನೀವು, ಆಯ್ತಾ? ಇದು ಪಾರ್ಟ್ 2 ಸರಿ ಹೇರ್ ಮಾಡಿ. ನಿಮ್ಗೆ ಫೈನಲ್ ಅವಕಾಶ ಕೊಟ್ಟಿದ್ವಿ.
10ನೇ ತಾರೀಕು.
ಯಾವ 10ನೇ ತಾರೀಕು?
10/4.
ಬರೋದಿಲ್ಲ, RSA ಇರೋದು ಅವತ್ತೇನೆ 8ನೇ ತಾರೀಕು. ಇಲ್ಲ ಅಂದ್ರೆ ಮುಂಚಿನ ಡೇಟ್ ಯಾವತ್ ಬೇಕು ಹೇಳಿ. 8 ಇಲ್ಲ 10 ಬುಧವಾರ ಮಧ್ಯದಲ್ಲಿ ಬರುತ್ತೆ. ಆಯ್ತು, 10ನೇ ತಾರೀಕು. 10ನೇ ತಾರೀಕು ಬಟ್ ಅದು ಕ್ರಿಮಿನಲ್ ಡೇ ಆಗೋದಿಲ್ಲ. 8/4 15/4 ಆಗೋದಿಲ್ಲ ಮೇಡಮ್. ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ಯಾವ್ದನ್ನು ಇಟ್ಕೊಳ್ಳೋದಿಲ್ಲ ವೆಕೇಶನ್ ಅಲ್ಲಿ. ವೆಕೇಶನ್ಗೆ ಹೋಗೋಕ್ ಮುಂಚೆ ಎಲ್ಲ ಬರೀಬೇಕು ಜಡ್ಜ್ಮೆಂಟ್. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ 1ನೇ ತಾರೀಕು ಅಥವಾ 2ನೇ ತಾರೀಕು ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? 1, 2 ಬೇಕಾ 8 ಬೇಕಾ ಯಾವತ್ ಬೇಕು ಹೇಳಿ? 15 ಕೊಡೋದಿಲ್ಲ. ಆಚೆ ಕುಡಿಯೋದೇ 8 ದಿವಸ. ನಾನು ಯಾವ್ಯಾವ ಹಿಯರ್ ಮಾಡ್ತೀನಿ ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದೋಗ್ತೀನಿ ಬಿಫೋರ್ ವೆಕೇಶನ್. ನಾನು ಯಾವ್ದು ಇಟ್ಕೊಳ್ಳೋದಿಲ್ಲ. 8ನೇ ತಾರೀಕು ಆಗ್ಬೋದಾ? 8/4.
Please your lordship, in this matter,
Hmm.
I appear for respondent number 6. I have
You already
already argued
ಹೇಳಿದಿರಲ್ಲ.
the matter and
ನೀವು ಆಲ್ರೆಡಿ ಹೇಳಿದಿರಿ. ನೀವು ಮತ್ತೆ ಇನ್ನಾರು ಒಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
appellant
ಸೈಡ್
counsel.
ಅವ್ರದ್ದು ಮಾತ್ರ ಇಟ್ಟಿದೀವಿ ಇವತ್ತು.
ಆಯ್ತು.
ಇವತ್ತೇನೋ ಟೈಮ್
My presence may be dispensed with on the next date of hearing.
ಆಯ್ತು.
serial number 61.
ನೀವ್ಯಾರು?
Petitioner.
ಪಿಟಿಷನರ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಮತ್ತೆ ನಿಮ್ ಲಾಯರ್ ಇಲ್ಲಿ?
Advocate actually medical emergency ಅಂತ ಹೋದ್ರು ಸರ್ ಇದ್ರು actually.
I appear for the respondent. I strongly oppose. ಯಾಕಂದ್ರೆ there is a direction by this court wherein he is directed to bear the medical expenses of the mother, which has been not done. Memo after memos have been filed.
ಆಯ್ತು. ನಾಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಯು ಬ್ರಿಂಗ್ ಯುವರ್ ಲಾಯರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡೋದಿಲ್ಲ ಡೇಟ್. ಅವ್ರು ಅದರ್ ಸೈಡ್ ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Serial number 53 my lordship.
53 ಹೇಳಿ ಏನಾಗ್ಬೇಕು ಅನ್ಸಲ್?
For the amicus curiae my lordship.
ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆದ್ರೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು ನಿಮ್ಮನ್ನ ಏನು ಕೇಳಿ? ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು ಏನಕ್ರಿ? ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಇಸ್ ನಾಟ್ ಅಸಿಸ್ಟಿಂಗ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ನಿಮ್ಮನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು. ವೈ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಟೈಮ್?
1 week
ನಾಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
prepare for that.
2018 ಮ್ಯಾಟರ್.
To prepare for
ಆಲ್ಮೋಸ್ಟ್ ಇಲ್ಲ, ನಾನು ಆಲ್ಮೋಸ್ಟ್ ರೀಚ್ ಆಗಿದ್ದೀನಿ. ಇನ್ನು ಇರೋದೇ ಸ್ವಲ್ಪ ಒಂದು 10
next week
ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅಷ್ಟೇ.
any next week my lordship. 28.
ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. 51 ಅಲ್ಲಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ವಾ? ಯಾವ್ದು ಹೇಳಿ? ಅವ್ರದಾ? ಫೀಸ್ ರೆಸ್ಪಾಂಡೆಂಟಿಗೆ. ತಗೊಳ್ಳಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿಗೆ ಫೀಸ್ 5,000 ಕೊಡಿ. ಅವ್ರು ಯಾರೋ ಉಮೇಶ್ ಅಂತಾರ ಇದ್ರು ನೋಡಿ, PB ಉಮೇಶ್.
Can I'm so sorry, ma'am. Serial number 40,
ಏನಾಯ್ತು? 40
230 have some difficulty, ma'am, today. Can I request?
ನಿಮಗೆ ಮಾರ್ನಿಂಗು ಡಿಫಿಕಲ್ಟಿ, 2:30ಗೂ ಡಿಫಿಕಲ್ಟಿ.
ಆ
ಮತ್ತೆ
ಥರ-
ಇನ್ಯಾವಾಗ ಇಯರ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಯಾರು? ಅವಿನಾಶ್ ಕೂಡ GS 227 ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ.
ಅದೇ ಅಲ್ಲಿ ಟೋಟಲ್ 1 ಅಲ್ಲಿ ಇನ್ನು ನಡೀತಾ ಇದೆ.
ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ?
Can I request?
ಕೋರ್ಟಲ್ಲಿ ಒಂದಲ್ಲ ಇದ್ಬಿಡಿ. ನಮ್ಮ ಕೋರ್ಟ್ಗೆಲ್ಲ ಯಾಕೆ ಬರ್ತೀರಿ?
ಇಲ್ಲ, ನಾವು ನಿಮ್ ಕೊಡ್ಗೆ ಎಲ್ಲ ಬಂದು ಇಲ್ಲೇ ಮಾಡಿದೀವಿ.
ಹಾ.
ಒಂದೊಂದ್ಸತಿ ಈ ತರ ಪ್ರಾಬ್ಲಮ್. Can I request for 3rd or 4th?
ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರ?
ಅವ್ರು ಹೇಳ್ತೀನಿ.
ಲೋಕಾಯುಕ್ತ
I'll inform them.
ಯಾರು? ಸ್ಪೆಷಲ್ ಲೋಕಾಯುಕ್ತ ಯಾರು? ಪ್ರಸಾದ್.
ಪ್ರಸಾದ್ಗೆ
ಹಾ.
ನಾನು ಹೇಳ್ತೀನಿ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ನೋಡೋಣ, ಆಮೇಲೆ ನೋಡೋಣ.
ಆಯ್ತು.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿಸಿ.
ಆಯ್ತು.
ಕೊಲಿಗ್ ಕೇಳ
With
2:30.
kind permission, my lord. 58ನೇ ಮ್ಯಾಟ್ರ್ ಏನ?
ಹೇಳಿ ಏನಾಗ್ಬೇಕು ನಾಯಕ್ ಹೇಳಿ.
ನಾನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಹೌದು.
ಅದರಲ್ಲಿ RF
ನೀವ್ಯಾಕೆ ಕ್ಲೇಮ್ ಕೇಳ್ತೀರಿ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ RFA ಇದೆ. ಅದಕ್ಕೋಸ್ಕರ. ಹೌದು.
My lords, for the petitioner in that serial number 58.
58 ಇನ್ನು ಬಂದಿಲ್ಲ, ರೀಚ್ ಆಗಿಲ್ಲ. ನೀವ್ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀರಿ? ಅದರ್ ಸೈಡ್ ಇದಾರ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಅವ್ರಿದ್ರೆ ರೆಡಿ.
ಬಂದ್ಲಿ ನೋಡ್ಲಿ ಹೇಳಿ ಏನು?
53.
53 ತಗೊಳ್ಳೋಣ ರೀ. ಈಗ ಆಲ್ರೆಡಿ 51 ಅಲ್ಲಿ ಇದೀವಿ ಅನ್ಸುತ್ತೆ. ಎಲ್ಲಿದ್ದೀವಿ ಮೇಡಮ್? 51 ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 52 ಇದೆ. ತಗೊಳ್ಳೋಣ, ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳೋಣ ಪ್ಲೀಸ್.
ಅದು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಇರ್ಬೇಕಲ್ವಾ?
Sorry. A3 correct. A2 and 4 is like.
Sorry, ಇದೆಯಾ? Announcement.
Pronouncement of judgment at 2:30, 69. B. Rupesh.
Appeal is dismissed.
Seventy. B. M. Siddhappa.
Second appeal is dismissed. ಹಿಂದಿನಲ್ಲಿ ಬರೀ ಅಪೀಲ್ ಅಂತ ಮಾಡಿದ್ದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಂತಿದೆ ನೋಡಿ. ಮೋಸ್ಟ್ಲಿ ಅಪೀಲ್ ಅಂತಿದೆ. ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಯಾರು?
71.
Appearing for respondent.
The second appeal is allowed to include judgment and decree dated 18/12/2008 passed in OS number 99 of 2006 by the trial court, and the judgment and decree dated 24/1/2011 passed in RA 10 of 2009 by the first appellate court are set aside, and consequently the suit of the appellant plaintiff is decreed as prayed for. In view of the disposal of the main appeal, IA, if any, does not survive for consideration, and the same stands disposed of. 2:30, thrown.
Orders at 2:30, 66.
ಏನು? ಅಂದ್ರೆ ಕೇಸೇ ಬೇರೆದ್ ಬಂದಿದೆಯಾ?
ಇಲ್ಲ, ಫೈಲ್ ಕರೆಕ್ಟ್ ಬಂದಿದೆ, ಹೆಸರು ಬೇರೆಯವ್ರು ಫೈಲ್ ಕರೆಕ್ಟ್ ಫೈಲ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿದೆ, ಹೆಸರು ಬೇರೆಯವ್ರು ತೋರಿಸಿ.
ಅವ್ರದ್ದೇನೆ. ಈ 4:30 of 23 ರಿಜೆಕ್ಟ್ ಆಗೋಗಿದೆ. ಆಯ್ತು. ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ, ಫೈಲ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿದ್ಯಾ? 24. ಬಟ್ ಕೌನ್ಸಿಲ್
ನಾನು ತಗೊಂಡ್ಬಂದಿದ್ದೀನಿ ಫೈಲ್.
ಅವ್ರು ತಂದಿದಾರೆ. ಲತೀಫ್ ಫೈಲ್ ಇದು. ಆಯ್ತಾಗಾರೆ ಇಬ್ರು ತಂದಿದ್ದೀರಾ ಫೈಲ್?
ಈಗ ಬಂದೆ ಫೈಲ್, ಈಗ ಬರ್ತೀವಿ. ಈಗ ಬಂದೆ
ಸೇಮ್ ಕೇಸ್ ಕನೆಕ್ಟೆಡ್ ಆಲ್ರೆಡಿ ಒಂದ್ ಕೇಸ್ ಬಂದಿದೆ, ಅದರದ್ದು ಸೇಮ್ ಕೇಸ್ ಇದೆ, ಇನ್ನೊಂದ್ ಕೇಸ್ ನೋ ಅದರ್ ಅದೇ ಕ್ರೈಮ್ ಅಲ್ಲಿ ಇನ್ನೊಂದ್ ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಆಲ್ರೆಡಿ.
ಅದೇ ಕ್ರೈಮ್ ಅಲ್ಲಿ ಇನ್ನೊಂದ್ ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗಿತ್ತ?
ಆಗಿತ್ತು.
ಅಲ್ಲ ಆಯ್ತು, ಬಟ್ ಅವ್ರು ಹೇಳೋದು ಈಗ ಫೈಲ್ ಬಂದಿದೆ ಅಂತ. ನೀವು ಕರೆಕ್ಟ್ ಫೈಲ್ ತಂದಿದ್ದೀರಿ.
ಅವ್ರಿಗೂ ಇನ್ನೊಂದ್ ಕೇಸ್ ಬಂದಿತ್ತು ಕನೆಕ್ಟೆಡ್, ಇನ್ನೊಂದು
ಇವತ್ತೇ ಇದೆಯಾ?
ಇವತ್ತೇ
ಇದೆಯಾ? ಗೊತ್ತಾಯ್ತು, ಹೇಳಿ ನೋಡಿದ್ರೆ.
ಇವ್ರು
ಏನ್ ಪಾಸ್ವರ್ಡ್ ಬೇಕಾ? ನೋಡ್ತೀರಾ? ಆಯ್ತು, ಪಾಸ್ವರ್ಡ್.
67.
67 ಅದೇ ಸೇಮ್ ಅಂತಾರಲ್ಲ ಅವರು. ಎರಡು ಕನೆಕ್ಟೆಡ್ ಎರಡು ಕನೆಕ್ಟೆಡ್ ಎರಡು ಪಾಸ್ ಓವರ್ ಆಯ್ತು.
Further hearing 68,
I have for the petition.
Shanti Bhushan.
Please.
ಏನಾಯ್ತು ಇದ್ರಲ್ಲಿ?
It says, my lord,
ಆಂಫೆಟಮೈನಾ ಅಥವಾ ಬೇರೆದ?
last
MDMA ಅಲ್ಲ.
MDMA Allah, my lord, your
ಆಂಫೆಟಮೈನಾ.
amphetamine.
Ah.
Your lordship had asked, out of 21 grams,
Ah.
why only 10 grams was sent?
Ah.
The remaining is here, my lord. It is there in the custody, my lord.
Huh?
Sorry.
Oh, only out of that 20, out of 21 grams, only sample sent.
Please.
Correct?
Please, my lord, please.
ಸರಿ, ಕೊಡಿ. ಮೇಡಮ್ ಮೋಸ್ಟ್ಲಿ ನೀವೇ ಮಾಡಿರೋದು ಇದು. ಅಲ್ಲಿಗೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಕಮರ್ಷಿಯಲ್ ಕ್ವಾಂಟಿಟಿ ಅಲ್ಲ ಅದು.
No.
And hence the petitions has to be dismissed. ಟೈಪ್ ಆಗಿರೋದು. ತಾಳಿ ಮೇಡಮ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಳ್ಳಿ. ಅರ್ಧ ಟೈಪ್ ಮಾಡಿದ್ವಲ್ಲ ಅದು. The main contention of the counsel appearing for the petitioners is that the trial court committed an error in granting the bail. And in spite of the seized contraband, 21 grams of MDMA. And the said contention cannot be accepted. This court has secured the FSL report. And FSL report is very clear that though the same was seized as MDMA of 21 grams, and FSL report is very clear that the same is not an MDMA and this same is amphetamine. And the trial court rightly comes to the conclusion that the same is a intermediate quantity. And in case of amphetamine, 50 grams is the commercial quantity. And when searching the case, and also on perusal of the FSL report, only portion of the 21 grams of alleged MDMA was seized, was sent to the FSL, and the report is very clear that the same is not the manufactured drug of MDMA. And when searching the case, when the FSL report is very clear that the same is a amphetamine, and question of invoking section 439 subclass 2 of CRPC for cancellation of bail doesn't arise. And hence I do not find any merit in the petitions to invoke section 439 up to 439 subclass 2 of CRPC to comes to a other conclusion, and the trial court rightly exercised its discretion, having taken note of the FSL report. The other seized articles are also not the commercial quantity, and hence no merit in the revision petitions. In view of the discussions made up, I pass the following order. Revision petitions are dismissed. That's all.
Password matter, serial number 5.
Great. ಏನಾಯ್ತು? ಬಂದಿದ್ಯಾ? ಈಗ ತಂದು ಕೊಟ್ಟಿದಾರಾ?
ಅಭ್ಯಾಸ petition.
ಹಾ. ನೋಡ್ರಿ ರಿಜಿಸ್ಟ್ರಾರ್, you see that if any records are called, you should send immediately. ಎಲ್ಲ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ಸ್ ಅಪೀಲ್ ಎಲ್ಲ ಬರ್ತದೆ ರೆಕಾರ್ಡ್ಸ್, ನಿಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ. ನೋಡಿ, you examine. ಫಸ್ಟ್ ಹೋಗಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ನಿಮ್ ಕನ್ಸರ್ನ್ಡ್ ಎಂಪ್ಲಾಯೀಸ್ ಕೈಲಿ ಯಾವ್ಯಾವ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫರ್ ಆಗಿದೆ, ಯಾವ್ಯಾವ ರೆಕಾರ್ಡ್ಸ್ ಕಳ್ಸಿಲ್ಲ. ಇಮಿಡಿಯೇಟ್ ಯು ಸಿ ದಟ್ ಆಲ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ಸೆಂಟ್. ಆಯ್ತು, ಹೋಗ್ಬೋದು ನೀವು. ಹಾ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್. ಏನ್ರಿ ರೆಡಿ ಇದ್ದೀರಾ? ಶಾರ್ಟ್ ಟೈಮ್ ತೊಗೊಳ್ಳಿ. ದಿ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ರಿಸೀವ್ಡ್ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಎರಡು ಇಬ್ರು ಇದ್ರಲ್ಲ, ಬೋತ್ ದಿ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಅಂಡ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವಾಗ್ರಿ 8/4 8/4 ಪ್ಲೀಸ್ 8/4. 32 ಇದೇನು ಅವೈಟೆಡ್ ಕಳಿಸ್ತೀವಿ ಅಂತ ಹೇಳೋರ. The TCR is awaited and the registry is directed to issue reminder. Nodi, if need arises, issue reminder if need arises. Serial number is to 32.
35.
35 also same, man?
Alla 35 one submission, my lord. Last
Adu-
date
adu
I,
eight-
I have taken time.
Second 84 KD. 35 lena?
35 I sought time to get the certified copy. ಅಲ್ಲಿ ನನ್ನ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಗಿದ್ರೆ ಬೇರೆ ಯಾವ್ದೋ ಫೈಲ್ ಬಂದು ಇದು ಜಾಯಿಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಈಗ TCR ಆಗಿ.
ಈಗ TCR ಬಂದಿದ್ಯಾ?
ಅಲ್ಲ, TCR ಇನ್ನೂ ಆಗಿಲ್ಲ. ಹಳೆ TCR ಯಾವ್ದೋ ಫೈಲ್ ಬಂತು. ನಾನು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿ ಅದಕ್ಕೆ ಟ್ಯಾಲಿ ಆಗ್ತಲ್ಲ ಅಂತೇಳಿ ಈಗ TCR ಅಂತೇಳಿ ಇದೆ ಬೈ. ಲಾಸ್ಟ್ ಡೇಟ್ I sought the time to get the certified copy. ಅಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡೋದು I came to know.
ಅಲ್ಲ, ಅಪ್ಲೈ ಮಾಡಿದಾಗ ಬೇರೆ ರೆಕಾರ್ಡ್
ಬೇರೆ ಯಾವ್ದೋ ಫೈಲ್ ಬಂದಿದೆ.
ಆಯ್ತು, ಈಗ ನೋಡೋಣ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಯಾವ್ದು ಬರುತ್ತೆ ನೋಡೋಣ.
ಆಯ್ತು,
await TCR. List this matter on 8/4. And
8/4
also
both the
and issue reminder.
my lord 16th
If records are not received. ಯಾವತ್ತು?
ಎರಡು ಕೂಡ 16th
ಯಾವಾಗ?
16/4.
16/4 ಬರಲ್ಲ. ಅದೇನಿಲ್ಲ.
ಅಲ್ಲ 15/4.
RSA day 18/4 ಆಗ್ಬೋದಾ?
18/4. both the matter.
ಎರಡೂನಾ?
First matter ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್, ಸೆಕೆಂಡ್ matter petitioner.
32 and 35.
32 and 35.
ಎರಡೂನು.
32 ಅಲ್ಲಿ ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್.
ಆಯ್ತು, 18/4. ಎರಡು ಅವೈಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ 18/4.
40. ಅವಿನಾಶ್ ಗೌಡ GS.
ಏನಾಯ್ತ್ರಿ? ಅದರ್ ಸೈಡ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರ? ನಾನು ನಿಮಗೆ ಹೇಳ್ತೀನಿ ಇದ್ರು, ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು ಬೆಳಗ್ಗೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಲೋಕ ಆಗ್ತಾ.
Please, fourth, have it on fourth, my lord.
Have it on 4th. Totally. Petitioner counsel seeks time and counsel also for the respondent present. List this matter 4th. 4/4 ಅಲ್ಲ ಮೇಡಮ್? ಆಯ್ತು, 4/4. ಅವತ್ತು RSA ನಾ ಏನಾದ್ರು ಇನ್ನೊಂದೇ. ಆಯ್ತು.
52. BB Shivkumar.
For the respondent, my lord. 138 of NA Act.
138 ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ?
Fine amount is 12,05,000, my lord.
ಹಾ,
Trial court of the accused got
ಕಟ್ಟಿದಾರ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಇತ್ತು. There is an element of settlement and submits that he has already informed the learned counsel for the petitioner ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡಿದ್ರು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಈಗ ಆರ್ಡರ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿದಾರ?
not, my lord.
ಹಾ,
No, my lord.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ ನೋಡಿ. ಆರ್ಡರ್ 23/2/2017. 25% ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು. ಯಾವ್ದು ಡೆಪಾಸಿಟ್ ಏನು ಇಲ್ವಾ? ತೊಗೊಳ್ಳಿ. The counsel for the respondent submits that the revision petitioner has not complied the order dated 23/2/2017. And this court also has perused the order sheet of the trial court. And also there is no any endorsement for having made the deposit in terms of the order dated 23/2/2017. The counsel for the revision petitioner is also absent. And hence the respondent is given liberty to proceed against the petitioner in view of non-compliance of the order of suspension of sentence. List after 4 weeks.
One kind submission, my lord. Earlier advocate name is still showing on record. Earlier advocate Ashok Kumar name is still showing on record, madam. Kindly the
That has to be deleted.
Yes, madam.
So registry is directed to delete the name of counsel B Ashok Kumar since counsel Suresh
Chotian
has filed wakalat for respondent.
much obliged.
53 Srinivas R. Amicus Curie ಇವ್ರೇನು ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ರಿ? Amicus Curie
ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತೀವಿ.
ಆಯ್ತು, ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡೋಣ. The amicus curiae seeks time and counsel for the respondent is present. Finally, list this matter on your date for madam.
5-4.
5-4.
54 urgent, 55.
55. Siddharth
Siddharth
Suman.
T.
T.
Srinivasan.
Srinivasan. Recalling filed by petitioner counsel. ಏನದು? IA 1/24.
My lord, in this case,
Recalling filed by petitioner counsel. ಏನ್ recall ಮಾಡಿ?
ಇದು final hearing ಎಲ್ಲ ನೋಡ್ಬೋದು ಅಂತ last time ನಾವು.
Huh?
IA to be heard along with mine ಅಂತ.
ಏನ್ IA ಏನದು?
ಅದು ಅದರಲ್ಲಿ without hearing the petitioner,
ಹಾ.
amount order to be released as is evident from the order, my lord.
ಹಾ.
We have filed objections also, not noticed.
ಕೊಡ್ರಿ ಅದೇನ್ ನೋಡೋಣ. ಈಗ ರಿಲೀಸ್ ಆರ್ಡರ್ ಆಗಿರೋದಾ?
Release order ಆಗಿದೆ.
ದುಡ್ಡು ತಗೊಂಡಿಲ್ಲ ಅವ್ರು ಇನ್ನು?
ಇಲ್ಲ ತಗೊಳ್ಳಿಲ್ಲ.
ಹಾ?
ತಗೊಳ್ಳಿಲ್ಲ.
ಅಲ್ಲ ರಿಲೀಸ್ ಆರ್ಡರ್ ಅದು?
ರಿಲೀಸ್
Release order.
ನಿಮ್ ತಕರಾರ್ ಹಾಕಿದ್ರೆ ಅದನ್ನ ಕನ್ಸಿಡರ್
ಹೌದು,
ಆಗಿಲ್ಲ.
ಹೌದು.
ಆಯ್ತು ಕೊಡಿ ತಗೊಳ್ಳಿ. ಈಗೇನ ಅಯ್ಯ ಹಾಕಿದಾರಲ್ಲ ಅದು. ಏನ್ ನಿಮ್ ತಕರಾರ್ ಏನ್ ಕೌನ್ಸಿಲ್?
ಅದು ಅವತ್ತಿನ ಇದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಮಧ್ಯಾಹ್ನ 2:15 ಇತ್ತು ಸ್ವಾಮಿ.
ಹಾ.
ಇದ್ದಾಗ ಅದು ಬೇರೆ ಮ್ಯಾಟರ್ ತಗೊಂಡಿದ್ರು, ಇದು ತಗೊಳ್ಳೋ ಚಾನ್ಸ್ ಇಲ್ಲ ಅಂತ ನಾನು 14ನೇ ಕೋರ್ಟ್ ಹೋಗಿ ಬರೋದ್ರಲ್ಲಿ
ನೀವೆಲ್ಲ ಬೇರೆ ಕಡೆ ಹೋದ್ರಿ?
ಇಲ್ಲಿ 14ನೇ ಕೋರ್ಟ್ ಬಂದೆ. ಅಷ್ಟೊತ್ತಿಗೆ ನಮ್ದು ಅಬ್ಜೆಕ್ಷನ್ ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ.
ಆಯ್ತು ಅಲೋ ಆಗಿದೆ ಅಲ್ವಾ? ರಿಕಾಲ್ ಮಾಡೋಣ. ಏನ್ ಗ್ರೌಂಡ್ಸ್ ಏನ್ ಹೇಳಿ?
ಅಲ್ಲ
ಗ್ರೌಂಡ್ಸ್ ಇದ್ರೆ ರಿಕಾಲ್ಗೆ ಮಾಡೋಣ.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ನಿಮ್
there is no legal enforceable liability
ಹಾ.
on the day where the respondent says that I have issued the check. I was not even in India, my lord. I was not even in India. That is evident from the NI D5. I produced it before the trial court.
ಯಾವಾಗ ಚೆಕ್ ಕೊಟ್ಟಾಗ್ಲಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಹಾ. ನೀವು ಆಂಟಿ ಡೇಟ್ ಹಾಕಿ ಚೆಕ್ ಕೊಟ್ಟು ಫಾರಿನ್ಗೆ ಹೋಗಿರ್ಬೋದು.
ಅಲ್ಲ ಚೆಕ್ಸ್ ಕೊಟ್ಟಿದ್ದು ನಾನು ಡಿನೈ ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ. ಚೆಕ್ ಹ್ಯಾಡ್ ಗಿವನ್, signature is mine, there is no dispute. What the respondent claim is that on 14/3/2019, I went to her residence, I gave the checks, I received the consideration. Everything is false. There is no legal
On that day you were
on
not
that
in
day,
the
my lord.
country ಅಂತ.
Yes, my lord.
ಏನ್ರಿ?
My lords may kindly peruse exhibit D5. That exhibit D5 says that on that day he was abroad. But actually at what time he came back to India, we don't know. It is the contention of this complainant that between 12 and 1 o'clock he had sought for the loan as such. They don't deny they were not there at that particular point of time also, that is not denied as such. They don't deny at what
Whether they have taken the defense before the trial court while cross-examining the witness.
Please, my lord.
they don't take that defense.
no,
They
where-
don't say on that particular day at
Put
that
it,
particular
deposition,
point
put
of
it.
time.
ಆಯ್ತು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳೋಣ ಬಿಡಿ.
ಹೌದು ಸ್ವಾಮಿ. ಅದು ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ರೆ ಐ ವಿಲ್ ರೀಡ್ ಆರ್ಗ್ಯೂ ಫಾರ್ ಫೈನಲ್.
ಆಯ್ತು ನೋಡಿ ಇದನ್ನ IA 1/24 will be considered along with the main petition ಅಂತ ಹಾಕ್ಬಿಡಿ.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
And list this matter for final hearing on ಯಾವತ್ ಬೇಕು ಇಬ್ರು ಹೇಳಿ. ಓದ್ಕೊ ಬನ್ನಿ.
15ನೇ ತಾರೀಕು.
ಓದ್ಕೊ ಬನ್ನಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ.
15ನೇ ತಾರೀಕು.
15th ಅಷ್ಟು ದಿವಸ ಹಾಕ್ಬೇಕು ನಿಮ್ಗೆ?
ಇದು 4th 5th ಮದುವೆ ಇದೆ, ಊರು ಹೋಗ್ತೀನಿ ಅಂತ. ಆಮೇಲೆ ಒಂದೇ ದಿನ 8th ಇರೋದು ಸ್ವಾಮಿ.
15th ಅದು RSA ಡೇ.
ಸರಿ.
15th ಕೊಡಕ್ಕಾಗಲ್ಲ. ಮದುವೆ ಇರೋದು ಯಾವಾಗ?
ಇದು 4-5 ಇರಲ್ಲ, ಹಾಗಾಗಿ
8 ಅಥವಾ 10 ಹೇಳಿ ಯಾವತ್ ಬೇಕು?
8ನೇ ತಾರೀಕು ಒಂದೇ ದಿನ ಇದೆ ವಾರಲ್ಲೇ.
8 ಬೇಡ 10ನೇ ತಾರೀಕು.
ಸರಿ ಸ್ವಾಮಿ.
10th
ಮಚ್ ಪ್ಲೀಸ್.
10/4.
56. H.C. Shivaramu.
Venkatesh TS.
Morning, I make a submission, madam. Kindly, day accommodation in this matter. Morning, I make.
Why you want time? Other side ilva?
Morning irliಲ್ಲ.
Petitioner counsel seeks time and respondent counsel is absent. List this matter on ಯಾವಾಗ ಬೇಕು? When do you want?
Any date, madam.
5-4.
5/4 madam? 5/4.
57. Pratima SK.
Pratima SK. G.
Chandrasekhar.
Chandrasekharayya. 138.
ಇಲ್ಲ ಸ್ವಾಮಿ. Domestic violence.
Domestic violence. Good.
The last occasion, just one submission. I had informed the council and then only taken an adjournment. I was not well, she took. But ಅವ್ರೇನೋ ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂತ ತಪ್ಪು ಹೇಳಿದ್ದಾರೆ. That is really wrong. I had informed him, sent him a message also. That is reflecting in this thing song.
ಬೇರೆ ಡೇಟ್ ಅಂತ ಪ್ರಿಪೋನ್ ಮಾಡಿದ್ವಿ. ನೀವ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರ ಅವರಿಗೆ?
ಹೌದು, ಮೆಸೇಜು ಇದೆ.
ಅವ್ರು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದು ಮಂಡೇ ಅಂತ ಮೈ ಲಾರ್ಡ್. ಆದ್ರೆ ಕೋರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು 3-4 ಏಪ್ರಿಲ್ 3rd.
ನಾನೇನು
ನನಗೆ ಏನು ಅಂದ್ರೆ
ಏನ್ ಹೇಳಿದ್ರಿ?
Speed-
ಇನ್ಫಾರ್ಮೇ ಮಾಡಿಲ್ಲ ಅಂದ್ರಿ.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದರೆ ಬಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಸ್ ನಾಟ್ ಕರೆಕ್ಟ್.
ನೋಡ್ರಿ
ಇದು
ನೀವು
ಫಾಲ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್.
ನೋ ನಾಟ್ ದಟ್ ಫಾಲ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್. ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡುವಾಗ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ಟೈಮ್ ತಗೊಳ್ತೀನಿ.
ನನಗೆ
ನಾವು ಕೋರ್ಟ್ ಕನ್ವೀನಿಯಂಟ್
ಟೆಲಿಫೋನಿಕರಿ ಅವ್ರ ಜೂನಿಯರ್
ನಾವು
ಮಾತಾಡ್ತಾರೆ ಮೈ
ಕೋರ್ಟ್
ಲಾರ್ಡ್.
ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ.
ಅಷ್ಟೇ.
ನಿಮಗೆ ಅವ್ರು ಮೂವ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರ ಇಲ್ಲ?
ನಾನು ಅವತ್ತು ನಂದು 70th ಮ್ಯಾಟರ್ ಇತ್ತು, ನಾನು ಲೇಟ್ ಬಂದೆ ಮೈ ಲಾರ್ಡ್.
ಬೇಡ, ನೀವು ಮಧ್ಯಾಹ್ನ ಬಂದೇನು ಹೇಳಿದ್ರಿ? ನನಗೆ ವಿತೌಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಡೇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಟೇಕನ್ ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ.
previous
Truly,
night itself
truly.
a message.
ಬಟ್ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದು ಮಂಡೇ ತಗೋತೀವಿ ಡೇಟಾ ಅಂತ.
ಹೌದು, ನಾನ್ ಮಂಡೇನೆ
ಅವ್ರು ಮಂಡೆಗೆ
ಮಂಡೇನೆ ಅವ್ರು ಕೇಳಿದ್ ಪಾಪ.
ಡೇಟು ಯಾಕೆಂದ್ರೆ ನಮ್ಮ ಡೈರಿ ನೋಡ್ಕೊಂಡು ಕೊಡ್ತೀವಿ ನಾವು.
She sought for
ನೀವ್
Monday.
ಯಾಕೆ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿ? ನನಗೆ ಇಂಟಿಮೇಷನ್
My lord, if at all it is a false submission, I truly apologize this honorable court. If at all it is a false submission, they asked for Monday, but the court has given on 3rd, 4th.
You said in the afternoon that no information is given
Truly, my lord,
without giving any intimation, date was taken ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ.
truly, my lord, the 3-4 was not my consent.
ಯಾವತ್ತು
Only Monday was my consent.
ಮೇಡಮ್ ತೊಗೊಳ್ಳಿ ಮೇಡಮ್.
That's true.
I'm okay.
Because of their insistence, persistence, I agreed for it.
ಅವತ್ತು ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನಾವು?
3-4 ಕೊಟ್ಟಿದ್ದು ಸ್ವಾಮಿ.
3-4.
Any date.
Post this matter on 3-4.
Great.
My lord, it is a,
ಆಲ್ರೆಡಿ ಇದೆಯಾ?
my lord, is a 2019 case, my lord. It is a maintenance regarding maintenance of a woman.
Counsel, whatever it may be, you are an officer of the court. Once other side has given an intimation to you that they are going to move an adjournment, as a officer of the court, you would not have made the false submission before the court saying that you have not been intimated. I believed your words.
That's
That's
true.
the reason I preponed it, because other side took the date without intimation to you. I believed you are an officer of the court. I believed your words.
My lord, I'll convince,
Not happen in future. That's all.
my lord, kindly listen to me. They asked for Monday.
Counsel,
I was not
I made it clear. Even if any counsel seeks adjournment for particular date, this court will not grant the time. As per the convenience of the court only, we will give the date. Even anybody comes and requests.
Now we
for
both
the
are
date.
present. Kindly listen to us, my lord.
Is this matter on 3-4 only?
Is the,
Don't make submission on the other, in the instance of in the absence of the other side.
if at all that happened,
False submission.
that all happened as a false submission, kindly I'll apologize for that.
Whatever it may be, I will hear the matter on 3-4. That's all. Great. Post the matter on 3-4.
58. Prashant BK.
For petitioners, my lord.
Yes, ಇದ್ರಲ್ಲೇನೋ ನಾಯಕ್ ಅವ್ರು ಏನೋ ಕೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ? ಹೌದಲ್ಲ ಮೇಡಮ್? ಹಾ.
Please, my lord.
ಇದಾರಲ್ಲ ಇಬ್ರು.
Sorry.
Yes, counsel, ಹೇಳಿ.
My lord, in this present revision petition, the petitioner is challenging the order of the learned magistrate, where the learned magistrate has refused to take cognizance of an offense under section 499 and 500 of IPC. My lord, in this case, the respondent has defamed the petitioner company in LinkedIn and has posted various malicious and scandalous statements in the LinkedIn posts. My lords, before going,
Where is your complaint?
my lord, it's in page number 33.
33. Go to relevant paragraph. What is the defamatory statements?
My lords, the defamatory statements made are produced in page number 15 along with the type copy.
15.
15. If I may,
14.
if I may read,
Typed copy.
my lords, if I may read the relevant paragraph. Hi, NNR Global Logistics team. After a long time, I had come again through LinkedIn because as per previous allegation against Mr. Parantaman, what he made allegations against me is false, baseless. Court refused his allegations against me because it was fake and false.
I have won the case through labor court and as per attached order, NNR has to reinstate me to the job. This month before 8th September 2019. It has not happened because once again NNR management stood behind culprit branch manager of NNR Bangalore. Indian management has put up this case in High Court of Karnataka through present General Manager Mr. Shashikant. Anyway, I am ready to face the issue at any level until I get justice. Culprit bank manager should be punished who is looting NNR money by submitting fake bills. He converted the office into brothel house and still management is supporting him to loot money. Anyway, until I get justice, I won't stop. My lords, he has made one more statement in page number 17. Typed copy of the LinkedIn post is produced in page number 17. My lords, he has stated that, dear all, please note in NNR India.
Whether it is a letter or sent to
My lord, he has posted this statements in a social media page.
social media.
Yes, LinkedIn.
Ah.
These are all extracts
LinkedIn.
LinkedIn.
Ah.
My lords, LinkedIn has around 40 crore global users. And accordingly, these statements are made in public platform.
Para document number 2.
Please, my lords. Please note, in NNR India, there is no value for sincerity and honest. Illegally, Indian management can do whatever they want. They will target the people. They will terminate the sincere employee. They may ready to kill the sincere employee. Example is myself. Without any black remarks, they illegally terminated me due to sincerity and honest. Even I do have very good feedback from customer as well. They protect people who is corrupt, psycho, culprit. Best example is NNR Bangalore branch manager Parantaman, who is involved in above and still he is leading NNR Bangalore. Here, everyone can understand that managing director Manish have also involved and he is also part of it. That's why he closed his eyes about Parantaman. I have submitted evidence of the above and management. My lords, next post is in page number 18 and the typed copy is in page number 19. Hi NNR India team, Mr. Shashikant, don't disappear from my LinkedIn page. One by one, come forward, comment on my review page if you are in right way. If you don't have a courage, you can disappear in the page. Come to the High Court. Let's meet there as per petition submitted against me. Don't try to save the culprit branch manager of NNR Bangalore, Parantaman, who is fraud and culprit. I do have
complaint by whom?
My lords, this complaint is made by the petitioner company. My lords, before going to that, if I may brief,
Global Logistics.
please, my lord, if I may brief background before this complaint. My lords,
It appears there is a dispute with regard to the employment is concerned.
indeed, my lords, the petitioner company is a Japanese multinational company having around 18,000 employees around the globe. And respondent was one such employee who was employed in the Bangalore branch office. And he was appointed as a senior executive operations. My lords, he was terminated on 16/6/2017 by a termination letter. The said termination letter is produced as document 9R, which is in page number 107. My lords, when we issued the termination letter, the respondent has challenged the said termination before the labor court in ID number 15 of 2018, seeking reinstatement and back wages. Accordingly, the labor court has awarded reinstatement into the petitioner company. The said award was challenged by the petitioner company in the High Court in the Honorable High Court. And the Honorable High Court was pleased to stay the award and also directed the petitioner company, since the award has been stayed, 17B wages be paid to the respondent. Accordingly, the petitioner has been paying 17B wages to the respondent. And as of now, he has drawn around 15 lakh rupees, my lords. My lords, when the matter stood thus, the respondent started posting defamatory, scandalous and malicious statements as mentioned previously, which is mentioned in page number 18, 19 and 20 of this petition, my lords. My lords, these remarks are highly defamatory and scandalous. They are not backed by any facts or reasons. And my lords, when the matter stood thus, the petitioner company decided to file a private complaint before the magistrate. And the said complaint is document number 8, which is at page number 33, my lords. My lords, however, the learned magistrate has refused to take cognizance
Yes.
of the
Yes,
complaint.
counsel, Naik,
My lords, if I may read the relevant paragraphs of,
no need, counsel. I will hear other side, then if necessary. I will-
Please, my lord,
indeed,
all
indeed,
these facts, my lord, what happened when the employee was removed from service
Yes.
because he has shown some irregularities in the books and accounts
Whatever
about
it
the
may be, how-
Parandaman, about
whatever it may be,
Parandaman.
counsel, whatever it may be, counsel, how you can.
Because I have not
Any-
made any allegation
if
against the
any
company, my
if
lord.
Any grievances, you can fight it in the court.
Because, my lord,
Why
what
you
happened,
send
my
it in-
lord,
why you-
after termination of service, reinstatement has been ordered, but they don't want to take me for employment. He has frustrated and
then
made
you
allegation
posted the
against
same in social
Parandaman, my lord,
media.
not against the company. Parandaman, who is manager, he has taken all the initiation, my lord.
Yes, because he is representing the company, that's why he
No,
has taken the initiative.
No, my lord, it is dispute between them only, my lord. That is the allegation for termination. He himself has taken initiation
Counsel,
for
whatever
termination.
whatever
Yes,
it may be.
I have taken before the court, my lord.
Then if
But
any
these
cases are
averments,
pending
my
before
lord,
the court, whether we can allow the parties to make any statements in social media.
no, my lord, but not against
You
my
see-
lord
you see-
company.
you see the
But this
letters,
Parandaman, who
document
is
number
did
1
all
and
these
2.
things, man.
This is scandalous.
Parandaman has to take my lord action,
Now,
not
counsel-
company, my lord. I have not made any allegation against company.
Hmm.
Because Parandaman has not taken any initiation action.
Hmm.
And no resolution has been passed till today, my lord,
If any
permitting
deci-
Parandaman
if
to
any
take
decision
action.
is not taken, then you have to implement it through court only, not by social media.
My humble request, my lord, because no money,
Now,
nothing,
counsel,
till my lord,
then
till
there
I
is
am
no
getting,
end. There is no any end if such permission is given to them.
because my lord, I am,
Trial court committed an error in coming to the conclusion that that is only a criticism. Is it a criticism?
yes,
You see
my lord,
paragraph-
against manager, my lord, I have criticized, my lord.
Paragraph number 6.
Yes, my lord, I
The
have
trial
gone
court
through
has
the
come to
order,
the
my lord.
conclusion that
And
statement is criticism. Heard the
because, my
petitioner
lord,
counsel.
it is frustrated for termination, my lord, because
it may
no
be,
money,
counsel.
nothing is employee, though he has served, my lord, and
him-
he is
let him face
at
the
the verge of
consequences, that's all.
manager, my lord.
Let
Only
him face
that
the
intention he
consequence
was
because of
terminated.
his attitude, that's all. Third.
Not
For the
attitude,
petitioner
my lord.
counsel and also the counsel appearing for the state. This revision petition is filed rejecting the private complaint and not taking the cognizance for the offense punishable on section 499 of IPC and section 500 of IPC. The specific case of the revision petitioner before the trial court while filing the PCR number 55812 of 2019 that the company that the complainant company in which the manager of NNR Global Logistics India Private Limited having head office at companies having head office at Gurgaon and manager is working as a manager in branch office Bangalore and the respondent worked as operations executive since 2010 to 2016, due to misconduct in the said work, accused is terminated from their company on 16/6/2017. Full stop. The accused has approached the Honorable Labor Court under ID number 15 for 2018 and he won the case and there was a direction to reinstate him. And complainant has filed WP number 41154 of 2019 against the said order before this court. By way of using LinkedIn ID, accused has posted defamatory words against the MD of the said company, about 50 crores people are watching the said website, comma, very website is professional network, comma, thereby diminish the image of the company, comma, others are asking them through phone call about the said messages, comma, thereby company has come into loss. In support of the complaint, also furnished the 15 documents and marked the same as exhibit P1 to P15. The trial court, having considered the evidence as well as the documents which have been produced, comes to the conclusion that there is a dispute between the parties with regard to the employment, and that is termination, and also order of reinstatement, and also comes to the conclusion that in order to invoke the offence punishment section 499 of IPC, such words shall be published with intention to make imputation concerned to the complainant, or with intention to harm him, knowing or having reason to believe such imputation will harm him, comma, but looking to the website messages, comma, it is noticed that there is no such any intention of the accused, comma, only he has discussed about the termination from the company and also winning of the case before the court. Further stated that he will meet him before the High Court, and hence it doesn't attract section 499 of IPC, and invoking of the same doesn't arise. The trial court also taken note of the judgment of the Apex Court in case of Subramania Swamy versus Union of India, reported in AR 2016 SC 2728. Comma, mere criticism is not a defamation. Comma, in case on hand, termination order is criticized by the accused, but he has not made any allegations with intention to defame the complainant, and hence rejected the same. Being agreed by the order of the trial court, the present revision petition is filed before this court. The counsel appearing for the revision petitioner brought to notice of this court the document number 1 and 2, which have been placed before the trial court, and also counsel brought to notice of this court referring the manager as culprit branch manager of NNR Bangalore, and also a specific statement is made that Indian management has put up the case in High Court of Karnataka through the present general manager, and anyway he is ready to face. And once again he says that culprit manager should be punished who is looting NNR money by submitting fake bills. He converted the office as brothel house, and still management supporting him to loot NNR money. Anyway, until he gets justice, he won't stop the legal fight. ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಏನ್ ಮಾರ್ಕ್ ಆಗಿದೆಯೇನ್ರಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಆಗಿದೆ.
ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್ ಟೆಸ್ಟ್ ಮಾರ್ಕ್ ಆಗಿರೋದು? And counsel also brought to notice of document number 2, wherein also a statement is made that NNR India, there is no value for sincerity and honest, comma. Illegally Indian management can do whatever they want, comma, they will target the people, comma, they will terminate the sincere employee. They may ready to kill the sincere employee, comma, example is he himself without any black remarks. They illegally terminated him due to sincerity and honest. Even he do have very good Facebook, feedback from the customers as well. The counsel also brought to notice of this court that the further amendment made in the said document, they protect the people who is corrupt, comma, psycho, comma, culprit, comma. Best example is NNR branch manager, Parantaman, full stop, who is involved all the above and still he is leading NNR BLR, comma. Here everyone can understand that managing director Manish also involved, and he is also part of it, comma. That's why he closed his eyes about Parantaman. ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಅದು ಮಾರ್ಕ್ ಆಗಿರೋದು?
14 and 14M. 14 is the CD that was produced. 14A are the hard.
ಅಲ್ಲ, ನಾನ್ ಕೇಳ್ತಾರೆ ಈ ಲೆಟರ್ಗಳು ಯಾವ್ದು? ನಿಮ್ CD ಬೇಡ,
14A, my lord.
ಹಾಕಿದಿರಲ್ಲ
14A, my lords.
14
A.
ಎ ಇನ್ನೊಂದು
Hard copy 14A, my lords. All are marked,
ಟೋಟಲ್ ಮಾರ್ಕ್ ಆಗ್ದಿಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನ ಇಲ್ಲಿ ರಿಲೇ ಮಾಡಕ್ಕಲ್ಲ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇಲ್ಲ, all are marked as 14A, my lord.
ಅದು ಏನೇನು ಅದು ಯಾವ್ದಾದ್ರು ಹೇಳಿ 14 ಕೊಡಿ ಮೇಡಮ್ ಅದೇನು ಹಾ ಕೊಡಿ. The council also brought to notice of the other document number 3, wherein also once again referred that don't try to save the culprit branch manager of NNR DLR within bracket Prathan, Parantam, who is fraud and culprit. He has got strong visual evidence on him. ಈ ಲೆಟರ್ಸ್ ಮೂರನ್ನು ಮಾರ್ಕ್ ಆಗಿದೆ ಏನ್ರಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಆಗಿದೆ, my lords. 14A, my lords.
14 ಏನ?
ಹೌದು, my lords.
ಇಲ್ಲೊಂದು CD ಇದೆ. ಯಾವ್ದಾದ್ರು ಇದೆ ಎಕ್ಸಿಬಿಟ್ P14 ಇಂತ ತಗೊಳ್ಳಿ ಒಂದು. P2.
Page number 100, my lords.
Huh?
Page number 100.
100.
They are marked as 14A.
P3. P4. P5. P6. P7. You have a letter correspondence between all of you.
It's in the last, my lords. 14. Page number 100, my lords.
How page number 100 ರೀ? ಇಲ್ಲಿದೆ ಮೇಡಮ್, ಯಾವ ಪೇಜ್ ನಂಬರ್ 100 ಇದೆ? P13 ಅಲ್ಲೂ ಕೂಡ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್. P14 ಆದ್ಮೇಲೆ ಇನ್ಯಾವ್ದು ಇಲ್ವಲ್ರಿ?
Page number 100, my lords.
ಯಾವ 100? ಇಲ್ಲ ಯಾವ್ದು 100 ಪೇಜ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ? 19 ಲಾಸ್ಟ್.
Petition, page number 100. my lords.
So you are relying upon document other than the documents which have been exhibited before the court. You are seeking an order for setting aside the order passed by the trial court.
Please, my lords.
You are misleading the court. I will impose the cost.
No, my lords. Same are marked, my
Show
lords.
me those documents now which you have relied upon in this revision. The documents which you have marked before this court, D1 to D3, not the part of the documents. How this court can comes to a conclusion the trial court committed an error anta?
My lords, the evidence is on page number
Evidence bitbiಟ್ರಿ.
14. I will mention ಮಾಡಿದ್ದಾರೆ,
You
my lords.
referred this document. No defamatory statement material is placed before the trial court. How a court can invoke section 499? Now you are relying upon the documents which have not been exhibited before the trial court and relying upon these documents. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಪ್ರಾಕ್ಟೀಸ್? ಎಷ್ಟು ವರ್ಷ ಆಯ್ತ್ರಿ ಪ್ರಾಕ್ಟೀಸ್?
1 year, my lords.
1 year. 1 year ಗೆ ಈ ಫ್ರಾಡ್ ಕೋರ್ಟಿಗೆ. I believed you your words. You are relying upon these documents. No doubt these documents are defamatory statements. Where is those documents?
My lords. If I may produce. the
ಪ್ರಾಕ್ಟೀಸ್
cop-
ಮಾಡದಲ್ಲೇ ಬಂದ್ರೆ ಹಿಂಗೆ ಆಗೋದು.
Apologies, my lords.
ಏನ್ ಅಪಾಲಜಿ? ಎಲ್ಲಿದ್ದಾರೆ ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ನೀವು ಯು ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 1, 2, 3 like that. These
Petition.
documents are not placed before the trial court. How you can seek for the relief of revision?
My lords, petition, I'll page number 100.
ನೋಡ್ರಿ ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾ ನೋಡಿದೆ ಎಕ್ಸಿಬಿಟ್ P1 to P15 ಎಲ್ಲ ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ಲೆಟರ್ಸ್ ಹೌದಾ? ನಿಮ್ಗೂ ಅವ್ರಿಗೂ ಟರ್ಮಿನೇಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಲ್ಲ ಹೌದಲ್ಲ?
My lords, 14 ಅಲ್ಲಿ CD.
And also order passed by the labor court. ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಕೊಡ್ರಿ, ಅದೇನಿದೆ ತೋರಿಸ್ಲಿ ಅವರು. I will impose the cost minimum 1 lakh. You are wasting the time of the court, relying upon the documents which have not been exhibited before the trial court. ಇವೊಂದು ಹೊಸ ಟೆಂಡೆನ್ಸಿ ಇಂಗ್ಲಿಷ್ ಬರುತ್ತೆ ಅಂತ ಮುಂದೆ ನಿಂತ್ಕೊಬಿಡೋದು ಕೋರ್ಟ್ ಮುಂದೆ. You should have the sense while making the submission before the court, that too in a high court. ಸೀನಿಯರ್ ಆಫೀಸ್ಗೆ ಹೋಗ್ಬೇಡಿ, ಅಲ್ಲೆಲ್ಲ ಕೆಲಸ ಕಲಿಬೇಡಿ, ಇಲ್ಲಿ ಬಂದು ನಿಂತ್ಕೋಬೇಡಿ. Yourself has relied upon the document, certified copies, exhibit P1 to 15 which have been marked before the trial court, but now you are relying upon the documents which are not other than the documents which have been placed before the trial court. It's unfortunate.
My lords, extracts were produced through CD, my lords.
ಏನ್ ಸಿಡಿ?
CD ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ ಅದು.
ಸಿಡಿ ನಲ್ಲಿ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಹಾಕಿದಿರ ಅದನ್ನ?
ಹೌದು ಮೈ
ಅದಕ್ಕೆ ಅವ್ರು ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ. ಸಿಡಿ ನಲ್ಲಿ ಏನಿದೆ ಅಂತ ಹಾಕಿದಿರೇನ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು?
lords, list of
ಸಿಡಿ ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ರೆ ಸಿಡಿ ನಲ್ಲಿ ಏನಿದೆ ಅಂತ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ಜಡ್ಜ್ಗೆ? ಈಗ ಇಲ್ಲಂಗ್ ತಂದು ಹಾಕಿದ್ರೆ ಅದನ್ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ ಹಾಕ್ಬೇಕಿತ್ತು.
lords, list of documents ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ. The extract of malicious
ಏನ್
comment.
ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಾರ್ಕ್ ಮಾಡಿರಿ, ಎಲ್ಲಿದೆ? ಯಾವ್ದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನೀವೇನು ಆಮೇಲೆ ನಿಮ್ಮ ಮುಂದೆ ಅವ್ರ ಮುಂದೆ ಏನಾಗಿದೆ ಅದೆಲ್ಲ ಇಲ್ಲಿ ತಂದು ಹಾಕಿದಿರಿ. ಕಾಪಿ ಆಫ್ ಇಲ್ಲೇನೋ ಇದೆ, ಏನೋ ಮಾರ್ಕ್ ಇದೆ, ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 19 ಏನೋ ಇದೆ. 14A ಅಂತೀರಿ, ಎಲ್ಲಿದ್ದೀರಿ 14A? ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿನಾಪ್ಸಿಸ್
ಹೌದು ಮೈ lords.
ಇದೆಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು. ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಬ್ಯಾಂಗ್ಳೂರ್ WP ನಲ್ಲಿ ನಲ್ಲಿ ತಂದು ಹಾಕಿದ್ರಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ, ಹೌದಾ? ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದು ಹಾಕಿದಿರಿ?
CD my lords.
ಹಾ?
CD ಹಾಕಿದ್ದೀನಿ.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು ಮೇಡಮ್, ರಿಟ್ ಪಿಟಿಷನ್ ಅದ್ರ ಕಾಪಿ ತಂದು ಹಾಕೋರು ಅಷ್ಟೇನೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದು ಹಾಕಿದಿರಿ? ಹಾ? ಅದನ್ನೇ ಮೇಡಮ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು. PCR ಹಾ ಎಲ್ಲ ವೇಜ್ ರಿವಿಷನ್ ಲೆಟರ್ ಇದೆಲ್ಲ ಯಾವ್ದು ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್. ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಳ್ಬೇಕಾದ್ರೆ ನಿಮ್ಮ ವಿಚಾರಣೆ ಆಯ್ತಲ್ಲ,
ಹೌದು ಮೈ
ವಿಚಾರಣೆ ಆಗ್ಬೇಕಾದ್ರೆ ನೀವು ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕೋ ಬೇಡ ಇವೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್?
ಆಗಿದೆ 14 and 14A ಅಂತ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ 14 and 14A? ಐ ಆಮ್ ಸರ್ಚಿಂಗ್.
14 ಮಾತ್ರ ಇದೆ.
ಯಾವ್ದು ಇಲ್ಲ. 14 ಬಿಟ್ರೆ
Petition.
15 ವರೆಗೆ ಮಾತ್ರ ಆಗಿರೋದು ಬಿಟ್ರೆ
ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹಾಕಿದೀರಾ?
Petition ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಹಾಕಿದೀವಿ, ಅದ್ರಲ್ಲಿ 14A ಅಂತ ಕ್ಲಿಯರ್ ಆಗಿರೋದು.
ನೋಡಿ ಮೇಡಮ್, ಇದೇನೋ ಇಲ್ಲ ಒಂದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆಯಲ್ಲ, ಇದೇನು ನೋಡಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೊಡ್ತಾ ಇದು CD ಆಯ್ತು ಇದು. ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಇಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅದು ಎಲ್ಲಿದೆ ಮತ್ತೆ? ಇಲ್ಲ ಅದೊಂದು 14A ಅಂತ ಏನೋ ಒಂದಿದೆ, ಕಲ್ಪ್ರೇಟ್ ಬ್ರಾಂಚ್ ಮ್ಯಾನೇಜರ್. ಟೈಪ್ಡ್ ಕಾಪಿ ಮಾರ್ಕ್ ಇಲ್ಲ ಇಂತ ಇಲ್ಲ. ಇದೆಯಾ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೇಡಮ್? ಬಟ್ ಇದು ಸರ್ಟಿಫೈಡ್ ಕೊಟ್ಟಿದಾರ ಅದು ತೆಗೀರಿ. 14 ಆದ್ಮೇಲೆ ಏನು ಇಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನು ಇಲ್ವಲ್ರಿ? ಕೊಡಿ ಅವರಿಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ತಾನೆ ಅದು. ಬೇರೆ ಏನಾದ್ರು ಮಾರ್ಕ್ ಆಗಿದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ನೀವು ಹೋಗ್ಲಿ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ತಗೊಳ್ಳಿ, ಮಾರ್ಕ್ ಇದೆಯಾ ನೋಡೋಣ 14A. ನಿಮ್ ಡಿಪೋಸಿಷನ್ ಇದೆಯಾ ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಸೋರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದಾಗ?
ಪೇಜ್ ನಂಬರ್ 47.
ಹಾ?
47. Petition, petition 47.
47, 48.
49 ಅಲ್ಲಿ 49 ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್
ಅವಕಾಶ ಮುಂದುವರೆದ ಸಾಕ್ಷಿ ಪ್ರಮಾಣ ಪತ್ರಿಕೆ
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ.
ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲೇನೋ ಫರ್ದರ್ ಎವಿಡೆನ್ಸ್ ಏನಾಗಿದೆ? ಕಳ್ಸಿಲ್ವಾ? ಸಿಡಿಯನ್ನು ನಿಶಾನೆ 14 ಎಂದು ಅದರ ಹಾರ್ಡ್ ಕಾಪಿಯನ್ನು ನಿಶಾನೆ 14A ಎಂದು ಗುರುತಿಸಲಾಯಿತು ಅಂತಿದೆ. ಹಾರ್ಡ್ ಕಾಪಿನ ಹಾರ್ಡ್ ಕಾಪಿ ಏನಿದೆ ನೋಡಿ ಮೇಡಮ್, 14A ಇದೆಯಾ? ಟರ್ಮಿನೇಷನ್ ಪ್ರತಿಯನ್ನು ನಿಶಾನೆ P15 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಡಿಪೋಸಿಷನ್ ಬಂದಿಲ್ವಾ? ಎಕ್ಸಿಬಿಟ್ಸ್ ಡಿಪೋಸಿಷನ್ ಇಲ್ವಾ? ಯಾವ ಕೋರ್ಟ್ ಇದು? ಬೆಂಗಳೂರಲ್ಲ ನೋಡಿ. This court has received the records from the senior solicitor, City Civil Court, Bangalore. In respect of PCR number 55812 of 2019. Mayo Hall idu. On the file of Mayo Hall. On perusal of the records of the trial court, no deposition is sent to this court. Only exhibits are sent to this court. And counsel also submits that the hard copy of CD is also produced before the trial court and the same is marked as exhibit P14A. And no such exhibit P14A is found in the lower court records. And hence it is appropriate to summon the court, kodi madam, senior solicitor of City Civil Court, Bangalore, to be present before the court with regard to sending of lower court records, sending of incomplete court records. List this matter next week alone this account. Hmm? 28/3. Let him come before the court. 28th night.
59.
Please, madam, please.
That's for the petitioner in this matter. Last time lordships had directed for trial court records, they have come. My lords, I require some accommodation to prepare fully. It's a slightly voluminous record, 40 plus witnesses, my lords. If 2 weeks may be granted, my lords, I'll be,
Prasanna Kumar ilwa?
no one's present. my lords.
Petitioner counsel seeks time and counsel for the Central Bureau of Investigation is not present before the court. If the counsel doesn't appear in the next state of hearing, matter will be heard in his absence. List this matter on, when do you want?
Anytime after 10th, my lords, I require 2 weeks to fully.
10/4.
Anytime after 10/4, my lords.
Counsel only 10/4 ಅಂದ್ರೆ ಮತ್ತೆ ರಜಾ ಇದೆ ನೋಡಿ ಅವಾಗ weekend.
15th, my lord.
12th ರಜಾ ಇದೆ. 15th 16th ಆಗಲ್ಲ ಮತ್ತೆ 17th ರಜಾ ಇದೆಯಾ? ಏನ್ 17th? ರಾಮನವಮಿಗೂ ರಜಾನಾ? ರಜಾ ಮಾಡಿ. ಆಯ್ತು 18th.
Very
18/4.
Grateful.
ಆಚೆ ಉಳಿಯೋದೇ ಇನ್ನು 5 ದಿವಸ.
My lords, interim order may be extended, my lords.
Order granted earlier is extended till next state of hearing.
Grateful, my lords.
60.
For the respondent, my lords.
Leelakanta Swami. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. For want of time, petitioner counsel is present, absent,
My lord,
respondent counsel is present.
from the day they've obtained the suspension of sentence, they're not coming on records, my lords.
ಕಂಪ್ಲೈ ಮಾಡಿದಾರೇನ್ರಿ ಆರ್ಡರ್ ನ ಇಲ್ವಾ?
ಅದಕ್ಕ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರೆ,
ಮಾಡಿದ್ದಾರೆ.
40% ಡಿಪಾಸಿಟ್
ಆಯ್ತು.
ಮಾಡಿದ್ದಾರೆ, ಅದಾದ್ಮೇಲೆ ಒಂದು 5-6 ಸತಿ ಡೇಟ್ ಬಂದಿದೆ.
ಅಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕು, ನಾನು ಅದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿದ್ದು. ಲಾಸ್ಟ್ ಟೈಮ್ ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂತಿದೆ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಫೈನಲಿ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಬಂದೇ ಇರ್ಲಿಲ್ಲ ಒಂದ್ 2-3 ಸತಿ.
ಎಲ್ಲಾ ಟೈಮು ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಇದೆ ರೀ. ನನ್ ಮುಂದೆ
ಇಲ್ಲ sir.
2 ಸರಿ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂತ ಹೋಗಿದೆ. At the request of the learned counsel for the petitioner and 5 to adjourned.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ
ಅವ್ರು ಇಲ್ಲ ಅಂತ ನಾವು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ರೆ ನಾಳೆ ಬರ್ತಾರೆ ಮತ್ತೆ ನಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಿರಿ ಅಂತ ಒಂದು ಅವಕಾಶ ಕೊಡೋಣ.
opportunity was provided multiple times. my lord.
ಎರಡೆರಡು ಸರಿ ಆರ್ಡರ್ ಬರೆಯೋದು ಬೇಡ. ತೊಗೊಳ್ಳಿ. Petitioner counsel is absent, respondent counsel is present. If the petitioner counsel doesn't appear in the next date of hearing, the order of suspension will be revoked in the next date of hearing. List this matter on 5/4.
Deeply obliged, my lord.
61, Ramesh Kumar RV, Krishnamurthy N.
For the respondent in this case.
Petitioner.
Submission.
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೇಂಟೆನೆನ್ಸ್ ಟು ದಿ ಮದರ್, ತಾಯಿಗೆ ರೆಗ್ಯುಲರ್ ಕೊಡ್ತಿದ್ದಾರೆ. ಟೈಮ್ಸ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಸಾಮಲ್ ಕೋರ್ಟ್. ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ಬೇಕು. ಒಂದು ವಾರ ಟೈಮ್.
Last time, with kind leave. Last time also I made a submission. His mother was admitted. I have shared the bills and everything. 50% as per the direction of this court, 50% has to be paid. Till date, they have not paid that amount, 7,000 and odd. Prior to that, I have made a memo. Along with the memo, I have produced the details, wherein 3,60,000 is the due. That is also not being paid. Everything which I produced before the court, everything they dispute. And also last time they said, as per the direction of the court, they were directed to pay 10,000. Now, 5,000 is paid. They say 10,000 is paid. Totally, the award passed by the trial court and the first appellate court is 10,000. And 5,000 ಬಂದು senior citizen act ಅಲ್ಲಿ total 15,000 maintenance ಕೊಡ್ಬೇಕಂತ ಆಗಿದೆ. ಅವ್ರು 15,000 ಕೊಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳ್ಕೊಂಡು I have produced along with the memo, I have produced the calculations. I have served the copies on them on the last date also. May I place it before this court, my lord?
I have one. Totally 1,60,000 arrears
ಕೊಡ್ಬೇಕು
ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
ಆಗಿದೆ.
ಅದನ್ನ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅದು ಕೊಟ್ಟಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದಾರೆ.
Intermediate
is not being paid.
ಎಲ್ಲವೂನು I have filed an affidavit. ಇಲ್ಲಿವರೆಗೂನು entire arrears has been paid. There is no arrears. I am regular in payments.
ಹೇಗೆ ಪೇಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀರಿ ನೀವು?
Through check, through cash, by online transfers. Transfers, online transfers ಮಾಡ್ತಾ ಇದೀವಿ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ಒಂದು ಕ್ಯಾಲ್ಕುಲೇಷನ್?
ಎಲ್ಲ ಅಕೌಂಟ್
ಇದೆ, ನನ್ನ ಮೆಮೊ ಇದೆ, ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಕೋರ್ಟ್ಗೆ.
memo along with the
ನಾನು ಮೆಮೊ
calculation.
ಕೊಟ್ಟಿದ್ದೀನಿ ಕೋರ್ಟ್ಗೆ.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ produced detailed
Now,
statement.
all that they want to see that they want to misinterpret the order of this honorable court.
Sorry, I am the last person to
No,
make
no,
the
ನಿಮಗೆ
submission
ಹೇಳಿಲ್ಲ.
for the court.
No, ನಿಮಗೆ ಹೇಳಿಲ್ಲ. The counterpart who is standing next to you.
And I also made a submission. This is the last case which
Total
I would.
maintenance payable from 4 to 21 to 29 to 24.
Kindly turn to my
37 months.
lord affidavits which are
37
placed.
months. Maintenance be payable is 3,70,000. Maintenance received is 1,85,000. ಇವರೆಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಟೇಬಲ್
ಫೈಲ್ ಮಾಡಿ every time ಪ್ರತಿ ತಿಂಗಳು.
ಆಯ್ತ್ರಿ, ಟೇಬಲ್ ಎ ಅಂತ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದಕ್ಕೆ ನೀವು
Objections ಹಾಕಿದೀವಿ ನಾವು.
Objections
ಹಾಕಿದೀವಿ.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ objection statement ಜೊತೆ ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿದಿರಿ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಎಲ್ಲಿದೆ ಕೊಡಿ.
Kindly turn to my memo, my lord.
ಮತ್ತೆ ಇನ್ನೊಂದು ಟೇಬಲ್ ಬಿ ಬೇರೆ ಏನೋ ಒಂದು ಇದೆಯಲ್ರಿ, 80 months.
ಅದನ್ನೇ ಅವರು ಈಗ
4 lakhs rupees, amount paid is 3,65,000, balance is 35,000. ಯಾಕೆ ಇದು ಟೇಬಲ್ ಎ ಅಂಡ್ ಬಿ ಅಂತ ಮಾಡಿದಿರಿ?
ಸ್ವಾಮಿ, ಇದು senior citizenship ಅಲ್ಲಿ ಮಾಡಿರೋದು. So that is not under challenge before this court. Only challenge before this court is order passed by the sessions court. ಅದ್ರ ಪ್ರಕಾರ 10,000 ಕೊಡಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 10,000 ಕೊಡಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. Senior citizens ಅಲ್ಲಿ 5,000, total 15,000 maintenance has to give. 5,000 which is apart order from the senior citizen. As per the order of the trial court as well as the sessions court, they have to pay 10,000 per month from the date of the order. Till date, I have produced my calculation. Let them produce the calculation and show that they have made the entire payment of 10,000 as per the order.
ಇದಕ್ಕೆ ನಿಮ್ ತಕರಾರು ಹಾಕಿದಿರೇನ್ರಿ?
That has ಹಾಕಿಲ್ಲ.
Calculation.
I'll file that. I'll just look into it. ನೋಡ್ತೀನಿ ಸಮಯ.
Statement subject to objection ಅಂತ ಕಾಪಿ ರಿಸೀವ್ ಮಾಡಿದಿರಿ ನೀವು? ಅದು ಯಾವಾಗ? 7/3/24.
Last time ತಮ್ಮ ಮುಂದೆ ಬಂದಾಗ.
ಇದಕ್ಕೆ objections ಹಾಕಿದ್ರ ನೀವು?
ಹಾಕಿಲ್ಲ.
I'll look into that and file it, my lord. 70.
And also I made a
As on
submission.
ಇಲ್ಲಿವರೆಗೂ ಕೂಡ I have records about the maintenance.
ಕೊಡಿ, ನಿಮ್
ಕೊಡ್ತೀನಿ. I'll just place it on record. I'll place it on record. Now, Lord, one thing what they want to that
ಒಬ್ಬ ಮಗನಿಗೆ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡೋದು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ, ಇನ್ನೊಬ್ಬ ಮಗನಿಗೆ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಲ್ಲ. ಎರಡು ಕಡೆಗೆ 10,000 ಇಲ್ಲೂ 10,000 ಮಾಡ್ತಾರೆ. Please, ನಾನು ಕೊಡ್ತೀನಿ. I will place it on record.
And
Counsel
also,
for the
I made a
week's time
submission
ಕೊಡಿ
before
sir.
the court. This is the last case I want to fight it out in the court, because it, end of the day, is a son, both are sons. It is their duty to look, take care of their mother, which has not been questioned. Hence, she is before the court. Now she is bedridden and private care has been taken. Every day nurse has to be there, who has to look after her daily, attend to her daily needs. 25,000, that also I paid. And I have produced the receipt. For that, they say, they'll question that, and also they file a memo stating that our ಮೇಲೆ enquiry conduct ಮಾಡಿ false receipts ಆಗ್ತಾ ಇದಾರೆ ಅಂತ. ನಾನು ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರೆ everything they question. They have a right, it is their home, they can come and ಮನೆಗೆ ಬರ್ಬೋದು, ನೋಡ್ಬೋದು ತಾಯಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಏನ್ ಮಾಡ್ತಲ್ಲ ಅಂತ.
Last time
First let him file statement
I'll
of
file it.
objections to
I'll
this.
look to the court, my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ತಮಗೆ ಒಂದು ವೋಚರ್ ಕೊಡ್ತಾರೆ, 25,000 ರೂಪಾಯಿ ನರ್ಸ್ ಎಂಗೇಜ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ಹೋದ್ರೆ ಅಡ್ರೆಸ್ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಟಿನ್ ನಂಬರ್ ಇಲ್ಲ, ಏನು ಅಡ್ರೆಸ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಎಲ್ಲ ಇಲ್ಲ. ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಈ ಕೋರ್ಟ್ ಇದ್ದಾಗ ಸಾಹೇಬ್ರು ಅಂದ್ರು, ದೆನ್ ಐ ವಿಲ್ ಟೇಕ್ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಯು ಅಂತಂದ್ಮೇಲೆ ಐ ವಿಲ್ ವಿಡ್ರಾ ಅಂತಂದ್ರು ಅವರು.
ಇಲ್ಲ ಇಲ್ಲ, I am sorry to
ನಿಮಗೆ
make
ಹೇಳಿದ್
such
ನಾನು.
submission.
You are
this
the
was
counterpart
never
there.
that. I openly called him to home.
ವೋಚರ್ ಕೊಟ್ಟಿದ್ದಾರೆ,
ನೋಡಿ ನಿಮ್
ವೋಚರ್ ಅಲ್ಲಿ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡ್ಬೋದು.
ನರ್ಸ್ ಇಟ್ಟಿದ್ದೇವಲ್ಲ ನಿಮ್
ತಾಯಿಗೆ
ನೋಡಿ ಅಂತ ಹೇಳಿದಿವಿ.
28,000 ರೂಪಾಯಿ ಪೆನ್ಷನ್ ಬರ್ತಾ ಇದೆ.
ನೀವೇ ಹೋಗ್ಬಿಟ್ಟು ನರ್ಸ್ ಇದಾರಲ್ಲ ಹೋಗಿ.
ನೋಡಿ
ಇಲ್ಲ
ಮನೆಗ್
ಅಲ್ಲಿ.
ಬನ್ನಿ, ಮನೆಗ್ ಬನ್ನಿ ಸರ್, ಮನೆಗ್ ಬನ್ನಿ.
ಸರ್, that exists, that institution which you say that ಇಲ್ಲ institution ಇಲ್ಲ ಅದು.
ಸರ್ ನಾನು ಹೇಳ್ತೇನೆ,
ಫೋನ್ ಮಾಡಿದ್ರು ತಾವು ರೆಕಾರ್ಡ್ ತಾವು ನೋಡಿ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು ಅದರಲ್ಲಿ.
ನಿಮ್ಮಿಬ್ರನ್ನ ಬೈಯಲ್ಲ, ಅವ್ರ ಮಕ್ಳು ಮಾಡ್ಕೊಂಡ್ರಲ್ಲ ಅವ್ರನ್ನ ಬೈತಾರೆ.
ಅಲ್ಲ, ನಾನು ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ, ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ, ಒಬ್ಬ ಮಗನಿಗೆ ಮೇಂಟೆನ್ಸ್ ಕೊಡ್ಬೇಕಂದ್ರೆ ಇನ್ನೊಬ್ಬ ಮಗನಿಗೆ ಮೇಂಟೆನ್ಸ್ ಕೊಡಕ್ ಆಗಿಲ್ಲ. ಇವ್ರು ಮಾತ್ರ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಿಯರ್ ಇನ್ ಈಸ್ ಇನ್ಸ್ಟಿಗೇಟ್ ಹಿಸ್ ಮದರ್, ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಹ್ಯಾವ್ ಬಿನ್ ಹ್ಯಾಪನ್ ನೌ.
ಮಕ್ಳು ಏನ್ ಮಾಡ್ತಾರೆ ಹೇಳಿ ಇಬ್ರು?
he is now as of now ಕೆಲಸದಲ್ಲಿ ಇಲ್ಲ. ಅವರು ಮೊದಲು ಮೇಂಟೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಯ್ತು.
ಕೆಲಸದಲ್ಲಿ ಇಲ್ಲ.
ಹೌದು, ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳ್ತಾರ ಅವರು.
ಅಡ್ವೊಕೇಟ್ ಆಯ್ತು.
ಐ ಡೋಂಟ್ ನೋ, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
ಎಲ್ಲಿ ವಾಸ ಇರೋದು, ಯಾರು ವಾಸ ಇರೋದು
ಈಗ?
ನಿನ್ನ ಮದರ್ ನಿಮ್ ಜೊತೆ ಇದ್ದಾರೆ? ಆಯ್ತು,
ಇಬ್ರಿಗೂ ಮನೆ ಕಟ್ಸ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾವು ಬೇರೆ ಕಡೆ ಮನೆ ಇದೀವಿ.
ಬೇರೆ ಮನೆಯಲ್ಲಿ?
ಹೌದು, ಬೇರೆ ಮನೆ ಇದ್ದಾರೆ. ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತೀವಿ 10,000 ರೂಪಾಯಿ. ತಾಯಿಗೆ 25,000 ರೂಪಾಯಿ ಮೇಲೆ ಪೆನ್ಷನ್ ಬರ್ತಾ ಇದೆ. ಅದನ್ನ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ಲಿಲ್ಲ. ನಾವು 10,000 ಕೊಡ್ತಾ ಇದೆಲ್ಲ 35,000 ರೂಪಾಯಿ ಆಯ್ತು ಅವ್ರಿಗೆ.
ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು?
ತಂದೆ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯ್.
ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯ್.
ಹೌದೌದು.
ಇಬ್ರಿಗೂ ಮನೆ
ಓದಿರೋದೇನು?
ಇಂಜಿನಿಯರಿಂಗ್ ಓದಿದ್ದಾರೆ.
ಇಂಜಿನಿಯರಿಂಗ್,
MCA.
ಒಬ್ರು ಲಾಯರ್, ಒಬ್ರು ಇಂಜಿನಿಯರಿಂಗ್.
MCA.
ಯಾರು?
ಇವರು
ಪೆಟಿಷನರ್. MCA. ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು?
ಇಲ್ಲ, ಇವಾಗ ಹೋಗ್ತಿದ್ರು ಅವರು. ಈಗ ನಾವು ರೆಸೆಷನ್ ಆಗ್ತಾ ಕೆಲ್ಸಕ್ಕೆ ಬಿಟ್ಟಿದ್ದಾರೆ.
ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಸ್ಕೊಟ್ಟಿದ್ದಾರೆ ಇಬ್ರಿಗೂ.
ಲಾಯರ್ ಮಾಡ್ಕೊಂಡು ಅಮ್ಮ ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕೇನ್ರಿ? You both sit together and take decision.
This is what I offered.
ಇಲ್ಲಿ ತಾಯಿ ಬಂದಿದ್ರೆ ನಮ್ಗೇನ್ ಚಿಂತೆ ಇಲ್ಲ. ತಾಯಿ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ಅವ್ರು ದುಡ್ಡು ಮಾಡ್ತಾ ಇರೋದು. ಮೊದಲನೇ ಮಗ. ತಾಯಿಗೆ 25,000 ರೂಪಾಯಿ ಪೆನ್ಷನ್ ಬರ್ತಿದೆ. 10,000 ರೂಪಾಯಿ ನಾವು ಕೊಡ್ತಾ ಇದೀವಿ. 3 ಲಕ್ಷ ರೂಪಾಯಿ ಡೆಪಾಸಿಟ್ಸ್ ತಗೊಂಡು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಈ ಕೋರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ. 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾಕೆ ಕೊಡ್ಬೇಕು ಅಂತ ಫೈಂಡಿಂಗ್ಸ್ ಇಲ್ಲ.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ ನೋಡಿ.
I'll file that. 2 weeks ಟೈಮ್ ಕೊಡಿ, ನೋಡ್ತೀನಿ.
2 weeks ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ, ನನಗೆ ಅಲ್ಲ, ಅದರಲ್ಲಿ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ
7 ನಂದು ಮಿಸ್ಟೇಕ್ ಅದಕ್ಕೆ.
7-3 ಅಲ್ಲೇ
ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ.
ವಾರ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ. The counsel for the petitioner seeks 1 week time, seeks 2 weeks time to file objections to memo, and the same was served on 7/3/24 itself, and hence it is appropriate to grant 1 week time. Please this matter next Friday raja alla, next Thursday haki.
Great sir.
28/3 alla
62 Manjunath Gowda.
Respond.
Srinivas.
Withdrawal of amount by the counsel for respondent.
So final hearing, I'm ready.
For 4/4/23, PV Manjunath Gowda, SV Srinivas. ಹೇಳಿ. ಏನು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡ್ತೀರಾ? ಹೇಳಿ ನೀವು.
One submission.
Objection file ಮಾಡಿದೀನಿ ನಾನು.
ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನ್ ನಿಮ್ದು?
ಈಗ ರಿಲೀಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಇದು ಮಾಡ್ಕೊಂಡು ಫೈನಲ್ ಆದ್ಮೇಲೆ.
One submission, it was earlier a coordinate bench of this court said it may be taken up for final hearing upon my submission. About agide Swami, and about 5 times they have taken time for final hearing.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಆಗಿದೆ.
For final hearing ಅಂತ I am ready for final.
ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರು, ಅದಾದ್ಮೇಲೆ ಐಎನ್ ಪ್ರೆಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ. ಐಎಂಎಲ್ ಮತ್ತೆ
ಐಎ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಮೇನ್ ಅಂತ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಏನಿದೆ ಮೇಡಮ್ ನೋಡ್ರಿ. ಆತರ
July 2000.
you argue on merits.
ನೆಕ್ಸ್ಟ್ ಮಾಡ್ತೀವಿ
My lord,
ಮಾಡಿಸಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ.
ಏಕೆ?
ಅಲ್ಲ ಫೈನಲ್ ಸ್ವಲ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
My lord, one submission, kindly see the orders 15/11/23 11 6 12 4 1 23 2. all dates final hearing, last chance ಅಂತ.
ಅಲ್ಲ ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್
Only-
ಮ್ಯಾಟರ್ಸ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಪೋಸ್ಟ್ ಆಗಿತ್ತು, ಅವರೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಇದು ಮಾಡ್ಕೊಂಡ್ರು, ಬಟ್ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗಿಲ್ಲ.
From 15/11,
Ordered
There was
as to
no-
address their arguments and merits instead of pressing IA number 2 of 23. ಯಾರು ಹೇಳಿರೋದು 2 of 23 ನೇ ಬೇರೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಫ್ಟರ್ 3 weeks ಅಂತ 7-8 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದ-
ನೀವೇ ಸಬ್ಮಿಷನ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಿ. ಆಯ್ತಾ? ಅದ್ರ ಮೇಲೆ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ 15/11. ಮತ್ತೆ 23/11 ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಪಿಟಿಷನರ್.
ಮಿಡ್ಲ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು ಲಿಸ್ಟ್
15/12/23 petitioner seeks sought accommodation on the ground that son of his senior colleague is admitted to hospital. Next 14/1/24 at the request of the learned counsel for the petitioner as a last chance list this matter 30/1. ಮತ್ತೆ 23/2 at the request of the learned counsel for the petitioner in this matter 7/3. counsel ನಮ್ಮ ಮುಂದೆನೂ ಕೂಡ ಬಂದು ಯಾವತ್ತು 7/3/24.
ಲಾಸ್ಟ್ ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್, ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ರೆ ರೀಚ್ ಆಗಿಲ್ಲ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಅಂತ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅರ್ಧ ಡಜನ್ ಟೈಮ್ ರೀಚ್ ಆಗಿದೆ ಅಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಸರ್, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಥರ್ಡ್ ಫೈಲ್ ಮಾಡಿ ಸರ್.
ಹೇಳಿ ಕೌನ್ಸಿಲ್
ಡಾಕ್ಯುಮೆಂಟ್ ಲೋಯರ್ ಕೋರ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಾಗಿದೆ?
ಐ ವಿಲ್ ಇಂಪೋಸ್ ದಿ ಕಾಸ್ಟ್. ಚಾಯ್ಸ್ ಇಸ್ ಯುವರ್ಸ್. ಹೇಳಿ.
ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಫೈನಲ್ ಅಂತ ಒಂದು ಮಾಡಿ ಸರ್.
ಲಾಸ್ಟ್
Next
ಚಾನ್ಸ್
date
ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ.
ಶಾರ್ಟ್ ಅಕಾಮಡೇಷನ್ ಮೇಲೆ.
The petitioner counsel seeks time and this court has noticed on several occasions the matter was urgent at the instance of the petitioner counsel. And when this court made it clear that if he is seeking adjournment, court will impose the cost in spite of it.
ಒನ್ ಮೋರ್ ಸಬ್ಮಿಷನ್ ಇನ್ ಕೇಸ್
In spite of it, he seeks time. ಹೇಳಿ.
ಇನ್ ಕೇಸ್ ಆತರ ಆದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ನಾನು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಗೆ
no,
ಆಮೇಲೆ ಬಿಟ್ಬಿಡಿ. ಈಗ ಹೇಳಿ. The counsel for the respondent would submit that several occasions matters listed before the court and even an application is filed for the withdrawal of the amount which is in deposit. And having taken note of the said fact into consideration, adjourned on cost of rupees 5,000 payable at registry and list this matter on. One date kodi madam.
5/4.
5,000 ಬೇಡ ಸರ್, ನನ್ನ ಕೈಯಿಂದ ಕೊಡ್ಬೇಕು.
5/4 ಏನು ಮಾಡಕ್ಕಲ್ಲ.
ನಾಮಿನಲ್ ಇದು ಮಾಡಿ ಸರ್.
ಅದೇ ನಾಮಿನಲ್ 5,000.
ನಾಮಿನಲ್ ಇದು ಮಾಡಿ ಸರ್.
may I request it may be observed that if it does not go on with the matter on that day.
5/4. If counsel not pays the cost and not if fails to argue the matter in the next date of hearing.
ಆರ್ಗ್ಯೂ ಮಾಡ್ಬಿಡ್ತೀವಿ, ಈಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ.
Revision petition will be dismissed ಅಷ್ಟೇ.
ಈಗ
ಮಾಡಿ ಅವತ್ತು ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಮಾಡಿ ಬಂದು. ನೆಕ್ಸ್ಟ್ ಉನ್ನಿ ಕೃಷ್ಣ ಇದೇನಾಯ್ತನ್ರಿ, ಇದೇನ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ
ಸಿನಾಪ್ಸಿಸ್ ಏನೋ ಕೊಡ್ತೀವಿ ಅಂತ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ ಅದು.
Synopsis ಹಾಕಿದೀನಿ, but I'll start off. My lord, may kindly take up first matter, that is 554/23. ನಾಲ್ಕಿದೆ. First on the list is 556 ಇದೆ. 554 ತೊಗೊಳ್ಳಿ. Yes, my lord, take 554.
ಯಾವ್ದು 554 ತಗೋಬೇಕಾ?
ಹೌದು ಸರ್.
ಆಯ್ತು.
My lord, this is a revision petition, my lord, filed against the order of conviction passed by the
554 ಕೊಡಿ ಮೇಡಮ್ ಮೊದಲು.
the order of conviction passed by the learned magistrate on 12/10/22, and subsequently my appeal, my lord, against the said order was also dismissed by the Honorable Sessions Court on 1/4/2023.
What is the amount in this?
My lord, the amount in this is rupees 10 lakhs under section 138 in it. Now, before I come to these two issues, my lord, what had happened, my lord, is that this particular person, the petitioner, is son of one of a director of a company called Indranagar Chit Funds. Now, my lord, Indranagar Chit Funds, my lord, had issued various checks to some people. As a result, my lord, there are many check bounce cases filed against the company, then its directors, signatories, and also family members. This person happens to be one of the son of one of the directors, nothing to do with the company at all. So, my lord, many criminal petitions were filed before this honorable court by the company on two grounds. One is that in view of the fact that that company was also wounded by the NCLT, as per the judgment passed by the Honorable Supreme, my lord, in fact, my lord only had passed an order. In view of the fact that
the company had been wound up, the check bounce cases would not lie, or it would not be maintainable as against the company by virtue of moratorium period, and it's a quasi-civil issue, and also against non-signatories and non-directors of the kitchen. So many complaints were filed, many quashing petitions were filed. But of that, my lord, this particular person, he also filed one criminal petition which got clubbed with so much. My lord, that criminal petition is 907/2021. What happened, my lord, is that 907/2021 is a criminal petition filed by this petitioner.
21.
That is when the trial was being conducted before the learned magistrate. My lord, there was an interim order of stay of all proceedings before the learned magistrate. My lord, I will just take my lord to kindly come to page 63 of my paper. This particular stay order was being extended on various occasions. I will come straight away to 28/6/2021. That is at page 63, my lord. 63, all connected matters were being taken up.
This is 907.
Come to 907, no? 907, this, my lord will get at page 69. 69, criminal petition 907/2021. Same petitioner, same respondent, and next page, my lord, may kindly see CC 5012/2019. Next page. Now, my lord may come to the last page, that is page 72 of that interim order. Interim order extended, etc. And copy to that 72.
Order at page 72.
Cost title first finally
Date of hearing.
petitioner counsel, next date of hearing. Then it says copy to all these learned magistrates before whom these matters were pending, including this petition. Next page, my lord, may kindly see page 73. I file a memo bringing to the notice of the honorable magistrate. Apart from this honorable court also having sent, I also file a memo and say, look, there's a stay order and hence it may be taken. It is taken on record. I produce certified copy itself. Now, my lord, the learned magistrate was very well aware of the pendency of petition and also of the interim order of stay. In fact, my lord, on the last occasion, a statement was made that the learned magistrate I was not aware. That's why our inquiry was also conducted by the coordinate bench of this honorable court, and it was found that the interim order was indeed communicated. Now, my lord, the learned magistrate, my lord, in spite of this order being stayed, proceeds to convict me, my lord. My lord, may kindly see the order of conviction, my lord, is produced at page 13, wherein, my lord, I have been convicted of the offence under section 138 NI Act. I prefer an appeal also, which is also confirmed. My lord, it would be very interesting, my lord, that subsequently these matters were disposed of by the honorable court, my lord. I have produced the final order at page 63.
63.
Also, page 63 only. Final order, my lord, may kindly see 124.
Final order in it.
75.
75.
ಇಲ್ಲ ನಾನು ಓದ್ತಾ ಇರೋದು ನಾನು ನನ್ನ ಫೈಲ್ ಇದು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನೀವು ಕೊಟ್ಟಿರೋದು 75.
ಇಲ್ಲ no, I would never have done that, sir.
ಅಲ್ಲ final
order, my lord.
Final order page 75.
ಹೌದು. ಅದಲ್ಲಿ ತಾವು I straight away, my lord, may come to page 124. Criminal petitions are allowed in part.
124.
124. It says criminal petitions are allowed in part. The proceeding petition number 1 corporate debtor, the Indiranagar chit funds, in all the petitions except CRLP 907. Except why 907 is the other company irlilla. Except 907, petition number 1 in then petitioner number petitioner number 1 in CRP 901, that is this petitioner herein, and petition number 4 in so and so. In all these petitions stand squashed. So, my lord, on that particular day,
1 and 4 ge illa.
1 and 4, 1 and 2 and 4 actually, 2 and 3 ge one case, 1 and 4. They were directors.
Second is petitioner number 1, corporate debtor. In all the petitions except criminal petition number 907 of 21.
Why 907 andre? That is because corporate debtor illilla. My lord, may kindly say, adal bari individual iddi.
Final order adag agilla.
So, ad agilla. But then,
this was the order passed on 19th day of July 22.
Yes, my lord, yes, my lord.
Hmm.
So in fact, on that day, the learned single judge of the Honorable Court even quashed the complaint against me also.
Hmm.
This petitioner, Iday party. But then, my lord, I had to be honest to the court. I filed a memo to the court and said, my lord, I think there's a mistake. Wrongly tag agide bearer jote. So, my lord, recall that order. So, my lord, the order got recalled. However, that recalling of order happened very, very late.
ಎಲ್ಲಿದೆ ಅದು?
ತಳಿ ಕೊಡಿ 50 ಆದ್ಮೇಲೆ 51 ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆಗುತ್ತೆ. ಇಟ್ಸ್ ಎ ಪಾರ್ಟ್ ಆಫ್ 124 ಆದ್ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 50 ಆದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆಫ್ ಪೇಜ್ ನಂಬರ್ 51 ಪೇಜ್ ನಂಬರ್ ಆಗುತ್ತೆ.
ಇದು ಕೊಡಿ ಕೋರ್ಟ್.
Oh, 907 be delinked.
It got deal.
Order be recalled.
ಹೌದು.
Petition be
ಹೌದು.
restored.
ಅದು
And be dismissed as withdrawn.
ಹೌದು.
As the petitioner would not want to pursue the petition any further.
ಹೌದು, ಯಾಕಂದ್ರೆ it was a wrong order. ಯಾಕಂದ್ರೆ that was passed in respect of corporate debtors. So I would not apply. ಯಾಕಂದ್ರೆ it was an individual transaction.
This order be treated as part and parcel of the order.
But my lord, when the order of conviction was happening, there was a stay order throughout. No, my lord, I have produced.
Conviction order ಯಾವಾಗ date?
12/10/2022 at page number
12/10.
Page number
After the withdrawal.
ಹೌದು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ, after the withdrawal ಕಿಂತ ಮುಂಚೆ, my lord may kindly, now I produce one set of documents. ತಾವು ಅದ್ ನೋಡ್ಬೋದು, page 11.
ಈಗ ಕೊಟ್ಟಿದ್ದ?
ಈಗ ಕೊಟ್ಟಿದ್ದು ನೋಡ್ರಿ. Date ನೋಡಿ ಸ್ವಾಮಿ, 7/11/2022. 7/11/2022.
ಎಲ್ಲಿದೆ ಅದು? ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್? ಪೇಜ್ ನಂಬರ್?
Page 11.
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಏನ್ ನಮಗೆ ಕೊಡ್ತಾ ಇತ್ತು.
ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ಅದರ್ ಸೈಡಿಗೆ ಡಾಕ್ಯುಮೆಂಟ್
ಕೊಡ್ತೀನಿ. ಅಸಿಸ್ಟೆನ್ಸ್ ಇರ್ಲಿ.
ನೀವೇನ್ ರಿಲೇ ಮಾಡ್ತಾ ಇರೋದೆಲ್ಲ ಅದರ್ ಸೈಡಿಗೆ
ಹೆಲ್ಪ್ ಮಾಡ್ರಿ.
11.
ಇದೇ ಸೇಮ್ ಥಿಂಗ್ ಕೊಡಿ ಅವರು. ಇನ್ನು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಇದೆ ಈ ಕಡೆ ಬನ್ನಿ. My lord, may kindly see 7/11/2022 is the order. Then what the learned single judge would say, the order was declared in open court on 19/7/2022. Before the order could be signed, a mention was made on 22/7/22 that the respondents have some more submissions, that is this bureau, to be made with regard to a corporate debtor being absolved in proceeding. According to them, even against the corporate debtor also proceedings should be permitted. Therefore, matters were listed for being spoken to on 7/11 and the response were heard on the said issue. However, they opined no further argument. So, my lord, though the order was supposed to be dictated in open court on 19/7, even as but it was not signed, as the Honorable Court would say. And even as on 7/11/2022, the order of stay subsisted and no orders were passed. In fact, my lord.
ಅಲ್ಲ ರೀ, ಈಗ ಡಿಕ್ಟೇಟ್ ನ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟ ಮೇಲೆ 19/7/22 ನಲ್ಲಿ how a court can say that it was not signed ಅಂತ?
It was not signed actually. ಅದು further
ಪ್ರಾಕ್ಟೀಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ ಡಿಕ್ಟೇಟ್ ಮಾಡಿರುತ್ತೋ ಅವತ್ತೇ ಸೈನ್ ಮಾಡ್ಬೇಕು ಡಾಕ್ಯುಮೆಂಟ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಂಗೆ ನಿಯರ್ಲಿ ನೋಡಿ, ತಾವೇ ನೋಡ್ಬೋದು, ನಿಯರ್ಲಿ ಅಬೌಟ್ ಎಷ್ಟೋ 4 months ಆಮೇಲೆ ಆಗಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲ ಸರಿ ರೀ,
ಅಲ್ಲ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ
ಇದು ಅಂತ ಕೇಳ್ದೆ ನಾನು.
ಇರ್ಬೋದು ಸರ್, ನನ್ಗೆ ಅದ್ರಲ್ಲಿ ಏನ್
ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಕ್ಟೇಷನ್ ಆದ್ರೆ ಅವತ್ತಿಗೆ ಅದು
ಆಕ್ಚುಲಿ ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಟೈಪಿಂಗ್ ಲೇಟ್ ಆಗ್ಬೋದು ಅಷ್ಟೇ.
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಟ್ ವಾಸ್ ಆಕ್ಚುಲಿ ಫರ್ದರ್. What is the effect of an order passed, dictated in open court but not signed?
19/7 ಡಿಕ್ಟೇಷನ್ ಆಯ್ತು, 22 ಆದ್ರೂ ಸೈನ್ ಆಗಿರ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು 7/11/22 ಅಂತ.
Samip, directly, I will not trouble my lord. My lord may come to para 8 of that judgment. It's a Supreme Court judgment, similar circumstances.
Para?
8. Swami.
Hmm. Hmm.
Swami, ತಾವು 8 ಗೆ ಬನ್ನಿ.
Hmm.
This court has also dealt with the issue in, male and now they talk about same issues, but my lord here. State of Manu so and so. Now up to the moment the judgment is delivered, judges have right to change their mind. There's a sort of locus pointente, and indeed last minute alterations often do occur. Therefore, however much a draft judgment may have been signed beforehand, it is nothing but a draft till formally delivered as judgment of the court. Only then does it proceed into a full-fledged judgment become operative. It follows the judge who delivers judgment or cause it to be delivered by the so and so, so and so. So what it says, my lord, is that unless and until, my lord.
ಅಂದ್ರೆ ಕೋರ್ಟಲ್ ಒಂದು ಡಿಕ್ಟೇಷನ್ ಕೊಡೋದು ಅಲ್ಲೋಗಂತಿದ್ದದು ಅಂತ ನಾ ಏನು?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು ದಟ್ ನಾನು ಆಸ್ ಎನ್ ಅಕ್ಯೂಸ್ಡ್ ಐ ಆಮ್ ಟೇಕಿಂಗ್ ಬೆನಿಫಿಟ್ ಆಫ್ ಆಲ್ ದಿಸ್. ನಾನು ಯಾಕೆ ಏನು ಹೇಳ್ತೇನೆ, ನೋ ಈವನ್ ಅದರ್ವೈಸ್ ಮೈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಸ್ ದಿಸ್ ದಟ್ till it was finally
ಒಂದ್ಸರಿ ಕೋರ್ಟಲ್ ಓಪನ್ ಕೋರ್ಟಲ್ ಡಿಕ್ಟೇಷನ್ ಆದ್ಮೇಲೆ ಎನಿ ಕರೆಕ್ಷನ್
actually ಇದರಲ್ಲಿ I mean since I
ಏನೇ ಆದ್ರೂನು
ಹೌದು ತಾವು ಹೇಳಿದ
ಅದನ್ನ ಕೋರ್ಟ್ ಮುಂದೆನೇ ಮಾಡ್ಬೇಕು.
ಹೌದು, I would have informed my client ಗೆದ್ವಿ
ನೀವು ಕೋರ್ಟಲ್ ಡಿಕ್ಟೇಷನ್ ಆತರ ಹೇಳ್ತೀನಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಯಾಕೋ ಕ್ಲೈಂಟ್ ಇಲ್ಲಿ ಇರ್ತಾನೆ, ವಿಟ್ನೆಸ್ ಮಾಡಿರ್ತಾನೆ, ಮತ್ತೆ ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಹಿಯರ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಬೀನ್ ಸ್ಪೋಕನ್ ಹಾಕೋಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ಕರೆಕ್ಷನ್ಸ್ ಹಾಕೋಬೇಕು ಅಲ್ವಾ?
ಬಟ್ ಆ ದಿನ ನಾನು ಲಿಸ್ಟ್ ಕಾಸಸ್ ತೋರಿಸ್ತೀನಿ. ಇಟ್ ವಾಸ್ ನಾಟ್ ಫಾರ್ ಜಜ್ಮೆಂಟ್, ಇಟ್ ವಾಸ್ ಫಾರ್ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್. So even my learned friend was appearing, so he will also not dispute that. No, my lord, it is like this. So this honorable court itself says, I had not signed that order as on that day. So it was done only in the month of November. By which time, my lord, the conviction has happened without having any care for, my lord, the interim order of stay which was there in this court. Now next, my lord, ನಾನು ಅಲ್ಲಿಗೆ ಸ್ಟಾಪ್
ಈಗ ನಾನು ಹೇಳೋದು ಓಪನ್ ಕೋರ್ಟಲ್ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತಾರೆ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನಾನು ಇನ್ನೊಂದು ಹೇಳ್ತೀನಿ.
ರಿಸಲ್ಟ್ ಏನಾಗುತ್ತೆ
ಅಲ್ಲ ಅದನ್ನ
go and tell the trial court no the petition was not allowed on quest. ಅಲ್ಲ court can proceed with the matter ಅಂತ ಹೇಳ್ತಾರೆ. ಅವಾಗ ಏನ್ ಮಾಡೋದು?
ಮಲಾಡ್ I don't
4 ತಿಂಗಳ ಮೇಲೆ ನಾನು ಕರೆಕ್ಷನ್ ಮಾಡಿದೆ ಅಂದ್ರೆ
ಮಲಾಡ್ ನಾನು ಆ ಕಡೆ ಇದ್ರೆ ಆತರ ವಾದ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ನಾನು I cannot say
ಹೇಳಿದ್ದು ಪ್ರಾಕ್ಟಿಕಲ್ ಅಲ್ವಾ?
ಹೌದೌದು.
ಕೋರ್ಟ್ ಮುಂದೆ ಕೇಳಿರ್ತಾರೆ ಆರ್ಡರ್ ಏನಾಯ್ತು ಅಂತ ತಿಳ್ಕೊಳ್ತಾರೆ. ಆಯ್ತು ನೆಕ್ಸ್ಟ್.
Even otherwise, my lord, even otherwise, if one were to look into the order sheet of the honorable trial court, my lord, magistrate court, even before this first judgment was dictated, the trial is getting progress. Further cross ಮಾಡಲ್ಲ. So, my lord, that is what I am saying. That is my case.
ಈಗ ನನ್ನ ಪ್ರಶ್ನೆ ಏನು ಅಂದ್ರೆ, ನಿಮಗೆ ಫಸ್ಟ್ ಸ್ಟೇ ಕೊಟ್ರಲ್ಲ, ಹೌದು, ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್, ಹೌದು, ಆ ಆರ್ಡರ್ ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದೀರಾ?
ಅದಕ್ಕೆ ನಾನು ಫಸ್ಟ್ ನಾನು ತೋರಿಸ್ತೆ ಹಾಕಿದ್ದೀನಿ.
ಅದ್ಯಾವುದು ಲೆಟರ್ ಡಾಕ್ಯುಮೆಂಟ್? ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಎಂಟ್ರಿ ಇದೆಯಾ ಅದ್ರ ಬಗ್ಗೆ?
ಇದೆ ಸ್ವಾಮಿ. Mixed up both the files, no?
Trial court order sheet.
Start from page number 124.
ಒಂದು ನಿಮಿಷ ಸರ್, I'll point it to the court.
ನಾವೇನು ಹೇಳ್ತಿಲ್ಲ, ಡೇಟ್ ಅಷ್ಟೇ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. 138 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಈ ಡಿಸ್ಪೋಸ್ ಆದ ನಂತರದ ಆರ್ಡರ್ ಶೀಟ್ ಸ್ಟಾರ್ಟ್ ಫ್ರಮ್ ಪೇಜ್ ನಂಬರ್ 138. 138.
ಯಾವ್ದು 138 ಅಂತ ಯಾವ್ದು ಈ ಪೇಜ್ ಇದ್ರಲ್ಲಿ ಇಲ್ವಲ್ರಿ? ಇದೆಯಾ 138? ಹಾ, ಹಳೆ ಇದ್ರಲ್ಲಿ
ಅಷ್ಟೇ ನಾನು ಹೇಳಿದ್, ಬೇರೆ ಏನು ಹೇಳಿಲ್ಲ.
138.
My lord may kindly see page number 73 ಬನ್ನಿ.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಯಾವತ್ತದು ಡೇಟ್? ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದು?
Interim stay was given on various dates, my lord.
ಅಲ್ಲ ಫಸ್ಟ್
ಇದರಲ್ಲಿ ನಾನು ಬರೀ ತಾವು 70 page 72 ನೋಡಿದ್ರೆ ಆಯ್ತು, ಅಷ್ಟು ನೋಡಿದ್ರೆ ಆಯ್ತು.
70
ಪೇಜ್ ನಂಬರ್ 63ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಅವ್ರು ಹಾಕಿರೋ
63.
Interim order was given initially on 8/6/2000.
day of June 20.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ my lord may kindly
stay ಇದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ. My lord may kindly see page 72 because I've marked everything. That's why I'm able to tell.
72.
72. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ತಾವು 71 ಬನ್ನಿ, one page before. It says, read High Court order dated 8/6/21 ಅಂತಿದೆ.
71.
ಹೌದು ಸ್ವಾಮಿ, 71. Read High Court, ಇಲ್ಲಿದೆ. Read High Court order, ಇಲ್ಲ ಸೆಕೆಂಡ್ ಲೈನ್.
Page 71.
71 ಅಲ್ಲಿ ಇದು.
ಹಾ.
So it's
Read
entry
High
ಮಾಡು.
Court order dated 8/6/21.
ಹೌದು. ಅವತ್ತು ಫಸ್ಟ್
ಅಲ್ಲಿಗೆ entry ಮಾಡಿ 8/6 ಆಗಿದೆ ಅಂತ.
ಹೌದು 21 itself. It got extended and also communicated, learned by. Then next page ನೋಡಿ ಸ್ವಾಮಿ, 73. It is my memo which I filed before the learned magistrate saying stay ಆಗಿದೆ ಅಂತ.
ಬಟ್ ನೀವು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 805 ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
That is the main matter ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ.
ಮೆಮೋದಲ್ಲಿ
805 ಅಲ್ಲ. See, it is like undersigned company so and so. The Honorable Court, accused submits that Honorable Court of Karnataka stay order criminal petition 805, the same may be ಅಂದ್ರೆ CC number 5012. ನಾನು ಕೇಸ್ ನೋಡಿ ಸ್ವಾಮಿ, CC ನಾನು CC ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
ಇಲ್ವಲ್ಲ ಮೆಮೋದಲ್ಲಿ CC ನಂಬರ್
ಇದೆ ಸ್ವಾಮಿ.
CC 5012.
5012 ಇಲ್ಲಿ.
ಆಯ್ತ್ರಿ, ಅದೇ ಕೇಸಲ್ಲಿ ಹಾಕಿದಿರಿ.
ಅದೇ ಕೇಸ್.
ಬಟ್ ನೀವು ಕೊಟ್ಟಿರೋದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ 805 of 2021.
805 ಅಂದ್ರೆ ಇಟ್ಸ್ ಅ ಮೇನ್ ಮ್ಯಾಟರ್.
ಮೇನ್ ಮ್ಯಾಟರ್ ಆಗಿ ನೀವು ಕನೆಕ್ಟೆಡ್ ವಿತ್ ಅಂತ ಹಾಕ್ಬೇಕಿತ್ತು. ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ 907.
It might have been done by the magistrate. ಸ್ವಾಮಿ ನಾವು ಕೊಲೀಗ್ಸ್ ಹಿಂಗ್ ಹಾಕಿದ್ದಾರೆ, ಬಟ್ ಮೇನ್ ಕಾಸ್ಟ್ ಇದೆಲ್ಲ ಹಾಕಿದೀವಿ and have taken certified copy from the court.
ಅದು ಫೈಲ್ ಮಾಡಿರೋದು ಯಾವಾಗ? 25/2/22 ನಿಮ್ ಪ್ರಕಾರ ಸ್ಟೇ ಆಗಿರೋದು 8/6/21 ಅಲ್ಲಿ.
ಹೌದು.
ಆಲ್ಮೋಸ್ಟ್ 8 month ಮೇಲೆ.
ಅಲ್ಲ, it was also intimated. The learned magistrate would not take, but I don't want to make any allegations. My case is that during subsistence of the stay, the trial has proceeded. And after that, by virtue of the Honorable Supreme Court, when the site is not signed, the stay continues. And my lord is very well aware, the latest Asians resurfacing judgment na clarify ಮಾಡಿದ್ದಾರೆ of Supreme Court, which I have also produced. I'll produce it right away, my lord.
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವಾಗಿಂದ ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದ್ದು? 8/6/21 ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ? 5012
ಆರ್ಡರ್ ಶೀಟ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
5012 ನಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್
ನಾನು ಇಲ್ಲಿ
8/6/21 ಮೇಲೆ ಏನಾದ್ರು ಕಮ್ಯುನಿಕೇಟ್ ಆದ ಬಗ್ಗೆ ಏನಾದ್ರು ಇದೆಯಾ ಆರ್ಡರ್?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಕಮ್ಯುನಿಕೇಶನ್ ಇರ್ಲಿಲ್ಲ. ದಟ್ ಈಸ್ ವೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಡ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಅಂಡ್ ವೆರಿಫೈ.
ಇಲ್ಲ, 8/6/77/21 ಇಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್.
ಅಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟೆ. There was, my lord, I'm making a submission from the bar. It is absolutely no falsehood. Wherein, my lord, the learned judge of this honorable court, but coordinate bench, asked to verify whether the learned magistrate, and it was found, yes, ಆಗಿದೆ ಅಂತ. I'm telling.
ಆಗಿದೆ ಅನ್ನೋದು ಎಲ್ಲಿದೆ? ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಇದೇ ಕ್ವೆಶ್ಚನ್ learned judge asked. ಅದಕ್ಕೋಸ್ಕರ a date was given. My lord may kindly see the order sheet of this honorable court.
ಯಾವ್ದ್ರಲ್ಲಿ? ಈ ಕೇಸ್.
ಹೌದು, ಇದೇ ಕೇಸಲ್ಲಿ ಹಿಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಜಸ್ಟಿಸ್ ರಾಚಯ್ಯ had referred the matter, my lord, for verification. ತಾವು ನೋಡ್ಬೋದು. In fact, my friend was also fair enough to admit it also, because even he was not aware.
ಕನೆಕ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಅಂತ ಇದೆ. ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದು ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಜಸ್ಟಿಸ್ ರಾಚಯ್ಯ ಅವರನ್ನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
ಸ್ವಾಮಿ, ಓಪನ್ ಕೋರ್ಟ್ ಸ್ವಾಮಿ, ನಾನು ಆರ್ಡರ್
ಫಸ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆಲ್ಲ ಕ್ಲಬ್ ಆಗಿದೆ ಅಲ್ಲ, ಆ ಮೇನ್ ತಗೊಳ್ಳಿ. ಯಾಕೆಂದ್ರೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಬರೆಯಲ್ಲ ನಾವು. ಒಂದ್ರಲ್ಲಿ ಕ್ಲಬ್ ಆದ್ಮೇಲೆ ಎಲ್ಲ ಒಂದೇ ಆರ್ಡರ್ ಶೀಟ್ ಮುಂದಕ್ಕೆ ಕಂಟಿನ್ಯೂ ಆಗ್ತದೆ.
No, my lord, may kindly see. An order sheet also I produced. Page 136 ತಾವು.
ಈವನ್ ನೋಡ್ರಿ, ಅಕಾರ್ಡಿಂಗ್ ಟು ಇವನ್ ಈ ಕೇಸಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಟ್ರೆ ನಿಮ್ಮವರೇ ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು 436.
Can I tell the reason? The reason, my lord, the reason is
23/6/22.
that is because NBWL issue ಮಾಡಿ learned magistrate doesn't take. The learned magistrate would say, ಇಲ್ಲ 6 ತಿಂಗಳಲ್ಲಿ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ, ಸ್ಟೇ ಇಲ್ಲ, ಅದಿಲ್ಲ, all those things. But my lord, that was not it. And my lord, we were very scared, and we would have appeared. But merely because I am subjecting myself, my lord, the learned magistrate cannot give away the rules, my lord. There was an interim order of stay.
That's what I am telling.
Lord, I cannot be, my lord, I was an accused in a court.
Order was communicated to the learned magistrate.
My lord, I have produced it, my lord, at page ಅದರಲ್ಲಿ.
ಆ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ, ಹೇಳಿ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿರೋದು. ನಿಮ್ಮ ಅದೇ ನೀವೀಗ ಹಾಕಿರೋ ಮೆಮೊ ಪ್ರಕಾರ ಇದೆ.
ಸರಿ, ಬೇಡ ಸ್ವಾಮಿ, ಅದು ನಾನು ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿರೋದು ತಾವು ನೋಡ್ಬೋದು. ಪೇಜ್ ನಂಬರ್ 72 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಕೆಳಗಡೆ ನೋಡಿ.
72 ನಲ್ಲಿ
ಇಲ್ಲಿ
ಇಲ್ಲಿ ಕಾಪಿ ಟು ಅಂತ ಇರುತ್ತ್ರಿ,
Copy two.
ಕಾಪಿ ಟು ಅಂತ ಇರುತ್ತೆ, ಕಾಪಿ ಓದ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
My lord, I have not.
It should be in
Ad-
record ಅಲ್ಲ.
My lord, that is why.
ಇದು ಆಫೀಸಲ್ಲಿ ಮಾಡೋ ಕೆಲಸ. ಎಂಟ್ರಿ ಮಾಡಿದ ತಕ್ಷಣ ಇದನ್ನ ಟೈಪ್ ಮಾಡಿಬಿಟ್ಟು ಕಳಿಸ್ಬೇಕು.
ಹೌದು.
ಹೌದಾ?
ಹೌದು.
ಅಲ್ಲಿಗೆ ರೀಚ್ ಆಗ್ಬೇಕು ಅದು. ರೀಚ್ ವೆದರ್ ಇಟ್ ಈಸ್ ಇನ್ ದ ನಾಲೆಡ್ಜ್ ಆಫ್ ದಿ ಜಡ್ಜ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಿದೆ material?
ಅದಕ್ಕೋಸ್ಕರ ನಾನು am telling,
ಹಾ.
my lord, that same questions was asked by this honorable court and my lord, ಅದಕ್ಕೊಂದು ಡೇಟ್ ಹೋಯ್ತು.
ಯಾವತ್ತು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ
ಸ್ವಾಮಿ ನಾನು ಅದು ಬರ್ಕೊಂಡಿಲ್ಲ, but I am telling, my lord, it did happen. It is
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಆತರ ಇರ್ಬೇಕಲ್ಲ ಯಾವ್ದಿದೆ ಅಂತ.
I don't know, my brother is also here. He will also say whether ಆಯ್ತಾ ಇಲ್ವಾ ಅಂತ. My lord, if he is saying that such an incident did not happen.
ಆರ್ಡರ್ ಮಾಡೋರು ಅಂತ ವೆರಿಫೈ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದೆ. ಯಾರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರು?
ಇವ್ರಿಗೆ registry of the trial court.
Registry-ಗೆ.
ನಮ್ಗಲ್ಲ.
Petitioner submit that annexure E has been communicated to the concerned jurisdiction magistrate wide its order dated 28/6/21. Registry is directed to furnish the details regarding communication of this order to the jurisdictional magistrate ಅಂತಿದೆ. ಇದ್ರ ಮೇಲೆ ಏನಾಗಿದೆ ಮೇಡಮ್ ನೋಡಿ?
ಇಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಅವ್ರು ಬಂದಿದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ.
ರಿಜಿಸ್ಟ್ರಿ ಡೈರೆಕ್ಟ್ ಮಾಡಿ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದಾರ? ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ?
ಹೌದು ಸ್ವಾಮಿ, ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರದ್ದು ಎಲ್ಲಿದೆ ರಿಪೋರ್ಟ್?
ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ my lord, ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಐ ಆಮ್ ಅವೇರ್.
Registry is directed to furnish the details regarding communication of this order to the jury. ಇದ್ರ ಮೇಲೆ ಏನಿದೆ ಮೇಡಮ್ ರಿಪೋರ್ಟ್? ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಕಮ್ಯುನಿಕೇಶನ್ಗೆ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಕೆಲಸ ಅದು. ರಿಜಿಸ್ಟ್ರಾರ್ ಅಂತ ಮಾಡೋದಲ್ಲ, ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಅಂತಾನೆ ಮಾಡ್ಬೇಕು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ.
ನಾಳೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ ಅವರು ಹೇಳಿ ಹಂಗಿದ್ರೆ, then it will please the issue. ನಾಳೆನೇ ಹಾಕೊಳ್ಳಿ once again. Because I am very sure it was done.
ಮೇಡಮ್ ಅದರಲ್ಲಿ
ಇದ್ರಲ್ಲಿಲ್ಲ
ರಿಪೋರ್ಟ್
ಏನಾದ್ರು ರಿಪೋರ್ಟ್
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ಇರ್ಬೇಕು ಮೇಡಮ್. ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಾದ್ರು ಕೊಡ್ಬೇಕು. ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಕಮ್ಯುನಿಕೇಟೆಡ್ ದಿ ಆರ್ಡರ್ ಟು ದಿ ಜಡ್ಜ್. ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇಟ್ಟಿರ್ತಾರೆ ಅಂತನಾ? ಯಾರ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತನಾ? ನೋಡಿ.
ನನ್ನ ನಾಲೆಡ್ಜ್ ಪ್ರಕಾರ ಕೇಳಿದೀನಿ ಸರ್ವಾಗಿದೆಯಂತೆ ಅಂತ ಏನೋ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು. ಕೇಳಿದೀನಿ ಸರ್ವಾಗಿದೆಯಂತೆ ಅಂತ. ನಾನು ಹಂಗಂದ್ರಾಗೆಲ್ಲ ರಿಪೋರ್ಟೇ ತರಿಸ್ಬೇಕು ಅಂದೆ. ಸೊ ಅದಾದ್ಮೇಲೆ ಮುಂದೆ
ಫ್ರೆಂಡ್ ಹೌದು ಆ ತರ ನಡೆದಿದೆ.
ಈಗ ರಿಜಿಸ್ಟ್ರಿ ಅವ್ರು ಮತ್ತೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಮೇಲೆ ಏನ್ ಮಾಡಿ ವೆರಿಫೈ ಮಾಡ್ರಿ, ರಿಪೋರ್ಟ್ ತರಿಸಿದಾರ ಏನೋ ಅಂತ ಕೇಳಿ. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಕಮ್ಯುನಿಕೇಶನ್ ಆದ ಬಗ್ಗೆ. ಮತ್ತೆ
ಇವಾಗ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದು ಇಷ್ಟು, ನಾನು ಕೇಳಿದೀನಿ ಸರ್ವಾಗಿದೆಯಂತೆ ಅಂದ್ರು. ನಾನು ಹಂಗಂದ್ರಾಗೆಲ್ಲ ಅವ್ರು ರಿಪೋರ್ಟೇ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿದೆ. ಅದಾದ್ಮೇಲೆ ಮುಂದಕ್ಕೆ
ಡೈರೆಕ್ಷನ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್,
ನಾಳೆ
ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲಿ ಕೇಳಿ ಏನಾಗಿದೆ, ರಿಪೋರ್ಟ್ ತರಿಸ್ಕೊಂಡಿದಾರ?
ಅಫಿಷಿಯಲ್ ರಿಪೋರ್ಟ್ ಹಾಕ್ಲಿ, ಓರಲ್ ಆಗಿ ಹೇಳೋದು ಇದು ಅಷ್ಟು ಸರಿ ಆಗಲ್ಲ.
ನೋಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ರಿ, ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಹಾಕಿ.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್
28
ಆಯ್ತು ನೋಡಿ ಮೇಡಮ್.
ಈ ಇನ್ನೊಂದು ಕೇಸ್ನ ಮೊದಲನೇ ಕೇಸ್ ಮುಗಿದ್ಬೋದು, ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೇ ಇಲ್ಲ ಮೊದಲನೇದ್ರಲ್ಲಿ. ಅದು ಮುಗಿಸ್ಬೋದು, ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು.
556 ಅಲ್ಲ?
ಹೌದು, ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ ಮಾಡಕ್ಕೆ. ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ಬೋದು.
ಈಗ ಈ ರೀತಿ ಆಗಿರೋದು ಎಂಟ್ರಿ ಮಾಡ್ರ ಆದ್ಮೇಲೆ
ಮೂರು ಕೇಸಲ್ಲಿ
ಈ ಮೂರು
ಕೇಸಲ್ಲಿ ಆಗಿದೆ. ಮೂರು 554, 557, 558.
ಹೌದು
ಮೇಡಮ್, ಇದು ಮೂರು ನೋಡ್ರಿ ಮೇಡಮ್. ಈ ಮೂರಕ್ಕೂ ಸಂಬಂಧ ರಿಪೋರ್ಟ್ ಇದೆಯಾ ಅಂತ ನೋಡಕ್ ಹೇಳಿ.
ಆಲ್ ಡೇಟ್ಸ್ ಆರ್
554, 557, 558 ಅಲ್ಲಿ ಆರ್ಡರ್ ಯಾವಾಗ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿದೆ ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಂತ ನೋಡ್ಬೇಕು. ಒಂದು ಈಗ ಬಂದಿದೆ ರೆಕಾರ್ಡ್ಸ್, ಅದೊಂದು ಚೆಕ್ ಮಾಡ್ಬೇಕು ಮೂರು ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಇಲ್ಲ ಅಂದ್ರೆ ರಿಪೋರ್ಟ್ ಏನಾಗಿದೆ, ರಿಜಿಸ್ಟ್ರಾರ್ ಏನ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಆಮೇಲೆ 556 ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು, ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನು ಇರ್ಲಿಲ್ಲ. ಮೊದಲನೇ ಮ್ಯಾಟ್ರ್
ಒಟ್ಟಿಗೆ ಮಾಡಿ, ಇದೇನು ಮತ್ತೆ ಡೀಲಿಂಗ್ ಮಾಡೋದಕ್ಕೆ ನೋಡಿ.
ಆಮೇಲೆ ಇದು ಯಾವ್ದ್ರಲ್ಲೂ ಎಂಟ್ರಿ ಮಾಡ್ರನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಕೋ ಕೇಸಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ.
ಎಂಟ್ರಿ ಮಾಡೋರು ಸ್ಟೇ ಕೊಟ್ಟಾಗ ಆರ್ಡರ್ ಇದೆಯಾ?
ಹೌದು, 4ರಲ್ಲೂ ಇದೆ.
ಏನ್ ಆರ್ಡರ್ ಇದೆ?
ಅಲ್ಲ, ಇದು ರಿವಿಷನ್ ಹೇಳ್ತಾರೆ.
ಅದಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರೆ ಈ ಆರ್ಡರ್, ಈ ರಿವಿಷನ್ಸ್ ಅಲ್ಲ.
ಈ ರಿವಿಷನ್ ಗಳು ಸಬ್ಜೆಕ್ಟ್ ಟು ಡಿಪಾಸಿಟ್ ಅಂತ ಎಂಟ್ರಿ ಮಾಡ್ರು.
ಯಾವ್ದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ
ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ನಾವೇ ನಿಮ್ಮನ್ನ ಹಿಯರ್ ಮಾಡ್ಬೇಕು.
ಕಮ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ my lord. ಅವ್ರ ವಾರೆಂಟ್ ಎಲ್ಲ ಆಗಿದೆ, ಅರೆಸ್ಟೆಡ್ ದೇ ವಿಲ್ ಫೇಸ್ ಇಟ್ ಅಷ್ಟೇ. ನಾನು ಹೇಳ
ವಾರೆಂಟ್ ಆಗಿದ್ರೆ ಅರೆಸ್ಟ್ ಆಗೋರ?
ಅಲ್ಲ ಅವ್ರ
ನಾನು ಹೇಳ್ತಾರೆ ವೈ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಹಿಯರ್ ದಿಸ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ಸ್ ಇಫ್ ಯು ಆರ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್ ವಿತ್ ದಿ ಆರ್ಡರ್.
My submission was that when there is an order of the court of staying, my lord, I was not even aware of the cases. I only went and just took bail. After that, my lord, I was subject to a conviction.
Then you make it the case that order was communicated and in spite of communication of the order, trial court has proceeded to pass an order, another you convince ಮಾಡ್ಬೇಕು courtಗೆ.
My lord, that's what my endeavor, my lord, I'm doing.
ಅಲ್ಲ, but here in this case, revisions ಅಲ್ಲಿ stay ಆಗಿದೆ, subject to
Deposit.
deposit. If you are not deposited, why court has to hear the matter?
But my lord, my revision may be heard, my lord. I'm
Revision-
not, I'm interim better Swami. If I'm arrested, I will face, I'll have to face it. Brother, I'm
Then,
come before.
if you have not complained, you can proceed
Yes,
against
yes,
them.
my lord,
That's
let
all.
him do it.
ವಾರಂಟ್
Then
ಇಶ್ಯೂ
proceed
ವಾರಂಟ್
against-
ಇಶ್ಯೂ ಆಗಿದೆ, ಅವ್ರು ಸಿಗ್ತಾ ಇಲ್ಲ. ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ, ಸಿಗ್ತಾ ಇಲ್ಲ.
ಆಯ್ತು.
ಎಲ್ಲದ್ರಲ್ಲೂ ವಾರಂಟ್ ಇದೆ.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ವಾರಂಟ್ ಆಗಿದೆ.
ಹೌದು, 4ರಲ್ಲೂ ವಾರಂಟ್ ಇದೆ.
ಆಯ್ತು, ಯಾವತ್ ಮೇಡಮ್ 28/4 ಚೆಕ್ ಮಾಡಿಸಿ. 28/4 ಹಾ ಪ್ಲೀಸ್. 23.
64. Vinita PC.
Non-compliance of office of
Prasanna
Registration IA 1/24 for release of amount.
But I am for the respondent.
ಅಯ್ಯ ಹಾಕಿರ್ದಾರ ನೀವಾ?
ಹೌದು, ನಾವೇ.
Why you have not complained?
But the copy has been served to other side, I think.
ಅದರ್ ಸೈಡ್ ಗ
ಹೌದು.
ಶುರು ಮಾಡಿದ್ರೆ ಹೋಗ್ಲಿ ಇವತ್ತಾರು
ಮಾಡಿದ್ದೀನಿ, ಮೊನ್ನೆನೇ ಮಾಡಿದ್ದೆ.
ವಿನೀತಾ PC ಅವ್ರಿಗೆ ಜಾರಿ ಮಾಡಿದ್ರ ಯಾವಾಗ?
Last 2 hearing back, I have served the copy, but I'll complain, ಬರ್ಲಿಲ್ಲ, sorry my lord.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಂತೆಲ್ಲ ಇದೆ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮೋಸ್ಟ್ಲಿ ನೋಡಿ ಮೇಡಮ್, ಕಾಪಿ ನಾಟ್ ಸರ್ವ್ಡ್ ಅಂತನಾ
ಹೌದು ಸರ್.
ಕೊಟ್ಟಿದೀವಿ.
ಕೊಟ್ಟಿದ್ದೀವಿ. ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಬೇಕು ನಮ್ಗೆ. ಹಾಕಿದೀರಾ?
ಇದ್ರಲ್ಲಿ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಬೇಕಲ್ಲ?
and after that, my lord, she appeared, ಅವ್ರು ಬಂದಿದ್ದಾರೆ, appear ಆಗಿದ್ದಾರೆ.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ದ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆ ಅಂತ ಅಲ್ಲ ಅದು.
Sir.
ಕೌನ್ಸಿಲ್ ಬರ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ರು.
ಏನಂತ?
I mean family court ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ಳಿಲ್ಲ,
ಹಾ.
ನೋಡಿ ವಾಟ್ ಹ್ಯಾಪನ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಇದರಲ್ಲಿ ಅವರು ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕಿ, in fact it is not on merits, my lord, judgment, trial court passed the judgment on the basis of the joint memo filed by
ಜಾಯಿಂಟ್
the,
ಮೆಮೊ ಮೇಲೆನೆ.
please, 19 ಲಕ್ಷ.
ಅದ್ರ ಮೇಲೆ ಹೆಂಗ್ ರಿವಿಷನ್ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ,
If they have filed the joint memo, not
Yes.
complied it.
ಹೌದು
Revision is not maintainable.
ಹೌದು. ಆಮೇಲೆ ಏನಾಯ್ತು, ಆಫ್ಟರ್ 8 months ಕೋವಿಡ್ ಆದ್ಮೇಲೆ ವಿ ಆರ್ ನಾಟ್ ಪ್ರೆಸಿಂಗ್ ದಟ್ ಜಾಯಿಂಟ್ ಮೆಮೋ ಅಂತ ಹೇಳ್ತಾರೆ ಕೋರ್ಟಿಗೆ.
ಅದ್ ಹೆಂಗ್ ಮಾಡಕ್ಕೆ?
ಅದೇ
ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿತ್ತಾ?
ಹೌದು, ಜಾಯಿಂಟ್ ಮೆಮೋ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿ
ಜಾಯಿಂಟ್ ಮೆಮೊ ಬೇಸಿಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಕನ್ವಿಕ್ಷನ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಹಾ?
ಅದು ಜಾಯಿಂಟ್ ಮೆಮೋ ವಾಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್.
ಏನಂತ?
ಡೇಟ್ ಕೊಟ್ರು, ಕೋರ್ಟಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಿರಲಿಲ್ಲ ಕೇಸು.
ಡೇಟ್ ಕೇಸ್ ಕ್ಲೋಸ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ, ವಿದಿನ್ 10 installment you have to pay 1 lakh each ಅಂತ ಮಾಡಿದ್ರು. ಬಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪೇಡ್ ಇವನ್ ಸಿಂಗಲ್ ಪೈ. ಆಫ್ಟರ್ 8 months ದೇ ಫೈಲ್ಡ್
ಕೇಸ್ ಕಂಟಿನ್ಯೂ ಆಯ್ತು.
ಕಂಟಿನ್ಯೂ ಆಯ್ತು.
ಹಾ.
ಕಂಟಿನ್ಯೂ ಆದ್ಮೇಲೆ ಅವ್ರು ಬರ್ಲಿಲ್ಲ.
ಹಾ.
ದೇ ಫೈಲ್ಡ್ ಎ ಮೆಮೋ ಟು ಅಜೆಂಡಾ ಮ್ಯಾಟರ್. ಆಫ್ಟರ್ ದಟ್ ಅವ್ನು ಬರಲೇ ಇಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಅಪಿಯರ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
Ultimate ಆಗಿ ಏನಾಯ್ತು ಆರ್ಡರ್?
3-1 ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ
313.
313 ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ ಜಜ್ಮೆಂಟ್ ಮಾಡಿ
Proceeded to pass an order.
passed that
ಆಯ್ತು.
order. Against that, my lord, they preferred a revision. Revision was also dismissed.
ಹ್ಮ್.
ಈಗ ಇಲ್ಲಿ ಮತ್ತೆ appeal was also dismissed. They filed a revision.
ಹ್ಮ್.
ಅದರಲ್ಲಿ 40% amount they have deposited. I filed
ನೀವು
application.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಿ. ತಗೊಳ್ಳಿ. Respondent counsel is directed to file an acknowledgement for having served the copy of IA number 1/24. ಅದೊಂದೇನಾ ಮೇಡಮ್ ಇರೋದು objections
ಹೌದು ಸರ್, ಅದೊಂದೇ ಇರೋದು. ಕಾಪಿ ನಾಟ್ ಸರ್.
on the petitioner counsel and list this matter on 28/3.
Please, apply.
65. Raghunath K.
Prashant UT.
For responding in this case, my lord, please.
Sorry, my lord. Sorry, instead of 28, 27, instead of 28, my lord, it could be taken on 27th.
27th ಬೇಕಾ? ಆಯ್ತು, 27/8.
Please, 27/3,
27/3.
please. Apply.
Yes, counsel ಹೇಳ್ರಿ.
And for appellant, my lord.
Petitioner. 60.
The judgment passed on the basis of joint memo,
On the
basis of joint memo filed by both the.
joint memo.
Yes, ma'am.
ಹಾ.
So joint memo filed on that day, the trial court was not considered the joint memo and disposed of the matter.
Installment.
Installments.
ಹಾ.
After the elapse of 189 days, the joint memo considered and the trial court disposed of the complaint by convicting the accused petitioner hearing. And thereafter.
Default accused shall have to undergo simple imprisonment for a period of 2 years.
Yes, ma'am.
The entire fine amount shall be paid to the complainant as compensation as per section 357 of CRPC. ಆಯ್ತು ಹೇಳಿ.
So after that, we preferred an appeal before the first appellate court and which came to be dismissed. And while dismissing the first
appeal
by the first appellate court, the grounds which were argued before the trial appellate court was not at all considered, my lord.
ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ ನಿಮ್ದು?
So ಇಲ್ಲಿ ಒಂದ್
Consent-
ಅಲ್ಲ
consent court ಮೇಲೆ ಏನ್
ಇಲ್ಲ
ground
ಇಲ್ಲ
ಏನ್
ಇದು
ನಿಮ್ದು?
ಏನಾಗಿದೆ ಅಂದ್ರೆ on the when very first day of the accused appeared before the trial court, the plea was recorded.
Yeah.
On the next day of hearing, he was insisted and instigated by the complainant as well as his counsel to file joint memo. The contents of the joint memo was not aware about by the petitioner hearing. And he was filed and thereafter he kept quiet. After a lapse of 189 days,
ಅಲ್ಲ ರೀ, if he is not aware of the same,
yes,
then why he did not bring it to the court notice that joint memo is filed fraudulently before the court?
so for that purpose, we are, we urged the same before the first appellate court.
ಅದೇ first payment due ಇತ್ತಲ್ಲ
ಇಲ್ಲ
15.
ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವ್ದು payment?
ಯಾವ್ದು
ಮಾಡಿಲ್ಲ?
ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಪೇಮೆಂಟ್ ಮಾಡೋದು ನಮ್ಗೆ ಗೊತ್ತಿದ್ರೆ ನಾವು ಮಾಡ್ತಾ ಇದ್ವಿ. ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಸೊ ಆಫ್ಟರ್ ಡಿಸಾನರ್
ಜಾಯಿಂಟ್ ಮೆಮೊ ಕಾಪಿನಲ್ಲಿ ಸೈನ್ ಮಾಡಿದಾರ ನಿಮ್ಮವರು?
ಮಾಡಿದ್ದಾರೆ.
ಸೈನ್ ಮಾಡಿದ್ರು.
ಮಾಡಿದಾರೆ.
ಅವರು ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ
ಮಾಡಿದ್ರು. ಬಟ್ ವಿಚ್ ವಾಸ್ and
ಅದು ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕಿರೋದು ಜಾಯಿಂಟ್ ಮೆಮೊ. Now you cannot contend that
and one more
not aware of the same.
and one more submission.
ಹಾ ಹೇಳಿ.
So judgment dated judgment of trial court man.
ಹಾ 27/8/21.
Page number
26/8/21 marks, please.
ಆಯ್ತು, ಒಂದು ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಇದೆ ಅಂತ ಡೇಟ್.
ಅಲ್ಲ ಅದಲ್ಲ. Page number 35 annexure B ಮೇಲೆ.
ಪೇಜ್ ನಂಬರ್ 35.
35 annexure B.
ಹಾ ಇದೆ.
26th day of August
ಹೌದು.
2021.
2021 ಅಂತಲೇ ಇದೆ.
ಹೌದು. So ಕೆಳಗಡೆ ಸ್ವಾಮಿ date of judgment 25/8/2021.
ನೋ ಸಿಗ್ನೇಚರ್ 27/8 ಅಂತಲೇ ಇದೆ.
ಅಲ್ಲ ಸಿಗ್ನೇಚರ್ 27/8 ಇದೆ ಸ್ವಾಮಿ.
ಹಾ
ಮೇಲ್ಗಡೆ 26th August ಇದೆ ಸ್ವಾಮಿ.
ಹೌದು.
ಸೊ ಇಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ 25th August 2021 ಇದೆ.
ಒಂದ್ ದಿವಸದ ಹೆಚ್ಚಿಗಿಂತ
25
ನಾಳೆ ಡೇಟ್ ಹಾಕೋರು ಜಡ್ಜ್ ಅಷ್ಟೇ.
25, 26, 27 ಮೂರು ಡೇಟು ಇದೆ ಸ್ವಾಮಿ.
ಮೂರ್ ಇಲ್ರಿ,
ಮೂರ್ ಇದೆ.
26th ಅಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಬಾಡಿ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಮೇಲ್ಗಡೆ 26th August ಇದೆ ಸ್ವಾಮಿ.
26th ಇದೆ ರೀ.
ಹೌದು ಸ್ವಾಮಿ. ಕೆಳಗಡೆ
ಬಾಟಮ್ ಅಲ್ಲೂ 26th of August 2021 ಇದೆ.
ಇಲ್ಲ
ಅಲ್ಲೂ ಸೈನ್ ಮಾಡುವಾಗ 27/8 ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ಡೇಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಪೇಜ್ ನಂಬರ್ 35 ಅಲ್ಲಿ
ಅದೇನೆ ಡೇಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ 26th ಅಂತ ಇದೆ.
25/8/2021 ಇದೆ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಕಾಲಮ್
ಅದ ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಆಯ್ತು. ಆಮೇಲೆ
ಅಂಡ್ ಸಿಗ್ನೇಚರ್ 27/8
that cannot be a technicality.
and the operative portion madam at page number 44. In default, the accused shall have to undergo simple imprisonment for a period of 2 years.
ಹೌದು.
So in respect of order dated 27/8/2021 madam. Order sheet nalli in default accused shall have to undergo simple imprisonment for a period of 1 year anta ide sir.
ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲ?
Order sheet nalli sir. Order sheet dated 27/8.
ಆಯ್ತು, 1 year ಮಾಡೋಣ ಬಿಡಿ.
1 year antide sir. So in addition to that, we have already paid
ಆರ್ಡರ್ ಶೀಟ್ ಅದು.
order sheet to trial court record nalli ಇದೆ sir.
That has been rectified later, my lord. That has been rectified by order dated 21/1/22.
ನಾನು ಮುಗಿಸ್ತೀನಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೆಕ್ಟಿಫೈ ಆಗಿದೆಯಾ?
ಹೌದು ಆಗಿದೆ. By order dated 21/1/2022, that has been rectified.
21/1/2022.
22 after the lapse of 4 months ಮೇಲೆ ಅಷ್ಟರೊಳಗೆ ನಾನು ಅಪೀಲ್ ಪ್ರಿಫರ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ. ಸೊ ಅಪೀಲ್ ಅಲ್ಲಿ ಗ್ರೌಂಡ್ಸ್ ಎಲ್ಲ ರೈಟ್ ಮಾಡಿ
ಪ್ರಿಫರ್ ಮಾಡಿಲ್ಲ.
ಅಪೀಲ್ ಪ್ರಿಫರ್ ಮಾಡಿದ್ದು
ಇಲ್ಲ, ಮಾರ್ಚ್ ಅಲ್ಲಿ ಪ್ರಿಫರ್ ಮಾಡಿದ್ವಿ.
ಇವನ್ ಆಯ್ತು, ಅದೆಲ್ಲ ಟೆಕ್ನಿಕಲಿಟೀಸ್. ಆಮೇಲೆ ಬಿಡಿ, ಈಗ ರಿವಿಷನ್ ಏನ್ ಗ್ರೌಂಡ್ ಹೇಳಿ.
under that circumstances the matter has to be remanded back to the trial court.
ರಿಮಾಂಡ್
So for that
ಕರೆಕ್ಷನ್ ಮಾಡಿ ಅಂತನಾ ಅಥವಾ
ಇಲ್ಲ, not only for this my lord, the fair opportunity should be given to the
ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕು?
ಅಲ್ಲ ನಾವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, we have not denied any documents.
ಕ್ರಾಸ್ ಏನ್ ಮಾಡೋದು?
ಇಲ್ಲ, in addition to that, the trial court as well as the first appellate court was not at all whispered anything in respect of the grounds which were urged before the trial court as well as before
For the petitioner counsel and also the counsel appearing to the respondent. This revision petition is filed challenging the judgment of conviction passed for the offence punishment of section 138 of Negotiable Instrument Act based on the joint memo filed by the petitioner as well as complainant. And in terms of the joint memo, ten installments were given to make the payment on 15th of every month, starting from 15/6/21 to 15/3/22. The said order was not complied, but criminal appeal was filed. In 2022,
ಇಲ್ಲ ಸ್ವಾಮಿ 23 22
ನೇ ಆಗಿದೆ.
ಮಾರ್ಚ್ 2022 after 1 year 1 month from the date of joint.
22ರಲ್ಲಿ ತಾನೇ ಹಾಕಿರೋದು ಅದು?
ಹೌದು ಸಾರಿ
ಅದೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. 2022. That is after the expiry of 10th installment dated 15/3/2022. And he did not file appeal immediately. And the reason stated in the appeal that signature was obtained fraudulently by the complainant to joint memo, and no opportunity is given.
One more submission.
Hmm?
One submission. So the petitioner was not at all aware about the judgment passed by the trial court, my lord.
ಅದೇ
Or else he might have preferred in time only.
The contention of the revision petitioner before the appellate court also that he was not aware of the judgment of the trial court passed on the joint memo. And the first appellate court, having taken note of the contention, in paragraph number 27 discussed that it is clear that the complainant has proved that exhibit P1 is the check issued by the accused, and the same is belongs to the bank account of accused. Further, the accused has not denied his signature on exhibit P1. The check was presented and the same was dishonored, and issued the notice, and the same was served, and he fails to pay the amount. And even the complainant was examined as PW1 and documents exhibit P1 to 11 are marked. And the accused had actively participated in the proceedings before the trial court at all the stages. But in spite of sufficient opportunity given by the trial court, the accused has not produced any documents in support of his case. And taking into note of the said fact into consideration, as well as the appellate court also taken note of the joint memo filed by the parties, and not only considered the joint memo as well as the material available on record also considered, and dismissed the appeal. Being agreed by the said order of conviction as well as. Madam, ಯಾರ್ರೀ ಪಿನ್ ಹೊಡೆಯೋರು? ಎಷ್ಟು ಹೇಳೋದು, ಎಷ್ಟು ಹೊಡೆಯೋದು ನೋಡಿ ಮೇಡಮ್. ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅದು ಏನ್ ಮಧ್ಯದಲ್ಲಿ ಹಿಂಗ್ ಹೊಡಿತಾರೆ? ಯಾವ ಪೇಜ್ ಅಲ್ಲ? ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸ್ ಇಂದ ಇಲ್ಲಿವರೆಗೆ. ಮಾಡೋದು ಒಂದು ಕೇಸ್ ನೋಡಿ, ಒಂದು ಕೇಸ್ ಅಲ್ಲ ಎಲ್ಲಾದ್ರಲ್ಲೂ. The main contention of the revision petitioner before this court is that the accused public petitioner herein is misguided by his counsel who attends the matter before the trial court with the collusion of the complainant, and also contend that he hails from various, he is hailing from various health hazards and undergone surgeries, and that apartment he was affected by COVID-19. And also judgment was pronounced.
When he was arrested, then only he came to know about it.
And date was given and date was pronounced as 26/8/21, but judge has signed the same on 27/8/21. And council also brought to notice of this court that pronouncement of date is mentioned as 25/8/21, and there is clear discrepancy, and hence matter requires to be remitted back to the trial court for fresh consideration. Per contra, the counsel appearing to the respondent to submit that when the accused was represented through counsel, and also he is a part of signatory to the joint memo, and voluntarily he came and settled the matter for total amount of rupees
69,99,703.
and he had agreed to pay the amount in installments at the rate of rupees 7 lakh each for nine installments, and 10th installment for the difference amount of one more installment is dated 15/3/22 for rupees 6,99,703.
69 lakhs.
When the details are 6,99,000.
69 lakhs.
Last installment.
Supplementary last installment, 6,99,703. And when the installments also bifurcated and signed the joint memo, now he cannot contend that he was not aware of the same. It is also important to note that in terms of the installment also, he has not made the payment. And after almost 1.5 years, filed the appeal, and trial court has passed the judgment based on the joint memo, and now cannot seek for a remand on the ground of technicalities. Having heard the petitioner counsel and also the counsel appearing for the respondent, and also considering the grounds urged in the revision petition, and scope of revision petition is very limited. The scope of revision can be exercised only if any material available on record is not considered by the trial court as well as the first appellate court. The fact of filing of joint memo is not in dispute, but the contention of the revision petitioner that he was misguided by his advocate who was on record. No material is placed before the court that any action is taken against the advocate who has misguided him. And it is nothing but a ground is urged in the revision petition after thought. Though he had signed the joint memo and agreed to make the payment on 10 installments in view of voluntarily settled the case for an amount of rupees 69,99,703. Check amount history?
69,99,703.
They same
Also.
amount. The document exhibit P1 is also not disputed. And on the other hand, before the trial court also the complainant has been examined as PW1, and also documentary evidence are also relied upon, that is exhibit P1 check as well as check return memo, copy of the legal notice, copy of postal receipt, RPD acknowledgement, and 4 invoices are also produced, original letter to accused, and copy of board resolution meeting for initiating the proceedings also got it marked. When searching the case, and once the revision petitioner unequivocally admitted that he had issued the check and also admitted the same and consented for the installment, and having taken the installment before the trial court after the examination of complainant, and also the joint memo was filed long back in 2021 itself. And the court cannot exercise the revision in a case of when the joint memo is filed and consented order has been passed by the trial court. Hence, I do not find any error committed by the trial court and also the appellate court in considering the material on record. It is nothing but an afterthought, and also with an intention to protract the proceedings, though he filed the joint memo in the year 2021 itself, and order was passed in 2021 itself, and making all his efforts to overcome the consent which has been given. And hence I do not find any error to exercise the divisional jurisdiction to set aside the order of trial court as well as the first appellate court. In view of the discussions made above, I pass the following order. Revision petition is dismissed.
One submission, my lord, in respect of sentence, my lord. In respect of sentence.
Sentence to your client is not deserved. When he make all these efforts, 21 like consent put 3 varsha.
You have already paid
Let him be
30%.
there in the jail for a period of 2 years.
In fact, my mother was suffering from.
He is not deserved. Next, then madam idu. Told. Yada pass over irbek nodi adu told.
Hello.
Passport matter 66.
Bandri Latif nimda inyavdu idu ashte alla.
66, 67 ಎರಡಿದೆ.
ಯಾರ್ಯಾರು ಇದು accused?
Accused number 1 and 3. 2 and 4 are enlarged on bail.
A1 and 3 na?
ಹೌದು. A2 ಮತ್ತು 4 bail ಆಗಿದೆ. ಕಸ್ಟಡಿ 2 years 8 months ಆಯ್ತು. ಬೇರೆ ಆಂಟಿಸಿಡೆಂಟ್ ಇವ್ರ ಮೇಲೆ ಇಲ್ಲ.
ಇದೇನು ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ಆಫ್ ದಿ FSL ರಿಪೋರ್ಟ್ ಅಂತಲೇನೋ ಒಂದು ಲಿಬರ್ಟಿ
ಅದು A5 ಮೇಲೆ A5 ಗೆ.
A5 ಗೆ.
ಹೌದು.
ಈಗ ಆಲ್ರೆಡಿ A5 ಬೇಲ್ ಆಗಿದೆ.
A5 ಬಗ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಬಟ್ A2 and 4 ಗೆ ಫೈಲ್ಸ್.
ಈಗ 1 and 3 ಏನ್ ಗ್ರೌಂಡ್ಸ್ ಏನ್ ಹೇಳಿ?
One is not the parity it applies. So far parity applies.
ಯಾರಿಗೆ?
A3
ಏನು? ಪ್ಯಾರಿಟಿ ಅಂದ್ರೆ ಏನು? ಯಾರು?
A2 and 4 are enlarged on bail.
A2 and 4 ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? A2 and 4 ಆರ್ಡರ್.
Page number 92.
Page number 92.
Please. And A1 is concerned Lord, only on the confession statement he was arrested on 1/6/2021. And from him, my lord.
ಏನ್ ರೀಸನಿಂಗ್ ಏನ್ರಿ A2 and A4 ಗೆ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ? ಏನ್ ಸೀಜರ್ ಏನು?
Seizure ganjam.
ಗಾಂಜಾ. ಎಷ್ಟು kg?
In total 2 vehicles, my lord. Accused number 2 and 4 are traveling in a Tata HR. That is the 157 kg.
157 kg.
That is including leaves, seeds, everything.
ಇದು ಅವರು ಎರಡು ಬೇಕು. 2 and 4 ಗೆ ರೀಸನ್ ಏನು ಅಂತ ಆರ್ಡರ್ ಬರೆಯಕ್ಕೆ ಗ್ರಾಂಟ್ ಮಾಡಕ್ಕೆ?
While granting the bail, my lord, the long incarceration in the custody and trial is not yet begun. Still it is in here before charge stage.
Period of more than 3.5 years. The Honorable Apex Court, notwithstanding the rigor under Section 37 of NDPS Act, has released the accused on bail subject to conditions. In the said case, the Honorable Apex Court has observed that prolonged incarceration generally militates against the 21 of Article 21. ಇದ್ರೇನ್ ಟ್ರಯಲ್ ಕಮೆಂಟ್ಸ್ ಆಗಿಲ್ವಾ?
Here before charge. Here before charge.
Still.
ಹೌದು.
ಈ ಕೇಸ್ ಇದ್ರಲ್ಲಿ ಎಷ್ಟು ಟೈಮ್ ಆಗಿದೆ?
2021 in the custody.
21 ಇಂದನಾ?
ಹೌದು. 2 years 8 months. ಈಗ 9-10 months ಆಯ್ತು. And A1 is concerned, Lord. On the basis of confession statement, A1 was arrested. A2 to 5 are apprehended together.
Along with conspicuous possession.
Please. On the confession, A1 was arrested. From him, Lord, 2 kg to
The confession.
accused number 2 to 5.
2 to 5 have given confession.
Confession.
Saying that
I was purchased from A1 anta.
from A1 ಅಂತ.
Yes.
ಆಯ್ತು.
On the basis of that statement, he was arrested. And from his house, Lord, 2 kg of ganja also arrested.
Only 2 kg.
2 kg. That is for so far as A1 is concerned.
A1 is concerned.
And A3 is concerned, Lord, they are traveling together. Accused number 2, 3, 4 and 2, 3, 4 and 5. They were traveling in 2 vehicles.
ಈಗ 2 ರಿಲೀಸ್ ಆಗಿದಾನೆ, 4 ರಿಲೀಸ್ ಆಗಿದಾನೆ, 5 ರಿಲೀಸ್ ಆಗಿದೆ.
5 Lordship has rejected the bail application.
ಅದೇ FSL ಅಂತ.
FSL ಆದ್ಮೇಲೆ.
ಅದು.
ಹೌದು.
ಆಮೇಲೆ ಬಂದಿಲ್ವನೋ?
ಆಮೇಲೆ ಗೊತ್ತಿಲ್ಲ ಏನಾಗಿದೆ.
ರಿಪೋರ್ಟ್ ಏನಾಯ್ತು?
FSL
positive.
Tested positive.
ಎಷ್ಟು ಅದೆಲ್ಲ?
ಗಾಂಜಾ.
ಒಟ್ಟಿಗೆ ಗಾಂಜಾ ಎಷ್ಟು ಸೀಸ್ ಆಗಿದೆ?
Bifurcation ಏನ್ ಮಾಡಿಲ್ಲ.
200 kg.
200 kg ನ.
Bifurcation ಏನ್ ಮಾಡಿಲ್ಲ. ಬೇರೆ ಆಂಟಿಸಿಡೆಂಟ್ ಇಲ್ಲ ನಮ್ಮ ಮೇಲೆ. ಫಸ್ಟ್ ಕೇಸ್.
Antecedents ಇದೆ.
First
ಯಾ-
case.
ಅದು A5 ಮೇಲೆ ಇದೆ antecedent.
ಮಂಗಳೂರು ಮೂಡುಬಿದ್ರೆ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಡಕಾಯಿತಿ
ಅದು A5 ಮೇಲೆ.
ಇವ್ರಿಗೂ ಇದೆ ಇವ್ರಿಗೂ ಇದೆ
ಇವ್ರ ಮೇಲೂ ಇದೆಯಾ?
ಇವ್ರ ಮೇಲೆ ಇದೆ
1 and 3 ಮೇಲೂ? ಎಷ್ಟು ಕೇಸ್ ಇದೆ?
ಒಂದಿಗಿಲ್ಲ ಆದ್ರೆ 2
1 3 ಇದೆ.
ಹೀಗೆ ಅದು
ನಮಗಿರೋ 3ನೇ. ಅಥವಾ 3.
ಒಂದಿಲ್ಲ
A1 ಮತ್ಲು ಓನ್ಲಿ ಬರೀ ಆನ್ ದ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಒಂದಿಲ್ಲ ಸರ್ ಒಂದಿಲ್ಲ 2 3 4 ಇದೆ.
ವೆರಿಫೈ ನೋಡಿ ಮಾಡಿ, ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡಿ.
2 3 4 ಇದೆ, A5 ಇದೆ, ದಟ್ ಈಸ್ NDPS.
ಇದೆ ಅಂತ
ದಟ್ ಈಸ್ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಡೆಕಾಯಿಟಿ ಕೇಸ್ ಇದೆ,
ಕೇಸಲ್ಲಿ ಇದೆ.
NDPS ಅಲ್ಲ.
ಡಕಾಯಿತಿ ಕೇಸ್ನಲ್ಲಿ ಅವರು ಮೂಡುಬಿದ್ರೆಗೆ ಬರ್ತಾ ಇದ್ರು ಆ ಟೈಮಲ್ಲಿ ಮೂಡುಬಿದ್ರೆಗೆ ಬರ್ತಾ ಇದ್ರು ಡಕಾಯಿತಿ ಕೇಸ್ ಕೋರ್ಟಿಗೆ ಅವರು
ಏನು
ಡಕಾಯಿತಿ ಕೇಸಲ್ಲಿ ಮೂಡುಬಿದ್ರೆಗೆ ಬರ್ತಾ ಇದ್ರು ಅವರು
ಮೂಡುಬಿದ್ರೆಗೆ ಬರ್ತಾ ಇದ್ರು
ಆ ಟೈಮಲ್ಲಿ ಅಪ್ರೈಡೆಡ್
ಬಟ್ ಅಲಾಂಗ್ ವಿತ್ ಮೆಟೀರಿಯಲ್ ತಾನೆ ಸೀಸ್ ಆಗಿರೋದು.
ಮೆಟೀರಿಯಲ್ ಸೀಸ್ ಆಗಿದೆ.
ಆಯ್ತು, ಇವು ಏನಾರು ಇದ್ರ ಕೇಸ್ ಇದೆಯಾ ಅಂತ?
NDPS ಇಲ್ಲ.
NDPS ಇಲ್ಲ.
ಇಲ್ಲ.
ಈಗ ಇದುವರೆಗೂ ಇನ್ನು HBC ಇಂದ ಇದೆಯಾ?
ಹೌದು.
ಹಾ, ನೀವು ವೆರಿಫೈ ಮಾಡಿದೀರಾ?
ವೆರಿಫೈ ಮಾಡಿಲ್ಲ ಸರ್.
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಮಂಗಳೂರಲ್ಲಿ.
ವೆರಿಫೈ
ಅದು ಅವ್ರನ್ನ
ವೆರಿಫೈ ಮಾಡಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ. A3 ಗೆ ಬೇರೆ ಕೇಸಸ್ ಇದೆ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಅಂತ ನೋಡಿ.
ಡೆಕಾಯಿಟ್ ಇದೆ, ಒಂದು ಡೆಕಾಯಿಟ್ ಕೇಸ್ ಇದೆ.
ಅದಿರ್ಲಿ, ಅದ್ ಬಿಟ್ಟು
ಡಕಾಯಿತಿ ಆಮೇಲೆ ಇನ್ಯಾವುದು ಕೇರಳ ರಾಜ್ಯ
ಸಿಮಿಲರ್ ಕೇಸ್ ಏನಾದ್ರು NDPS ಕೇಸ್ಗಳು ಇದೆಯಾ ಅಂತ ನೋಡಿ.
ಇಲ್ಲ. ಮೈ ಸಬ್ಮಿಷನ್ ಮೇ ಬಿ ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್. ಐ ವೆರಿಫೈಡ್ ಫರ್ದರ್. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲೂ ಬಂದಿತ್ತು ಇದು.
ಮಂಜೇಶ್ವರದಲ್ಲಿ 320.
Heard the petitioner counsel and also the counsel appearing for the state. This court earlier rejected the bail petition of accused number 5 in criminal petition number 3484 of 2022. ಇದು ಫಸ್ಟ್ ಕೇಸ್ ನಿಮ್ಮದು?
ಫಸ್ಟ್ ಕೇಸ್.
ಮತ್ತೆ ನೀವು ಮೂವೇ ಮಾಡಿಲ್ಲ 2.5 ವರ್ಷದಿಂದ?
ಇಲ್ಲ.
These petitioners are accused number 1 and 3. Case of the prosecution is that accused number 1 had procured the ganja to the tune of 270 kgs, 740 grams from Andhra Pradesh, Visakhapatnam, and bifurcated the same. And accused number 2 to 4 have purchased the same.
2 to 5.
2 to 5 ಅದು 2 to 5 have purchased the same. Accused number 5, 6 ಬೇರೆ ಇದೆನಾ?
6 milad who
Number 6
provided eacher. 7 is the mother of A2.
Transport the same. And accordingly the same was transported with 3 talwars and knife. And when the vehicle reached Hassan, and when the vehicle was stopped and on verification found that ganja to the tune of 60 kg, 680 grams in KA03 MK04649 Skoda car, and accused number 2 to 4 in the 2 and 4 in the other vehicle, other each insulator lorry to the tune of rupees 100 to the tune of 157 kgs 60 grams and transported the same via Mangalore to Kerala, and the same was seized accordingly. The case has been registered and investigated the matter. The counsel appearing for the petitioner would vehemently contend that allegation against accused number 1 is that he had procured the same and sold the same to the accused number 2 to 5. And the accused number 1 is implicated in the case only on the voluntary statement of accused number 2 to 5. And raid was also conducted in the house of A1 and found only 2 kg of ganja in the said house.
In his house.
And except this, nothing was found in the house of the accused number 1. The counsel appearing for the petitioner also would contend that accused number 3 is entitled for bail on the ground of parity, since this court already granted the bail in favor of accused number 2 and 4 in criminal petition number 10343 of 2023 connected with 9828 of 2023, wherein this court, having considered the judgment of the apex court in Ravi Prakash case, where 247 kg ganja was recovered from the truck in which the accused was traveling. And an observation is made by the appellate court, apex court, that when the trial has not been commenced for a long period of, for longer period, and the same is nothing but incarceration suffered by the accused. The counsel also would submit that still case is pending for hearing before charge. And trial has not been commenced, and this petitioner is also in the these petitioners are also in the custody from 2.5 years. Houda?
2 years.
2 years.
A3 was arrested on 26/5, my lord. A1 was on 1/6/2021.
ಎಷ್ಟಾಗ್ತದೆ 21 2 ವರ್ಷ ಆಗುತ್ತಲ್ಲ
3 ವರ್ಷ 2 ವರ್ಷ 10 ತಿಂಗಳ
ಅಂತೀರಿ
ಹೌದು 21
ಅದೇ 2 years 10 months
ಹೌದು
ಮಾರ್ಚ್ ಅಲ್ಲ ಈಗ 2 years 10 months and hence they may be enlarged on bail by applying the parity. Further, the counsel appearing for the state would contend that accused number 1 is the masterminded and also he involved in procuring the ganja to the larger extent of 217 kgs, and the same was sold and the same was transported in the vehicle involved in 2 vehicles, and they have been repeatedly arrested. That is accused number 2 to 5. And accused number 6 is provided the vehicle for transportation. The counsel also would vehemently contend that against the accused number 3, one more dacoity case is also pending, but no any antecedents in respect of accused number 1. Having heard the petitioner counsel and also the counsel appearing for the respondent state, and also considering the factual aspect, seizure of ganja is 157 kg in one vehicle and in another vehicle 60 kg. And also having taken note of incident was taken place in 2021 in the month of May 2021. And these 2 petitioners are also in the custody from the date of their arrest. And also when there is no any criminal antecedents against accused number 1. And accused number 1 has been implicated based on the voluntary statement of accused number 2 to 5. And seizure from his house also only 2 kg. And accused number 3.
Also one mobile.
ಯಾರಿಂದ?
1 ಇಂದ.
ಆಯ್ತು. And also seize the mobile from accused number 1. And accused number 3 was along with other accused persons while transporting the same. And when this court already exercised the discretion in favor of accused number 2 and 4, having considered the judgment of Ravi Prakash case of Supreme Court with regard to the taking into note of the accused were in jail for a period of more than 5 years. And also in the case on hand, admittedly the case is still for consideration of HBC. And when there is no any other criminal antecedents in respect of transportation of ganja by this accused number 1 and 3, and it is appropriate to exercise the discretion on the ground of parity, as well as no other criminal antecedents against both the petitioners, and hence both of petitioners are enlarged on bail subject to executing a bond for rupees 2 lakh with 2 sureties for the satisfaction of the trial court.
Respect to serial number 2, my lord. In this case, because of non-prosecution. Whereas already steps ತಗೊಂಡಿದೀವಿ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಈಗಲ್ಲ on 5-2 ಅಲ್ಲಿ ತಗೊಂಡಿದೀವಿ
ಅದೆಲ್ಲ ನೋಡಿದ್ದೀವಿ.
No, my lord, it was misplaced in the file.
ಯಾವಾಗ? ಅವ್ರ ಮೇಲೆ ಹಾಕಿ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಮೇಲೆ PF ಕೊಟ್ಟ ಮೇಲೆ ಯಾಕೆ ಹಾಕಿಲ್ಲ? ಇವ್ರು ತಗೊಂಡು ನೋಡಿ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಲ್ಲ ನೋಟಿಸ್. ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ. ಇಲ್ಲ ರೀ, ಅದು ಆಲ್ಮೋಸ್ಟ್ 20 ಇಂದ ಹಂಗೆ ಇದೆ. PF ಕೊಟ್ಟರೋದು ನೀವು ಒಂದೇ ಸರಿ ಇರ್ಬೇಕು ಈಗ.
ಇಲ್ಲ ಸ್ವಾಮಿ, this is the second time.
ಆಯ್ತು, ಏನಾದ್ರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ. ನಾವು ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ಯು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ರೆಸ್ಟೋರೇಷನ್. Why you are not represented morning?
Morning, my lord, my senior is AGA and he's representing in 23. Because his family member met with an accident, he couldn't appear today. So I had to inform that court priorly that the government advocate is
File an
not.
application stating all this. And also having taken steps on so and so date, then I will consider. First, I will look into the order sheet. How long you have not paid the PF? I think when I passed an order, I have verified all the order sheet. For a longer period, you have not taken steps. Then we'll see.
Yes, madam. Bless.
I'm caring. Further